here. Is the broadcast on?
Yeah.
Thank you. The court will note that as we get started, there is a courtroom conduct order in effect that you've all been advised. Please pay attention to the terms of that order, including making sure you don't have any devices that would go off and interrupt proceedings. No recording within this courtroom or photography of any type. The court is providing public access through the open proceedings as well as the live stream that's being conducted. With the court's live stream, we have, I think, good technology in place to accomplish that. If something comes up that interrupts the live broadcast of this trial, and this will be throughout the trial, we'll give an opportunity to try to get that started again. However, if there's going to be any kind of significant delay in the live stream broadcast, the court will be continuing on with the proceedings. So there may be gaps in that, but I think our technology is in place that hopefully that won't occur. But just so those listening in understand, if it does come up, we likely will not pause the trial longer than necessary to make that accommodation. At this time, I'll note also for the benefit of counsel, we do have all 18 jurors, our 12 jurors with 6 alternates have arrived this morning, and everyone has submitted their juror affirmation sheet regarding following the court's admonishment while they've been gone. No issues to bring up on the affirmations of the jurors. So with that in mind, then let me go to the state, noting the state is here present. Is the state ready to proceed this morning?
Yes, Your Honor. Thank you.
Thank you. Is the defense ready to proceed?
Yes, Your Honor. Thank you.
Okay, thanks, counsel.
Good morning, everyone. I didn't want to interrupt the
All right,
judge.
before we bring the jurors in, which we'll do very shortly here, I also, as we are getting started and before the jurors are sworn and we take evidence, is there, I believe we've already had a motion to exclude witnesses. Let me just clarify on the record, is there going to be a motion to exclude witnesses through evidence portion of the trial made by the defense?
Yes, Your Honor. So,
Very well. The court will reaffirm then there has been a motion to exclude witnesses. So as the state begins with its case in chief, keep that in mind that they are not permitted to observe the trial proceedings, including the live stream. The only exception would be for a witness. If they statutorily qualify as a victim, then they are permitted to observe the proceedings. So each witness is going to be questioned whether or not they've observed any trial proceedings, and I would instruct the state, and then following the defense, if they have witnesses, to make sure that the exclusionary rule is followed. Does the state have any questions on that matter?
Your Honor, the state would just clarify and just make counsel and the court aware. It's the state's understanding that through the Constitution and statutorily, victims have a right to remain in the courtroom throughout the proceedings, regardless of whether or not they are victims. And we have discussed that with defense counsel and made the court aware of who we think there may be a crossover with, meaning individuals that may be present and also witnesses. But statutorily, they would have the right to be here. So including any of the defendant's children, as well as, since they were Tammy's children, as well as siblings, sometimes grandparents. The court made a ruling last year in the Vallow case. I think if we're following a similar guideline, those are the individuals that we would just note for the record may be present at times, but should have the right to be present throughout the proceedings. In addition, I would just note for the record that we do have our case agent who will be present for the duration of the proceedings, and that's Chief Deputy Vince Kaikamani.
Okay, and the
Thank
state's
you,
permitted the case agent as it relates to victims. The court agrees they are permitted to see the proceedings, including if they are a witness. We would take up on a witness by witness basis whether or not they fall within the statutory qualifications permitting that. And I know the state's aware of the issue. We'll make rulings tested as to whether or not they would qualify and later called to testify. Mr. Pryor from the defense, any further comment or questions on the exclusionary ruling?
Nothing further, Your Honor.
Okay, thank you.
Yes, you have new emojis and member badges.
All right, this
so
time
have
then
fun
we
with
will have
those.
the jurors brought in.
Yes, sir.
All rise.
Welcome here, everyone. Welcome. Thank you for being here, and thank you for the 10 gifted membership, and enjoy your new emojis. There's some fun ones in there. I think my favorite one might be GTFU. Sure. Grow the
All
fuck
the
up.
jury's present and accounted for.
All right, thank you, Mr. Bailey. Please be seated. All right, thank you, ladies and gentlemen of the jury. We're on the record on Fremont County KCR 22-21-1623, State of Idaho versus Chad Daybell. We're ready to proceed with opening arguments and initial instructions this morning to you as jurors. The court notes that the prosecution is present as well as the defendant and the defense attorney representing him as well. We have qualified this panel of 18 jurors consisting of 12 jurors with 6 alternates, and they are now seated for trial. Let me start with the state and ask, will the state agree that the jury has now been properly seated and ready to be sworn?
Yes, Your Honor, thank you.
Will the defense agree as well?
Yes, Your Honor.
Thank you. All right, ladies and gentlemen of the jury, thank you for returning this morning. You're now seated as jurors
The
in the
reason
case
we're here,
before us.
remember.
As previously been told, I'm Stephen W. Boyce, the District Judge of Fremont County in charge of this courtroom trial. I'll briefly reintroduce you to some of our court personnel assisting here today. Shannon Holstein, seated to my right, is the clerk who is keeping minutes of the trial proceedings, will be marking trial exhibits and administering oaths to you as jurors and to the witnesses. We do have our courtroom bailiffs as well who assist with keeping order in the courtroom and helping the jury move about where they're supposed to throughout the day, and then enforcing any conduct orders we have in effect here for the trial. Our court reporter today, Amy Bland, is taking a stenographic record of everything said during the trial proceedings, and my staff attorney, Courtney Stallings, seated to the far right, who assists me with legal research and administrative matters that come up throughout each day of trial. Each one of you has been qualified, examined, and selected to serve as a juror of this court. The clerk will now have a roll call of our seated jurors. Please, Madam Clerk, if you would conduct the roll call. As to each juror, once your juror number is announced, please just indicate present or here verbally so we acknowledge that on the record. Madam Clerk.
Juror 27, present. Juror 219,
Here.
juror 505,
Here.
juror 631.
Here.
Juror 653.
Here.
Juror 686,
Present.
juror 752,
Present.
juror 1680, present. Juror 823,
Here.
juror 1358,
Here.
juror 1365, yeah. Juror 716, yeah. Juror 751,
Here.
juror 997,
Here.
juror 1078, juror 1577, here. Juror 1271, juror 1382,
So the jury, a couple fun facts.
Thank you,
The
Madam Clerk.
jury is 10 men and 10 women.
This case has been brought by the state of Idaho. I'll sometimes refer to the state as the prosecution.
Just like last trial.
State is here represented in this trial by Lindsay Blake, Fremont County prosecutor. Ms. Blake, could you please stand briefly? Also, Rob Wood is the Madison County prosecutor. Ingrid Beatty is a special assistant prosecutor,
Good morning, Evil Queen.
and Rocky Wixom is a Fremont County deputy prosecutor. The defendant in this case, Mr. Daybell, is represented by his attorney, John Pryor. Thank you, counsel. In a few moments, the clerk will read you a redacted version of the amended indictment in this case. That document is not to be considered as evidence. It sets forth the charges against the defendant. You must not consider it as evidence of guilt and not be influenced by the fact that charges have been filed. Mr. Daybell has pled not guilty to the charges contained in the amended indictment.
Okay, I'm gonna talk over him a little bit.
Again, it's a description of charges. It is
Yeah,
not
they're
evidence.
being extra
Under
careful
our
with
law and
this
system of
with this
justice,
trial,
every
Johnny.
defendant
They're
is
being
presumed to be
very,
innocent.
very, very
This
careful
means two things.
Um,
First, the state has the burden of proving the defendant guilty.
in their jury
State has
selection.
that
They
burden
even
throughout the
selected
trial.
more
Defendant is
than they
never
usually
required to
do
prove his
for the
innocence,
initial
nor does the
pool.
defendant ever have to produce any
So,
evidence at all. Second, the state must prove the alleged crimes
So,
beyond a
did you all
reasonable
know
doubt.
that
A
it
reasonable
was
doubt is not a
exactly
mere
1 year
possible
ago
or
today
imaginary doubt. It is a doubt
when
based on
Lori
reason and common
Daybell's
sense.
trial started,
It may arise from
and
a
that they
careful and
also
impartial
had
consideration
10
of all
men
the
and
evidence
10
or
women?
from a lack of evidence.
Crazy, right?
If after considering all the evidence you have a
Considering
reasonable
all
doubt about the defendant's guilt, you must
all the
find the defendant
delays,
not guilty.
all the things that they've had to do to get
The
here.
duty of the jury is to determine the facts. And then
Amazing
apply
that
the
it
law
ended
set
up
forth
on
in the
this
instructions
date.
I will later give you to those facts. In this way, you will decide the case.
Yep.
In applying
Took
the
a
court's
long time to select
instructions
a
as to the
jury,
controlling
but-
law, you must follow those instructions.
And they were being
regardless
very,
of
very
your
careful.
opinion of what the law is, or what the law should be, or what any lawyer may state the law to be.
This is going to be
During this
a
course of the trial,
really,
including,
this is going to be a difficult
opening
trial.
statements, you're
It's
instructed
one that's been
that you are not to
a
discuss
long,
this case
long
among
time
yourselves
coming.
or with anyone else, including
We,
using the
I've
internet
been
or
following
social
this
media
case
or any other form of communication
since the kids
electronic
went
or
missing
otherwise,
in
do not conduct any
2019.
personal investigation
They
or
were
accept
announced
any
missing,
information from any source,
and
including
the reports
and
all
do
went
not
out
formally
in
bring us
December of
case
2019,
until after the case
but
is
they were
submitted
last seen
to
in
you for
September
determination. The
of
court's giving you that
2019.
instruction now multiple
Yes,
times.
Speckles, very
I will
highly
continue to
anticipated.
give you that instruction. And again,
Now,
that's not because I don't think you're
Lori and Chad
attention.
were going to be tried together,
It's just important enough.
but
We'll keep reiterating
Chad
that
waived
I will
his
note we received
right
further
to a speedy
affirmations
trial,
today from each of the
and
jurors
Lori
who
did
have
not.
followed that instruction.
So they had to sever the
So thank you
cases,
for that.
and it
At
eventually
this
ended
time
up
then,
with
next
Lori's
matter we'll
case
take up
not
is to
being
have
a
this
death penalty
jury
case
placed under oath for
because
trial.
they,
At this time then,
in
Madam
fact,
Clerk, if you're ready to adjust the oath,
unfortunately, the
stand
prosecution
and be
screwed
placed under
screwed
oath.
up deadlines, and they couldn't
When you
get
stand, then please raise your right hand.
their discovery in on time
You solemnly
for
swear or
death
affirm
penalty, so they
that
had
the
to take it
trial
off the
is now
table.
on trial, and a true verdict rendered herein according to the law and the evidence. So
She's
help me
swearing
God.
in the jurors. So
All right, thank you.
this
Please
is
be
a
seated.
this is going to be a very different trial, I believe, though. Lori did not allow
All right,
her
the
team to
jurors
put
have
on
already
a
been
defense
advised,
whatsoever.
of some of our trial procedures in this case, and I'll just give you some additional general.
I believe Chad is
information
fighting
here.
for his
Our
life.
Normal schedule is to run trial from 8:30 each day until 3:30. At times that will need to be modified. for certain
8:30 to
reasons.
3:30
Sometimes
each
we have
day is the
matters to be
schedule.
argued outside of your presence. Sometimes during the recesses, they may seem to go long because we're conducting other court business outside of your presence. But we will take recesses through the morning and also in the afternoon. If anyone is uncomfortable, needs a break or recess for some specific reason, please notify the bailiff and we'll do our best to accommodate each of you and keep you comfortable while you're here. In addition, if anyone has any kind of accommodations they need, for example, assistance with a hearing device, other matters, please notify the bailiff again, and we want to make sure.
Now, is
you
there
are as
anyone in the
comfortable as you
chat
can be
right now
and
at
able
this
to,
point who
give
doesn't
our
know very
defendant
much
throughout
about this case?
presentation of evidence in the case.
Because I have
The
loaded up
seats that
my
you have been,
tabs
assigned to at this
with
time will be
information
your
for us to
specific
talk
seat
about,
throughout the trial. Please return to that same
during
assigned
breaks and
seat
things
each
like that.
day or
But
after each break.
I don't
so
want
that
to
we
bore
are
you
able
with
to
information
determine
that you
who's
already
here and
know.
someone's not for some reason who's not here.
And I know a lot of you have been
If
following
there are
this case, but I'm just not sure
interruptions
how
during
closely,
the
and if
trial,
anyone
I know that
is
can be frustrating, but we'll work our best to keep those
would
to a
like,
minimum,
some of the
move the
rudimentary
trial as
basics
long
of
as
this.
efficiently as possible, but at times it just
I agree,
takes
Alex.
time
I
to
think,
hear motions that are necessary.
we're going to see
outside of
an
the presence,
actual defense
and then the
from Chad's team.
courtroom and your
Um,
location for
Chad has a
deliberations, as
very,
well
very
as
aggressive
during the
lawyer,
trial where you'll be held. We provided,
even though
of course,
the
access
lawyer
to
did try
restrooms,
to
like
take himself off the case late last year or mid last year in a last
I'll
ditch
address your
move.
compensation here. State law allows you for
The
$10
judge
a
wouldn't
day for
allow
your
it,
jury
and
service.
so
However, after 5
he's still
days,
on the
that bumps
case,
up to $40
and
a day. So
he tried to
this
remove
trial is
himself
expected to go
from the
some
case.
time. You'll likely get into
Okay,
that
sounds good, Lollipop Guild.
increased range of compensation, and that's pursuant to Idaho Code 2.
The reason Pryor was trying
You're
to
also
remove
entitled,
himself
I
from the
believe,
case
to a mileage
was
reimbursement
to,
for
I
travel
think,
each day.
try to get the death
And that
penalty
can
off
further
the table.
explain to you if you have
Because they
any
had just been
questions.
trying to get the death penalty off the table. That was most of what their stalling
Also,
tactics
you may
were
notice
about.
from time to
And that was
time,
like the last
for
ditch
a lot of the
effort.
time, I'm looking at monitors
Finally,
here in the trial.
hello,
We have
Chopper's
case information
here.
here, availability to
And we
access
say it with him,
case citizens
finally.
from the bench. And so, if you notice me looking at those monitors, it's generally to assist me in trial issues that come up.
Yeah, I mean,
At this time, then the court
no
will
matter
provide
what
the jury with some additional
I say
jury instructions.
or anybody
As I
says,
read through these, it's somewhat lengthy.
we're
And
here
I
for the
will
people, for the victims, right?
notify you
We're
that
here
you
for
don't
the
have to
people who,
necessarily memorize
the
everything
kids
I'm
that were
saying
found
when the trial
in Chad's
is
backyard.
concluded and you deliberate. You will have printed copies of these
And we're here
instructions
for
to return
Tammy,
to for reference.
right?
And if you'll give me just a
Who
moment,
I
can
truly
include
feel
in
hasn't been
my staff attorney.
given enough attention. There was a foundation started in her name by her family. We'll talk more about that. Chopper, thank you for offering I am the mod. No, I understand.
Thank you.
It's nothing personal.
Now
I
that you've
just
been
don't have
sworn
mods on my
as
I'm
jurors
the mod
to
on my
try this
channel.
case, I'll go over with you what will be happening. I will
But
describe
thank
how the
you. I
trial will be
appreciate
conducted,
the offer.
what we will be doing. At the end of the trial, I'll give you more detailed guidance on how you are to reach your decision. Because the state has the burden of proof, it goes first. After the state's opening statement, the defense may make an opening statement or may wait until the state has presented its case. The state will offer evidence that it says will support the charges against the defendant. The defense may then present evidence that is not required to do so. If the defense does present evidence, the state may then present rebuttal evidence. This is evidence offered to answer the defense's evidence. After you have heard all of the evidence, I'll give you additional instructions on the law. After you've heard the instructions, the state and the defense will each
Trolls are
be given
trolls.
time
They
for
just get
closing
zapped here.
arguments.
But
in their closing arguments, they will summarize the evidence to help you understand how it relates to the law. Just as the opening statements are not evidence, neither are
if I
the
ever
closing
get to a
arguments.
point where I feel like I
After
need
the
a
closing
mod,
arguments,
I'll
you will leave
remember
the
that,
courtroom
Chopper.
together to make your decision.
Appreciate that.
During your deliberations, you will have with you my instructions, the exhibits admitted into evidence, and any notes taken by you in court.
Y'all haven't seen any trolls come
The
in
defendant is charged by the state of Idaho with
this
a
morning,
violation of
right?
law. The
I
charges
haven't seen
against the
any.
defendant are contained in the amended
If you see a
indictment.
troll that I don't
The
see,
amended
just put
indictment
troll
is
in the
simply a
chat and
description of
I'll
the
take care of
charges.
it. But
It's
don't,
not evidence.
no need to respond to the troll or give them any
Jury instruction number 3. The defendant, Chad Daybell,
give
has
them
been
any
charged
supply.
in the amended indictment with certain counts of entering into a conspiracy with Vallow Daybell and or Alex Cox and or other co-conspirators. The crime of conspiracy involves an agreement by 2 or more persons to commit a crime. You must only consider the evidence against the defendant, Chad Daybell, in this case, and should not speculate as to any other case or legal proceedings involving any alleged co-conspirators. You must remember that the defendant, Chad Guy Daybell, has the presumption of innocence, and you must consider his guilt or innocence based solely on the evidence provided
Evil
in this
queen.
case.
Of course, she's not a troll.
Instruction number 4. It is alleged that the crimes charged were committed on or about or on or between a certain date.
You're
If you
all
find the crime was
badasses.
committed, the proof need not show that it was
You're
committed
all
on that
badasses.
precise date.
I love y'all. You're great.
Instruction number 5. Under our law and system of justice, the defendant
Okay,
is
so he's
presumed to
still
be innocent.
talking about
Presumption of
instructions.
innocence means
So,
2 things.
Um,
First, the state has the
yes,
burden of
right
proving the
now,
defendant guilty.
he's just giving
The
the
state has
jury
that
the
burden
instructions
throughout
of,
the trial.
what
The
to
defendant
listen
is
for.
never
Hello,
required to
sexy,
prove his
wild
innocence,
thing,
nor
McLovin
does the
freaking
defendant
Papa
ever
Elvis
have to produce any
Claus.
evidence at all. Second, the state must
The
prove
longest,
alleged
funnest
crime beyond a
name
reasonable
on
doubt.
YouTube.
A reasonable doubt
There's a
is not
difference
a mere
between our level
possible
of
or
strange
imaginary doubt.
and
It is a doubt
trolls,
based on reason and
aka
common sense.
adults living with their
The
parents in
narration
basements
of
with no
careful and
lives. Yes.
impartial consideration of all the evidence or from lack of evidence. If after considering all the evidence you have a reasonable
Yeah, I love
doubt
my
about
dog
the defendant's
too.
guilt, you must find the defendant not guilty. Jury instruction number 6.
Yeah, I
A
mean,
defendant in a
it might
criminal trial
even
has a
take a
constitutional
bit
right
for the
not
trolls to
be
find my
compelled to
channel because I haven't
testify.
been live in a little
Decision
bit
whether
on
to
this channel, and
testify is left to the
you
defendant,
know,
acting
I
with
kind
the
of do it
advice
to
and
myself.
assistance of the
I
defendant's
stream a
lawyer.
trial
You
here,
must not draw
and
any
then
inference of guilt
thank
from
you,
the fact
sexy
that
wild
the
thing. Thank you,
defendant
everybody, for
may
the
not
love.
testify, nor
Um,
should this fact be discussed by you.
You know, I'll
enter
stream a
into
trial here,
deliberations
and then
with
I'll pay
the lawyer.
attention to my other channel, and then
Jury
I
instruction
have to
number
get
7.
back into the algorithm with this channel
If
when I
during the
start streaming
trial
another trial.
I may say or do anything which suggests to you that I am inclined to favor the claims or positions of any party. You
That's
will
right,
not permit
Johnny.
yourself to be influenced by any
Especially in
such
this day and
suggestion.
age.
I will not express nor intend to express, nor will I intend to intimate any
Yeah.
opinion.
So
as to
one
which
thing,
witnesses
hello,
are
Stevie's
or
mom.
are not
You
worthy
know,
of belief,
one thing
what facts are or are not
that
established,
we
or
are
what
probably going to
inferences
see,
should be
and we
drawn
saw
from
it
the
a bit
evidence.
in,
If
you know,
any
I watched
expression
some of the
mine
jury
seems to
selection.
indicate an opinion relating to any of these matters, I will instruct you to disregard it.
John Pryor drones
Jury
on
instruction
and
number 8.
on and on
Your
and
duties
on
are
and
to
on.
determine the facts, to apply the
He
law
is
set forth in my
he's
instructions
one of
to
these
those
people that
facts, and
kind
this way
of,
to decide the case. In doing
like,
so, you
once
must
he
follow my
takes the
instructions
floor,
regardless of your own
he kind
opinion
of
of what the
doesn't
law
let it
is or
go.
should be, or what either side may say
And
the law to be. You must consider them as a whole, not picking out one.
he
disregarding
weaves a
others.
lot of like
The order in which the
excuses
instructions
and
are given has no
explanations into
significance
his
as to their relative importance.
conversation that really
The
don't need
law
to be there
requires
at that
your
point.
decision be made solely upon the evidence before you. Neither sympathy
Yeah,
nor
that's,
prejudice should
you know,
influence you in your
Lori's
deliberations.
trial was not streamed.
Faithful
What
performance
they
by
did was they
these
put
duties
updates
is
on
vital
later,
to the administration of justice.
and therefore
In determining
I
the facts, you may
usually
consider
was
only
just
the evidence
reading
admitted in this trial.
about
This evidence
Lori's trial or
consists of the
listening to
testimony
what
of the
people were
witnesses,
saying about it. You know,
the
I would go
exhibits
to
offered
Alex's
and
channel or
received,
Jen Lou's
and any
channel
stipulated
and
or
read,
admitted facts.
listen to them doing
The
their
production of
recaps.
evidence in court is governed by rules of law. At times during the trial,
But I
an
didn't
objection
actually ever
may be
listen
made
to
to
audio from
a
Lori's
question asked
trial.
the witness or to a
And
witness's answer.
in all
or to an
honesty, I
exhibit.
started listening to some of it
This simply
yesterday
means I'm being asked to decide a particular rule
and the day
of law.
before as I was preparing for
Arguments on the
this,
admissibility of evidence
and
are
it
designed
sent
to aid the
chills up
court
my
and not
spine.
to be considered by you
The
to affect
prosecution
deliberations.
is
If I sustain an
has
objection to
put
a
their
question or
entire
to an
heart and
exhibit, the
soul
witness
into
may
this
not answer
case.
the question, or the
At
exhibit
least
may not be considered.
that's how
Do not
it
attempt to
appeared
guess what the
in
answer
Lori's
might have
trial.
been or what the
And I
exhibit
have no
might have
reason to
shown.
believe that they wouldn't be doing it on
Similarly,
this
if I
trial
tell
as
you not
well.
to consider a particular statement or exhibit, you should put it out of your mind and not refer to it or rely on it in your later deliberations.
So I do plan to be here
During the
live
trial,
every day with
I
the
may have to
trial.
talk with the parties about the rules
If
of law, which
there's a
apply
day
to this
that
case.
for some reason I
Sometimes
can
that will
stream, I'll let
occur
you all know
over on the
and
corner
as
there,
soon as
and we
advance
have
as
a device
possible.
here that whites out the noise, so you can't hear us speaking there.
This
At
has
other
just been a
times, I'll
long
excuse you
time
from the
coming,
courtroom
something
so
I've
you can talk
personally
while we
been
look
waiting
at
for
problems with
and
evidence.
following.
You are not to speculate about any such discussions. They are necessary from time to time to help the trial run more smoothly. Some of you have probably heard the terms circumstantial evidence.
Yep.
Direct evidence,
You know,
and hearsay.
I don't
evidence.
take any
Do
disrespect
not
of
be concerned
anybody
with
in my
these terms.
chat.
You are to
You know,
consider all
if
the
I-
evidence admitted.
If I don't
this
see the
trial.
disrespect,
However, the law does not require
I
you
might,
to believe all of the
it might
evidence.
end up getting
As
by,
the sole
but
judges of the facts, you must determine what evidence you believe and what
I
weight you attach
agree
to it.
with you there, Chopper.
There is no magical formula by which one may evaluate testimony. You bring with you to this courtroom all the experience and background of your lives. In your everyday affairs,
You're all
you
very
determine for
welcome.
yourselves whom you believe, what you believe, and how
Thank
much
you,
weight
Stacy
you
P.
attach to what you are told. The same considerations that you use in your everyday dealings in making these decisions are the considerations which you must apply in your deliberations. In deciding what you believe, do not make your decisions simply because more
Yeah,
witnesses.
I
may
think
have
my core
testified one way
audience
than
here,
the other.
which is,
Your role is to think
you
about the
guys
testimony of
make
each
up,
witness
you know,
heard
my core
and decide
audience.
how much
You
believe
know
of
that
what
I
the
don't take
witness had to say.
disrespect in chat.
A witness
for
who has
people.
special knowledge in a
We don't
particular
have
matter
time for people's
may give an
petty
opinion
drama.
on that matter.
This
In
is
determining
a
the weight to be
major,
given such an opinion,
major
you should
death
consider the
penalty
qualifications and
trial
credibility of the
for
witness
the death,
and the
for the
reasons given for the
murders
opinion.
of 3
You are
people,
not bound by
3
such
innocent
opinion.
people,
Give it the weight
because of a
opinion to which
doomsday
you are
cult
entitled.
run by this Yahoo. The ideas of this Yahoo, who had some very, very similar ideas
Jury
as
instruction
Jody
number
Hildebrandt.
9, at the conclusion of the trial,
I would
you will
say that
decide as to each charge whether the
Chad and
state
Lori's
has proved the
ideas
defendant
were
guilty
more
beyond a
radical,
reasonable doubt.
but
The subject of
what
penalty or
happens with
punishment
people
is
when
not
they
to be
get
discussed
involved
or
in these,
considered by you in making these
you know,
decisions. That is
extreme
a matter which must not in any
mindsets
way affect
is
the verdict.
the more they get into
Jury
it,
instruction number 10.
the more,
The state
the
is seeking the
deeper
death
and
penalty in
deeper
this case.
and deeper they
If the
go,
defendant is
and the
convicted of murder
darker
in the
and the
first degree,
darker and
there
the
will then
darker
be a separate
we go.
sentencing phase of the trial.
And,
At that sentencing phase, additional evidence may be
when it
presented
came to
and the
Chad
jury
and
will be
Lori,
given
they
additional
actually
instructions.
said the words
At the
zombies
conclusion of
and
that
dark
hearing,
spirits
the jury will
and
then
things like
decide
that.
if the defendant will be sentenced
And
to death. If the jury decides that the defendant
it
will not
appears
be
that
sentenced to death,
very,
either the defendant will be
all of the
sentenced
same
to a
themes
term
were
of life
running through
imprisonment
Jody
without the
Hildebrandt and
possibility
Ruby
of
Frankie.
parole,
And when
or
you
the
read
judge
Ruby
will sentence the
Frankie's
defendant to
diary
a term of
pages,
life imprisonment
journal
during
pages,
which the defendant could not be paroled for at least 10 years and possibly for life.
yes, I
Jury
agree, Chopper.
instruction number 11.
Your opinions
wish,
matter. If
you may
you
take
have a
notes to
different
help you
opinion than
remember
I
what
do, or people in
witnesses
the
said.
chat, your opinion
If
is
you do
welcome,
take
as
notes,
long as
please keep
it's
them to yourself
said
until after
respectfully.
you and your fellow jurors go to the jury room to decide the case. You should not let note-taking
Thank you,
distract
Lollipop
you so
Guild.
that you do not hear other
We
answers by the witnesses.
represent the
When you leave at night,
Lollipop Guild.
you'll leave your notes here with the videos.
Yeah, so I
If you do
also
not take
read,
notes, you should rely on your own memory
I
of what
actually
was
read
said and not be overly
something like
influenced by
3
the
of
notes
Chad's
other
books.
jurors. In addition,
And
you cannot assign one person the duty of
when
taking
you
notes for all
read
of you.
his books, you get a
Jury
very,
instruction number
very
12.
interesting
It is important
perspective on his
That as jurors and officers
point of view.
of this court, you obey the following instructions at any time you leave the jury box. Whether it be for recesses of the court during the day, or when you leave the courtroom to go home at night.
I agree,
First,
Tiggy Girl.
Do not talk
I
about the
think
case
what
among
happens
yourselves or
is,
with anyone else during the course
you know,
of the
they
trial.
create this,
You should keep an open mind throughout the trial and not form
they
or
create this
express an
dogma,
opinion
this
about the case.
mindset.
You should only
create
reach your
this
decision after you have heard all
excuse
the
to
evidence,
call themselves a
after you've
prophet,
heard my final
and then they
instructions,
start
and after the
abusing that
final
power
arguments.
of
You may discuss
being
this
considered a
case
prophet
with the other
by
members of the
followers.
jury only after it is
And
submitted to
the
you
thing
for
that
your decision.
really, really bothers
All
me
such
about this whole
discussions should take
situation
place in the jury room.
is that it's
Second,
clear to
do
me
not let any
that there
person
are
talk
more
about the
people
case
in the
your
world who
presence.
believe
Anyone
like
does
these
talk
people
about it to
believe.
you, tell them you're a juror of
Because
the
when you
case.
see the
If
journals
they
of
won't
Ruby
stop
Frankie
talking, then
and
report
her
that to the
talking about
lawyer
her
or
kids
courtroom
acting like
staff as soon
demons
as
and,
you're able to do that.
you know, being
You
possessed,
should not tell your fellow jurors
and
about
how
what
they
has
were
happened.
punished and the ideas
Third,
used
during
to
this
punish
trial,
them.
do not talk with any of the parties
It's
or
insane, and
lawyers
you can
or any
see
witnesses.
that
By
this
I mean
way of
not
thinking,
only
at
do
least
not
this
talk about the
idea,
case, but do not talk at all, even to pass the time of day. In no other way can all parties be assured of the fairness they are entitled to expect from this jury.
The ideas are
Court during this trial may not
incredibly
make any investigation of this case
dark
or
and
inquiry
sinister
outside the courtroom
and
on
put
their own. Not
the power
any
of
place
God into the
mentioned in
prophet to
testimony
decide who gets to
without
live and
more
who
of the
gets
court
to
do
die.
so. You must not consult any books,
And
records.
it's true,
internet,
Chopper,
or
that
other
cults
source
are
of
everywhere, but I'm
information unless
talking
I
about
specifically authorize you to do so.
this specific way of thinking that comes,
Fifth, do not read
that's a
about
branch
the
off
case
of
in
the
newspapers,
LDS
do not
church,
listen to radio or
off of the
television
LDS
broadcasts
faith,
about the trial.
LDS faith,
You must base your verdict solely on what is presented in
where
court, and not upon
these groups come
newspaper,
together
radio,
and it
television, or
appears that
media
they're
account of what
sanctioned
may have
by
happened. Each
LDS,
day,
but
you
they're
will be
not.
required as I
In
mentioned,
fact,
to sign an
Chad's
affirmation
teachings
to
got
follow
him
this
excommunicated
admonition.
from LDS church. So what he did was he
That
formed
concludes the court's
groups with other
first
excommunicated people
instructions, then, and as I
who
mentioned, we will
had
be
these
providing
similar
copies of
radical
those when we
beliefs.
deliberate
And the radical
for
beliefs
further
are,
reference. Next,
in
at this
Chad's
time,
mind,
I am
that
going to have
we
the clerk
are
read the amended and
reincarnated
redacted
over
indictment
and
to
over
you.
and over and over.
Madam
And
Clerk, if you're ready to read
he
the
has
amended
the ability to
indictment,
tell
will
you
please do that
who
at this
you
time.
were in a previous life and what your mission is. And he told Lori, he and Lori got Lori to believe that she was a direct descendant of Jesus through these teachings.
State of Idaho plaintiff versus Chad Daybell defendant, case number CR.
They went into they spent hours and hours and hours and hours in the temple, praying and you know, using the temple as a method to appropriate powers that they didn't have. And in fact, they probably got married in a temple before they to each other in a temple as thinking that they were celestial beings before either of them got actually officially divorced from either of their family members, either of their spouses.
Conspired, confederate, and agreed to commit murder in the first degree of Tylee Ryan.
So to give you an idea of his books tell a story of a government that is trying to take power over its people by chipping them, and how there's only one religion and one church that can save all of these people from being chipped and overtaken by the government. And it was his, it was this way of thinking, this particular way of thinking that he was espousing. Okay. And in this book, special people are selected to go to tent cities. There are white tent cities. It's not original in the least, Johnny. There are white tent cities and there are other different colored tent cities. If you're in a white tent city, you are chosen. You get to, you are part of the 144,000 that's been chosen to stay behind and, lead the rest of civilization into redemption. And all the other tents, well, God gets to decide what to do with those other, people in the other colored tents. But, so there are the people who refuse to get chipped and they who go to the white tents, and then there are the people who also refuse to get chipped, but for some reason they get relegated to a different color tent. And then there's the rest of the world that allows themselves to get chipped and overtaken by the government. And the reason the chip is coming into play is because of course, a virus of some sort is coming over the country, and according to Chad's book, the government actually planted that virus so that they could convince them to wear this chip so that they can be controlled. So that's right, Johnny. I agree. So in his book, he's basically painting a picture of what he thinks. Yes, so many prophets have predicted the C word, yes, um, in one way, shape, or form. Um, but basically, that's in his writing. He also wrote a book that tells his own origin story and his own childhood and his upbringing and his family and his ancestry, and it basically paints him as a descendant of one of the founders of LDS. I think anyone else can correct me if I'm wrong, who's in the chat, if they read this book, but he claims to be a direct descendant of Joseph Smith. Joseph Smith was the founder of the LDS Church. So he thinks he has the blood of a prophet, and or at least he's saying he has the blood of a prophet, and it is therefore his destiny.
2019, in the county of Fremont, state of Idaho, was concerned in the commission.
Did Chad? Yeah. I mean, that would mean he's a prophet. If he's a prophet, then he would have prophesied that he and Lori would be spending the rest of their eternal life visiting each other in portals through prison walls.
To wit, did either kill Tammy Daybell and or assist in the killing of Tammy Daybell, and or did encourage the killing of Tammy Daybell, and or did command another to kill Tammy Daybell.
Yep, that's right, Chopper. And it appears that since that time, that entire story has gotten scientifically debunked. The things that he wrote in his magical tablet were impossible. He tried to say that they were inspired teachings that came through him, and he had to write it onto this magical tablet by looking at glasses, looking at stones, and reading them through the stones. And the things that he claims that the spirit wrote through him were things that were physically impossible to have happened at that period of time in history, or just impossible to happen. For instance, they didn't have the type of animals that he claims that they had at the time. That those animals didn't exist in that geography at that period of time. Things like that. Hey, just on. Yep, nobody gets to see the tablets either. Yep, and even though the beliefs might not be the same as Scientology, the system of control, the ideas around how to get your people in line and how to prophecy, they all match with Scientology's system. Cults all work in, there's always
Thank you very much.
similarities that you can pick out in cult-like systems, like Scientology, like Chad and Lori's, bullshit church.
That concludes the court's opening instructions.
Yeah, that's right. Jesus was in Missouri.
Sworn as well. The next matter we would take up then are opening statements.
Good question, Sparkles. I don't know.
Yes, Your Honor. Who will be giving the opening statement? I will, Your Honor. Very well. Mr. Wood, you may present your opening.
Okay, we've got openings now from Mr. Wood. Let's listen up.
Your Honor, may I inquire, is there a hand mic so that I may address the jury?
I think we do have one. Might take us a moment to get it over to you.
And I do have a PowerPoint attached.
All right.
Peace to Tightly and JJ and Tammy.
May I proceed your phone? Yes, it's for the HDMI. May I proceed, Your Honor?
Yes, you.
Two dead children buried in the defendant Chad Daybell's backyard in September of 2018. The next month, the wife is found dead in their marital bed. 17 days after the death of his wife, Tammy Daybell, this defendant is photographed laughing and dancing on a beach in Hawaii at his wedding. It's Lori Vallow, a woman who was his mistress and the mother of the children buried in the graves on his property. 3 dead bodies. This defendant believed he had a right beyond the ordinary. When he had a chance at what he considered his rightful destiny, he made sure that no person or no law would stand in his way. His desire for sex, money, and power led him to pursue those ambitions. And this pursuit led to the deaths of his wife and Lori's 2 innocent children. Chad Daybell is an author who wrote books about the apocalypse. During this trial, you will hear a story more troubling. And the story is real. Chapter 1. The defendant was a seemingly ordinary man. You'll see that he craved significance. He worked in journalism and he worked as a sexton in a graveyard. He married his wife Tammy in 1990 after meeting at Brigham Young University, and they settled in Utah. As a full-time homemaker and mother, Tammy's love for her family was boundless. Together, Tammy and the defendant started a small publishing company, which Tammy supported in many ways. They had 5 children together. They moved to Idaho, where Tammy became a beloved school librarian. She was devoted to service, her community, and her faith. But for this defendant, that ordinary existence was not enough. Chapter 2. Lori Vallow was a homemaker from Arizona. Your Honor, this mic just,
Sorry, Mr. Wood. Let's see if we get a replacement mic.
I got it working now.
Okay.
I noticed that the PowerPoint is not up.
Yeah, look, I think your mic's off.
Okay, I didn't turn it off this time, so
You might have a bad battery.
All those pesky technical issues always cutting into the flow, man. Yeah, grandkids are little petri dishes, aren't they? Kids are little petri dishes. That's actually Steve Jobs used to say that. My house is a petri dish because he would get sick all the time. He had little kids when I worked there.
You want to phone the screen as well?
Your Honor, it's up on the screen and I can explode in the HDMI. I'm not sure why it's not transferred. I don't know if there's any one person out with that.
Let's see if we can get some help to maybe see if we can get the signal to work on that.
Just really messes with the flow, man. when you got those tech issues. You know, I really wish these lawyers would take more time to come into the courtroom, especially if it's
Sorry.
their home courtroom,
Can I proceed?
Yeah, but I'm still not sure I'm gonna like that one.
and make sure the tech works.
Check.
Okay, thanks.
Apologies for the interruption, writing down. Chapter 2. Lori Vallow was a homemaker from Arizona.
Good morning, Marie.
She was married to her fourth husband, Charles Vallow, and she was the mother to Tylee Ryan and JJ Vallow. Tylee was a normal, vibrant teenage girl. She loved her friends. You'll hear that she loved her Jeep. She loved Chipotle. She loved her little brother, JJ. JJ was a 7-year-old boy on the autism spectrum. He required extensive special care and need. He loved his sister. You'll hear about a pivotal date that set in motion the deaths of Tammy, Tylee, and JJ. October 26th, 2018. That was the day when Chad Daybell and Lori Vallow met at a religious conference in St. George, Utah, where they were introduced by a mutual acquaintance. At this time, both still married to other spouses. That introduction set in motion the reality you're going to hear about. We know what happened next through the defendant's own words. You'll hear. Though both married, Chad and Lori began to have an affair. You will hear excerpts from the defendant's extended text messages to Lori that reveal his mindset and his motivations. In his thirst for sex, power, and money, Chad created an alternate reality where they called themselves James and Elena, names that Chad claimed were from past lives they had put together. The defendant's text messages reveal their story of lust and their plan for a future together. Chad Daybell wrote that upon meeting Lori Vallow, he experienced a happiness unmatched by anything else in his 50 years. He was captivated by her appearance, so much so he said she was out of his league. You will hear evidence in his own words, how he was taken by her beauty and spoke about their sexual encounters on many occasions. More than anything else, Chad's obsession with Lori was rooted in her adoration for him. She was the mirror reflecting the grandeur he saw in himself. He called her an exalted goddess. He told her in writing that she had returned to earth to perform a special mission. And part of that mission included being with him. They soon came together and turned their dreams into a plan for the future. One free from what they called obstacles. And those obstacles were Tylee, JJ, and Tammy. Chapter 3. You'll hear that in the world that Chad and Lori planned for themselves, they identified those who stood in the way of their dream as dark.
Hello, Brad.
Their spouses, Lori's own children, and any who oppose them were labeled sometimes as dark spirits or even zombies. This was more than an alleged belief of right-wing labor. The evidence will show that it was a convenient narrative that dehumanized people who stood in their way and who were labeled as obstacles. This narrative gave them the pretext to remove people from this world for their own good. Chad and Lori preached that only through spiritual intervention, what they sometimes called casting, sometimes through burning, or even through death, that these dark spirits be cleansed. Enter Alex Cox, Lori's devoted brother. Chad and Lori manipulated Alex with promises of spiritual rewards. They wielded their influence over Alex, drawing him into their plotting and planning of their own future. After the deaths of Tylee, JJ, and Tammy, Chad Daybell gave Alex a blessing. This blessing was reported by Lori, who was present. And in that blessing, he said to Alex, "You have earned the privilege to be a member of their exclusive religious group." And he also said to him, "You have already assisted us in ways that can never be repaid." But you will also see other text messages. Chad and Lori discussed more earthly concerns, that Alex could be the one to implicate them. Alex knew this as well. Shortly before he died, on December 12th, 2019, he told his wife, Zulana Pastenis, who you will hear from, he was afraid he was going to be Chad and Lori's fall guy. Chapter 4. Once their calculated plan was devised, it only took months to execute and remove perceived obstacles in Chad Daybell's path to a new life. Charles Vallow, Lori's husband, who was labeled as dark by the defendant, was shot and killed by Alex Cox in Arizona. Lori stood to gain $1 million, money that could fund Chad and Lori's future. Yet following Charles's death, Lori Vallow awaited a $1 million life insurance payout that never came, only to learn
Ooh,
that the
that pissed her off.
beneficiary was no longer her. Upon learning she would not receive that insurance money, Lori would text Chad, "I'll still get the $4,000 a month from SS, meaning Social Security." Chad replied to her in a text that read, "It will be interesting to see if it got changed after he had 2 bullets in his chest." Tylee Ryan, also branded Dark and a zombie, was last seen on September 8th, 2019. Subsequent investigations revealed the horrifying truth. Her remains, charred and dismembered, were found in a grave on Chad Daybell's property.
I'm showing her last known
Without
picture.
Charles's $1 million in insurance money to support them, Lori Vallow continued to illegally receive Tylee's Social Security benefits, provided after the death of Tylee's biological father, who had been Lori's third husband. According to this defendant, J.J. Vallow, Lori's son, was also possessed. After he was labeled as a dark entity, his fate was no less tragic than his sister's. His young life was also planned. Later, his bound body was discovered buried in Chad's backyard, his death by suffocation. Yet while JJ was missing, Lori continued to illegally receive JJ's Social Security benefit, money provided by Charles Vallow's dad. Tammy Daybell, a vivacious, healthy mother, was another individual labeled as a dark spirit to be removed. On October 9th of 2019, she reported being shot at night near her home by a man covered in black. She thought it was a paintball gun. On October 19th, 10 days later, she died in her own home with her husband present. This was soon after an increase in the value of her life insurance to more than $400,000. This defendant rapidly cashed in that life insurance and began looking for condos in Hawaii with Lori. You'll see the rental application he submitted for a couple with no kids. Medical examiners would later determine that the only reasonable explanation for Tammy's death was not of natural causes, but rather a homicide. In fact, you will hear from multiple witnesses that Chad predicted multiple times that Tammy would die in early death. Chapter 5. 17 days after his wife's death, Chad Daybell and Lori Vallow got married and celebrated on a beach in Hawaii, Hawaii, symbolizing what he called their eternal union. Chad and Lori were preparing their wedding well before Tammy's death. Lori was shopping for wedding rings while Tammy was still alive. Now, without the earthly obstacles of spouses and young children, and with Tammy's insurance policy and the children's Social Security funds, they could live the life that Chad and Lori wanted. Nothing was going to stand in their way. Chapter 6. Unfortunately for this defendant, reality soon shattered their bliss. 2 things led law enforcement to his and Lori's door. On October 2nd, 2019, Lori Vallow's nephew-in-law, a man named Brandon Boudreaux, was shot at in Arizona by someone from what he believed was Tylee's Jeep. Law enforcement in Arizona investigating Brandon's shooting contacted law enforcement in Fremont County, Idaho, to look for Alex Cox and for Tyler's Jeep. And you'll hear that that Jeep was later found in Rexburg, Idaho, in Madison County. Meanwhile, J.J. Vallow's grandmother, concerned that she hadn't seen or heard from him in months, asked police for help. The police followed up and located Lori in Rexburg, Idaho, where the police did a welfare check at Lori's apartment. Law enforcement arrived at Lori's door on November 26, 2019. When asked about Lori, Chad first told law enforcement he didn't know her very well, despite the fact that they were married and had been in a relationship for over a year. Lies by Lori to police about JJ and Tylee's whereabouts, and then a move to Hawaii, and Lori's unwillingness to present her children to law enforcement to prove their well-being led to her arrest and extradition. As Lori refused to produce her children, law enforcement continued their search for Tylee and JJ. During that search, they located a unique text message that this defendant, Chad Daybell, had sent to his wife Tammy on September 9, 2019, which was the day after Tylee Bryant's last known appearance. You'll hear from the FBI agent who found that message, that this message seemed longer than his usual text to Tammy, and it had a more conversational tone. In that text, Chad claimed he'd had an interesting morning, that he'd shot a raccoon, that he'd buried it in what they called the pet cemetery,
Jesus Christ.
and that he'd had a fire on the property where he burned some lawn debris. When law enforcement finally went to the defendant's property the following June, they didn't find a raccoon. They found Tylee's burnt remains that were buried in the pet cemetery. And they found JJ nearby, buried under a tree near a pond. Ladies and gentlemen, you've been told this would be a lengthy trial. You will hear from many witnesses. You will hear a lot of evidence. You're going to hear a lot of dates. The following is just a timeline of major events to help understand when these things took place. October 26, 2018, Chad and Lori meet in St. George, Utah.
Here's your timeline for anyone who.
July 11,
The timeline.
2019, Charles Vallow, Lori's husband, shot and killed by Alex Cox. Between August 31st and September 1st, Lori, Alex Cox, and Tylee and JJ moved to Rexburg, Idaho, just a few miles south of the defendant's home. Tylee's last known sighting was September 8, 2019. The text I just spoke of about the raccoon was sent by the defendant to his wife September 9, 2019. JJ's last known sighting you'll hear about September 22nd. The attempted homicide of Brandon Boudreaux in Arizona was October 2nd. The shooting I mentioned of Tammy, the shooting at her, the unsuccessful shooting, October 9th, 2019. Tammy's death, October 19th, 2019. 17 days later, Chad and Lori marry in Hawaii. Law enforcement did a welfare check looking for JJ November 26, 2019 in Rexburg, Idaho. November 26th and 27th, Chad and Lori leave town. June 9th, 2020, Tylee and JJ's remains are found on Chad's property. As I said, you're going to hear a lot of evidence from a lot of witnesses. And there's going to be kind of different groups of evidence you're going to hear from. You'll hear from law enforcement, some of whom will give you a broad overview of the investigation and what they did, how the search for Tylee and JJ drew to a case of murder. You'll hear how it began by people who knew Lori and Chad, the James and Elena. You'll hear about the James and Elena story and about their relationship with each other and how they pursued their dream, their plan for a life together. You'll hear in the defendant's own words, people referred to as obstacles, how they need to be gotten rid of. You're going to hear financial evidence. You'll hear from an FBI forensic accountant and a detective, a Social Security administrator, investigator, who will talk about the finances involved in this case. You'll hear more from law enforcement, from multiple law enforcement agencies, the Rexford Police, the Fremont County Sheriff's Department, the FBI, Social Security Administration, about the investigation into these crimes. You will see forensic evidence. You'll see DNA testing to identify the body of Tylee. You'll see DNA testing that showed that DNA from Tylee was found on at least 2 tools in the defendant's shed. You'll hear digital evidence dealing with geolocation data tied to certain phones that were used in this case. You'll hear from Hawaii law enforcement about searches they performed in Hawaii on the defendant and his wife. And finally, you will hear many of this defendant's own words. You will hear voice recordings of this defendant. You'll hear, recorded phone calls between him and his wife, Daybell. You'll read multiple texts that he and Lori sent back. Another text he sent. Chapter 9, what's unwritten. The defendant stands before you today, charged with multiple crimes. First-degree murder for the death of Tammy Daybell. First-degree murder for the death of Tylee Ryan. First-degree murder for the death of J.J. Vallow. Conspiracy to commit murder of Tammy Daybell. Conspiracy to commit murder and grand theft by deception, the death of Tylee Ryan. Conspiracy to commit murder and grand theft by deception for the death of J.J. Vallow, and insurance fraud. Two dead children buried in this defendant's backyard. The next month, his wife dead in their bed. 17 days later, this defendant marries Lori Vallow. Members of the jury, days or probably weeks from now, when the evidence in this trial is fully unfolded, we will have the opportunity
Look
to
at those
speak
two
with you again.
dorks.
And at that time, we will ask you to end this horrible narrative. Your verdict will be the link that writes the final chapter of this tragic saga. A chapter that delivers justice for Tammy, justice for JJ, and justice for Tyler. Thank you.
All right, thank you, Mr. Wood. That will conclude the opening statement of the state. Mr. Pryor, a couple of questions. First, is the defense going to give an opening statement now or defer until later? And second, if you are going to give an opening statement, would you prefer we take a mid-morning recess or go forward?
Judge, could we take a short recess? And I have a
Okay, I think this is a good time then for our mid-morning break. We'll go ahead and take that now. And then once that's concluded, Mr. Pryor can give his opening statement to the defense.
All rise.
Well, that is certainly on brand for Mr. Pryor to say, I need a break. Mr. Pryor is a very high maintenance guy. He's always asking, from my observations, he's always asking for more, always asking for more time, more of this, more of that. It'll be interesting to see his opening remarks. Those remarks from Rob Wood. That was Rob Wood, the prosecutor who just gave the state's opening arguments. And, you know, Um, he made he made salient points. He broke it down. It was a solid opening argument. It certainly wasn't delivered with the kind of passion I think I would want to have. If I was one of the victims in that case, like if I was a family member sitting in the room, I'd be feeling so angry that I want my anger to be vented out from the prosecutor. And I don't think you're going to find that in Rob Wood. By the way, if you're just joining, please remember to hit the thumbs up. Um, you know, so I think that the state has such a solid case that it would take a really it would take some big mistakes for them to mess up this prosecution. I mean, face it, I mean, like, they found these kids in his backyard. I will be very interested to see what kind of defense they try to put up. But I just wish that the prosecutor who gave the opening statements last trial for Lori Vallow was a female. Her name's Lindsay, I believe. Lindsay, I forget her last name at the moment. But she really brought you more into the emotion of the day, the impact of what we're about to hear. And he was just kind of reading off of a script, you know. I have seen Rob Wood get fiery. I have seen him be able to show passion and anger and things like that. In a courtroom, I think it's tricky. You have to balance your logic and your reason with your passion, and you can't let one side or the other take over too much, because you do have to connect with um the jurors on some level, on some emotional level. You want them to at least like you, right? Like you enough to want to listen to you. But even further than that, you want them to be drawn in by the story you're telling and to feel something from it. And I just, don't really feel like they heard much at all. So they heard much of that passion. But um, I'm not putting him down. I'm just saying that it just could have been delivered with a little bit more charisma and convincingness. I am very interested in hearing what John Pryor has to say. I suspect he might go on longer because he is kind of a windy guy. He's a very windy guy. But I think, what I do appreciate about those opening arguments is that he got across the timeline. Um, yeah. He said, he presented the timeline. He basically put things in chunks that were understandable. He put them in chapters that would be easy to follow. And I suspect that maybe when they do the closing arguments and also as they go throughout the trial, they'll be referring to those chapters. And, to be fair, there's a lot of information to break down in this case. There are so many layers. There's 3 innocent murders, murders of innocent people, I should say. And, they have a lot to present. I'm waiting to hear how many times Pryor says, frankly, Judge. I know we should maybe do a bingo card for him because he has these catchphrases that he uses all the time. So let me pull up some information. I'm going to, before we get into the opening statements of Mr. Pryor, I pulled up some information on his background. Now, he's a very interesting character. I don't know if you know this, but he actually has his own little bit of a past. He was actually he had to do a little bit of time for battery, and so he clearly has an idea of what it's like to be part of the system. Uh, yeah, he clearly wanted to keep it simple. Boop, 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 boop. The other things, like hold on, I'm looking for this information that I believe it was a partner, Johnny. Yes. Okay, I found it here. I'm going to start reading it to you. I'm not going to show it on screen because um in case court comes back, and then I'd have to get rid of that part of the screen. So this article is from 2012, September 13, 2012, and the hearing the title is Trial Underway for Idaho Attorney Accused of Battery. An attorney accused of assaulting a woman at his Nampa law office. So no, it was not his spouse, not his partner, but someone at his office, is facing trial this week on a charge of battery with intent to commit a felony. Prosecutors claim John Pryor of Meridian tried to have sex with a woman who rebuffed his advances during a May 31st, 2011 incident. During a trial that started Tuesday, Pryor's attorney countered that Pryor and the woman engaged in consensual sexual activity and that the woman's story has changed at times. This is sounds like a very typical case. The trial continued with testimony Wednesday and Thursday. The alleged victim, 20-year-old woman, told jurors that Pryor offered her money, employment, and assistance in a legal case if she would have sex with him. She testified that when she rejected Pryor's advances, he attempted to force himself on her. A grand jury indicted Pryor earlier this year, and since he practices as a Canyon County defense attorney, the Idaho Attorney General's office is prosecuting the case. Deputy Attorney General Jessica Smith opened her arguments by telling jurors the woman who had come to Pryor's office to talk to him about a job and discuss a child custody case. He had something else in mind, and that was sex, Smith told the court. Pryor took the woman into a conference room and then left to retrieve paperwork, but instead returned with a condom, the prosecutor said. Pryor then took off the woman's clothes, forced himself on top of her, and attempted to rape her. Smith said. The prosecutor told jurors she would present NDA evidence to show Pryor unlawfully touched the woman. Defense attorney Scott Fauser told a very different version of the incident, saying the woman was in dire financial straits and agreed to have sex with Pryor for money, but then lied about it to her family, her boyfriend, and to police. Fauser promised to show jurors video surveillance from the law office and evidence of a $200 bank deposit made by the woman. She denied that she had agreed to such an offer while being questioned by Fauser, saying she deposited an unemployment check and money given to her by her father. The woman told jurors she didn't resist or scream because she was too afraid and went to police later that day at the urging of her cousin and her boyfriend's mother. I wasn't going to say anything, she said, because I was scared of him, because I didn't think anyone would believe me. So that's the story. Now, hello, welcome, Adrian. Hello, welcome, people coming in. That's the story about John Pryor, and that was just as they were going into trial. That doesn't say what the outcome of the trial was. my understanding. Okay, here's the result. Nampa attorney John Pryor sentenced to 120 days for battery. John Pryor, an attorney who pled guilty to a reduced charge. So this is what he did. He pled down. He pled guilty to a reduced charge of misdemeanor battery, was sentenced Tuesday to 120 days in jail, 100 days suspended, and 30 days discretionary, and fined $137.50. Pryor pled not guilty in May to the original charge of battery with intent to commit serious felony. The charge came after a 19-year-old, they said 20 in the other article, Caldwell woman seeking employment and legal advice reported Pryor attempted to sexually assault her in his building's conference room. Pryor's attorney argued during the jury trial that the victim consented to the advances and took money from his office. The woman denied both claims. So he pled that baby down. And that's what happened to that case. That's what happened there. So that would be the answer to your question, Johnny, of why he's not on a sex offenders list. He pled it down and it became a misdemeanor. And that happens in many, 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 many of these cases. There are, I think, a lot of sex offenders running around out there who got, their charges got pled down, and that might have been a primary reason the charges were pled down, was so they wouldn't appear on the sex offenders list or wouldn't have to register as a sex offender, because that's a major deterrent. But unfortunately, that those courtroom dealings then take that red flag off of the list for people, for future victims, right? So that was a long time ago. I mean, we do have to acknowledge it was it was a very long time ago, and he did his sentence, and I hope to God that either he wasn't guilty of those things and just did what he had to do to get rid of it, or he isn't that way anymore. His demeanor and his antics in the courtroom show that, to me, that he does have like kind of an entitlement vibe going on, a little bit of a whiny vibe going on. He, and I guess maybe that's something that a lot of defense attorneys have to, like a posture that defense attorneys have to take. But yeah. So that was in 2012, Stacy. So it was, over 10 years ago. How are you all doing in the chat today? I wonder if any of you have been following the Apple River stabbings trial. That is a deep question, Johnny, which I will answer, but not right at this moment. But I believe some people can change, and I believe other people cannot change. And it's hard for us to tell as mere mortals when they've crossed that line. So we're talking now about the Apple River stabbings trial. It is a fascinating trial, and in fact, today they did closing arguments, and they might be happening still right now. So what I was thinking I would do is that when this case goes on lunch break, when this trial goes on the lunch break, I will show the closing arguments, and I will also talk anybody through the case that might not have followed it. It's fascinating because it's a it's a self-defense case. It's a man who, you know, is being accused of stabbing 5 people during a river brawl. But there are many questions about who initiated the first contact, who was the aggressor, um, you know, and he's claiming self-defense. And so um, we will, Johnny. He, to me, and I'll, you know, as a spoiler alert, to me, the defendant is shady. I mean, the he walks over to a group of teenage boys. They ask him, and they're, you know, these are teenage boys. These are teenage boys who are obviously drunk. They ask him what he's doing. They claim that he made a remark something like, looking for little girls. He claims he didn't say that. He claims he said, I'm looking for my phone, because the reason he went over to their area is because a person in his party lost the phone. So he put on his snorkeling gear in shallow water and was like swimming around with his snorkeling gear in shallow water in a river looking for this phone, he says. But he comes upon these kids. They say, what are you doing? They claim he says, looking for little girls. So they start doing what drunk high school boys do, which is not fun. I highly recommend that you stay away from drunk high school boys, because they are jerks. They're jerks. They'll call you names. They'll do things that make you ashamed to have teenage kids, right? So they started taunting him, and they started telling him, go away, and they started calling him pedophile and predator, and one of them called him an raper. So he and they keep telling him to leave, and he doesn't leave. He doesn't walk away. In fact, he impedes their tubes. You know, they're tubing down the river, so they're sitting in tubes as they're going down the river, drifting down the river. He actually impedes their tubes from continuing to go. So since this man isn't leaving, the kids start yelling to other groups on the river to come help. They're like, help, there's this old man. You know, uh, I'm not repeating all this perfectly and verbatim, but um, some other people came over, and it's specifically 2 women from a different group came over and started yelling at him and saying, get away from here, get away. And he wouldn't. And more people started coming over, and he wouldn't leave. And finally, someone was punched, and most witnesses claim that the defendant punched one of the girl that was in front of him, telling him to go. He claims he didn't punch. He claims he just pushed her away. So, but before you know it, he, like, within quick succession, and it's all on video. Most of it is on video. You can see most of this on video. He takes out his knife and he stabs 5 people, killing one of them and disemboweling another one. Yeah, and I agree with you, Evil Queen. I don't think he went there with the intent to kill anybody. But that was an excessive use of self-defense, in my opinion. You don't need to bring a knife to a fist fight. He could have turned around and walked away. And also, then, after all of that happened, and it is absolutely grotesque and grueling to this trial. They've been going back and forth through the footage of this video on the river. I would absolutely hate to be a juror on that in that trial, in that courtroom, because they keep having to watch video of teenagers being killed and disemboweled. But so he was pounced on. He did feel ganged up on. There was, a crowd thing. They were jeering him. They were taunting him. He could have walked away. But then this stabbing happens, right? And that's what the whole idea of, who's the aggressor and was he acting in self-defense? That's what's on question in trial. But his actions after all of that tell me that he's guilty, okay? Of at the very least, again, not first degree murder. He didn't walk over there to choose. He didn't go to that river choosing to kill people that day. But he used excessive force, okay? Most of them didn't even know they were stabbed at first. It went so fast. So then he literally stabs one kid in the heart, killing him. He disembowels another kid who when he testifies, says, I was literally holding my intestines in my hand. It is absolutely horrifying, you guys. This guy, the defendant, just walks away, just casually walks away after the fight is broken up. He goes to a whole other part of the river away from his group, washes his hands, and throws the knife onto the riverbank. And then when the cops catch up with him later, he pretended nothing ever happened. He pretended nothing ever happened. So then the cops finally catch up to him, and he lies and lies and lies. At first he says, hey, what fight? I didn't know there was a fight. Oh my gosh, there was a fight. And then they finally, zero in on the fact that he's the one that was in the fight. And then he just lies and lies and lies. He's like, oh, well, he didn't know that it had all been recorded on video. Didn't know that it was all recorded on video. So he just tells this entire tale about how the other kids pulled knives on him. So I think, when you look at the video footage, you look at the look on his face, you look at the way he was reacting to being taunted. What you basically had there was a guy who was basically saying, oh, this is just a bunch of silly teenagers over here. But then he gets into their drunk way, and drunk teenagers are jerks. They're jerks. They start calling him all kinds of names, and they start surrounding him, and then he punches, and people start punching him, and then he stabs. And it reminds me of it's like the physical version of a YouTube drama war, where one person makes one person makes a taunting move, the next person escalates, the next person escalates, the next person escalates, and it's hard to see where it started, who's to blame, who should hold responsibility for that whole thing starting in the first place. And most of the time it's because somebody's feelings got hurt about a name they were called. Yep, that's right. Hippie Chick says The other young adults that came over to help the teenagers were the ones that were really up in his face at the end of the altercation because the woman was the person he hit. And that's right. So by the kids' testimony, they say, hey, you know, we see this guy come over. We start, you know, he says he's looking for little girls. We start saying, go away. Then these older women, they're not older, they're only in their like 20s, 30s. They come over and adults start coming over. And when the adults come over, we felt safer. And it was the adults that were starting to get into this man's face. And it was this, what I find very interesting is the main woman that he first punches was not called as a witness. They called every other person in the groups as a witness. But this girl, Maddie Cohen, was not called to the stand, and I'm not sure why. It sounds like she has a very troubled life with addiction. I don't know if that is why, but she hasn't been called to the stand. But I believe they did have her testimony from her police interviews in the, you know, during the trial. They showed that. Yeah. So she was called, but not on film. Huh. Okay. Most of them now are only, oh, she testified off camera. Gotcha. Okay. Looking for her testimony and I just couldn't see it, and I guess that's why. So the kids, all down to every single one of them, and they're only, you know, at most 19, 20 now, because at the time they were juniors and seniors in high school. And this has severely traumatized them for the rest of their lives, and they see the role that they played, and they feel horrible about it, and they say that they would never do it again. The kids, all the kids, there were many kids who testified and other witnesses who testified, and they are so, I think they were all involved in a very traumatic situation. So some of their stories, you know, some of their testimony differs a little bit from the other, but none of it ever veers so far off course as to
Thank
you
you. Please
thinking
be
that
seated.
they're actually lying. Okay, it looks like they're back.
Please have the chair, bro.
Mr.
Okay, Mr. Pryor, let's see what you got. Okay, people. What's going on, people? More technical difficulties? I'm not sure. This is so weird. They're just kind I guess they're waiting.
All rise.
Okay, they're waiting for the jury.
Very present and accounted for.
All right, thank you. Please be seated. We've concluded our morning recess. We're back on the record on KCR 22-21-16-23. State of Idaho versus Chad County Daybell. This is the time we'll next have opening statements by the defense. Mr. Pryor, is the defense ready to proceed?
Yes, Your Honor, may I have the post permission to enter the well?
You may.
Thank you.
And maybe check that microphone to make sure it is working.
Okay. Good morning, ladies and gentlemen. As an introduction, I'm John Pryor. I'm the defense attorney for Mr. Daybell. And I'm from Meridian, Idaho. I'm an attorney from Meridian, Idaho, over here on the west side of the state. I want to talk to you a little bit today. And at my age, video presentations are not something that would come easy to me. So I'm just going to talk to you a little bit about my view of the case and the facts and evidence. And what's important are facts and evidence. I think that when we went through the jury selection process, we talked about facts and we talked about evidence. And the judge gave you an instruction to talk to you a little bit about you take into consideration the facts of this case and not be distracted by other things. Don't be distracted by speculation. Don't be distracted by guesses or assumptions or hunches. It all comes down to facts and evidence. So I'm going to talk to you a little bit about the facts and evidence in this case. Chad Daybell, and I'm learning this, and I've had some time to learn about this because it didn't come natural to me. But Chad Daybell went on what's called a mission early on in his life. And I guess what a mission is, I'm not familiar with that, but I guess what a mission is they go away to a location and they talk to people about their religious beliefs. And Chad's faith, that was important as part of his faith. And when they return from these missions, they start the process of moving on with their lives. And when Chad got back from doing his mission in New Jersey, he met Tammy Daybell. Another fact that I discovered, and you'll hear a little bit about, is that Chad had an extended engagement, had an extended by his faith standards romance before they got married. Chad and Tammy dated for approximately 6 months. And what I understand is by their nature, 6 months is an extended dating process before you end up getting married. So after 6 months, they got married. They were married in Utah and proceeded then to have children. They have 5 children, now all 5 adult children. At some point, they moved back here to Idaho, or moved to Idaho, and they started a small publishing company. And you'll hear testimony that the publishing company was predominantly run by Tammy. Tammy managed it. Tammy was the brains behind the company. And Tammy basically took the reins and did everything that was necessary to move this publishing company. It was a small publishing company, a very small publishing company. And what they did is basically publish books. Chad would write these books. And he would write these books about his religious experiences. In his faith, he had certain beliefs, faith that he practiced. You know, when he went on his mission, when he, read his interpretation of the books that he used for his faith, he started writing books about things that were consistent with his faith. Things like premonitions. We've all heard of premonitions, about being able to predict things, about being able to see maybe when things happen. And some people believe in that, some people don't. Some people have personally experienced that, or I've been here before. But he writes about his premonitions. He writes about good and evil. and what it means to be good, and what it means to be evil. He writes about dark and light. He writes about subjects that are a little darker, like death, and maybe the coming of the end of things, and when his savior in his mind is going to come back, and maybe there'll be some kind of a redemption of some sort. But his books covered a lot of subjects like that, and they were all based on fiction. In other words, he was writing these books about theories and things that came into his head, and he would write these stories. But he also wrote children's books, and he wrote books for teenagers. And he wrote these books about adventures and then some crazy ideas about things that kids and teenagers get involved in. In about October of 2018, Chad was going out and he was invited by one of the witnesses that you'll hear in this case to speak about his books. And this was not uncommon. He would travel and he would be asked to say, well, come and talk about some of the things that you believe in. You've talked about these premonitions, some life experiences. You're going to hear testimony about that. And he was invited on one particular occasion in late October. And he attended this, and while he was there trying to sell his books, and like most of us who are business people, the focus of these meetings really was for Chad to try to get his books published, because that's how he made a living. And he was there in one of his booths trying to promote his books, and he laid them out there. And this beautifully stunning woman named Lori Vallow comes up. And she starts giving him a lot of attention. And she pursued him. And she encouraged him. And you'll hear testimony that she went so far as to grab behind him and sort of help him in trying to sell some of his books. She obviously had an interest, and maybe she felt that he was this publisher, or maybe she had an opinion. You'll hear testimony about that. And then after the seminar, there was a length of time where there was no contact between the two of them, a month and a half, 2 months. And during that time, Chad Daybell went on his day-to-day life. He'd been married to Tammy for some 29 years, has no remarkable background of any kind. I think the testimony we'll offer will show I think he had a speeding ticket in 2005. But Lori Vallow was a different story. Lori Vallow was someone who, right out of high school, married her first husband. You'll hear testimony about this. That marriage was very short-lived, very short-lived. She then married husband number 2 a few years later. And again, very short-lived marriage. And there's some testimony indication that there were some problems with the marriage that caused the breakup. But the concern seems to be, the theme seems to be that Lori's brother, Alex, and you're going to hear about Alex Cox. Alex Cox was Lori's protector. Alex Cox would do anything and everything to protect, aid, and assist Lori Vallow in whatever her endeavors, without unbridled question, anything. And if Alex Cox even perceived that there was a problem, Alex Cox reacted. You're going to hear testimony that in 2007, I believe it was in August of 2007, Lori Vallow had finished up going through her third marriage with Joseph Ryan. It was a tumultuous, you'll hear testimony that it was a tumultuous marriage, a terrible marriage. And Lori Vallow made accusations against Joseph Ryan of abusing their child, Tylee. Yes, the same Tylee. And during one of the visits of 2007, folks, and I want to tell you, you're going to hear testimony that in 2007, Chad Daybell didn't even know Lori Vallow existed. But Alex Cox, after one of the exchanges and the visitations with Tylee, Alex Cox approached Joseph Ryan and shot him with a taser and assaulted him. Was eventually charged with aggravated assault, was eventually put in jail, and had this on his record. And there is representation, the facts will suggest that at the time Joseph Ryan feared for his life. This was a serious situation. But it set the pattern for what we're dealing with Alex Cox. Whenever there was a problem or a threat to Lori Vallow, you'll hear testimony that Alex Cox came to the rescue. But Alex Cox would run without even question and do whatever was necessary to solve Lori Vallow's problems. We're going to fast forward then to 2019. Lori Vallow is still married to Charles Vallow. And the prosecuting attorney mentioned this, yes. Chad Daybell at that point, coming in January and February, started to have communications with Lori Vallow. And yes, folks, it turned into an inappropriate relationship. 2019 forward. And yes, he was engaging in discussions. He was engaging in contact with her, all of the things that the prosecutor talked about in terms of a relationship. But subsequent to the seriousness of this relationship getting rolling, Alex Cox was at a visitation in 2019 with Charles Vallow. And Lori Vallow was there. Tammy Ryan was there. JJ was there. They were all present. And during that altercation and that supposed visit, much like with Joseph Ryan, Alex Cox took out a gun and shot Charles Vallow. And then after calling 911, he then finished the job and walked up to him at close range, finished him off. Now, you're going to hear testimony that in some way, Chad Daybell is implicated in that. And you're going to hear further testimony that he was not. You're going to hear testimony and see documentation that suggests that the prosecuting attorney on review of this indicated that there is no likelihood of conviction of Chad Daybell. You'll hear testimony that Chad Daybell had nothing to do with the execution by Alex Cox, Charles Vallow. And the same for Brandon Boudreaux. You will hear that Chad Daybell is not being pursued for any involvement in the Brandon Boudreaux attempted murder. Those occurred and those are separate, as well as the Charles Vallow. So what we have is we have a situation where someone who's 29 years old, Chad Daybell, 29 years of marriage with Tammy Daybell, no discernible issues in his life. And then Lori Vallow comes in the picture, Miss Texas. You'll hear testimony about this beautiful, vivacious woman, very sexual person, and very manipulative. And she knows how to get what she wants. And she drew Chad Daybell into a relationship, and an unfortunate relationship, that Chad fell into. After that, things started rolling, and issues started happening that eventually, yes, there was a murder, and there was a burial. And you've heard discussion about the backyard of Chad Daybell. Well, we have a 4.5-acre farm in Fremont County, Idaho. And you'll hear testimony that the body of J.J. Vallow was discovered behind an irrigation pond and a tree out in the pasture. So technically, yes, maybe the backyard, but more accurately described as the pasture, hidden behind a tree. You're going to hear testimony that also in the middle of this pasture was a raspberry patch, former raspberry patch, that was then turned into a place for them to bury the cats, the dogs, and all of the animals on the farm. Okay? Again, out in the pasture of the field and not the backyard. You'll hear testimony about that. You're going to hear
It's
from
his
4
property.
experts that I'm going to bring forward. And these 4 experts, the first one is going to be Dr. Greg Hampikian. And Dr. Hampikian is a bit of a notable local from Boise State University. And Dr. Hampikian is a DNA expert, considered one of the best DNA experts. He's been involved and has significant work that he's done on both the defense and for the prosecution. He was involved and led the team with Amanda Knox in Italy that got her exonerated because of the DNA evidence. He has substantial experience. And anybody or anyone who knows anything about DNA goes to Dr. Hampikian first, because he is the guy. And Dr. Hampinkian is going to talk a little bit about the DNA evidence that's found on the scene. Dr. Hampinkian is going to talk about the fingerprint on the plastic that J.J. Vallow was discovered in was that of Alex Cox. Dr. Hampinkian is going to talk about the hair sample that was found on the plastic of Alex Cox and that it was Lori Vallow. Dr. Hampinkian is going to talk about several, and I mean several other hairs that were found on the plastic of J.J. Vallow. But he's also going to say that there was no DNA evidence, no hair sample of Chad Daybell on Tylee Ryan or on J.J. Vallow. You're then going to hear from Dr. Raven. Dr. Raven is a forensic pathologist, and she's going to talk a little bit about the circumstances surrounding Tammy Daybell. And what Dr. Raven is going to say is that there's no indication that this is either a homicide or any other crime, and that the only conclusion she could come to is you can't determine what the cause of death was. There's no way to determine it. Tammy Daybell was buried. You'll hear testimony about that. And then a short time later, the police officers showed up and they dug her body up after she'd been buried, after she was laid to rest, and then continued after the body was pulled out of the ground and continued to examine it for whatever they were looking for. And what you're going to find is based on that, Dr. Raven's going to say you can't determine what the cause of death is. You're going to hear testimony from the Daybell children, from the children themselves, 4 of the 5 children, I think, three or four of the 5 children. Testimony. They're going to talk about their mother's health struggles. They're going to talk about their mother's use of various medicinal treatments that she would use, oils that she would put on her leg, medicine and different herbs that she would take, and that her mother was suffering from, that their mother was suffering from a number of maladies, and that she would refuse to go see a doctor or get it treated. And Dr. Raven's going to enlighten you a little bit about some of the circumstances regarding Tammy Daybell. You're then going to hear from Patrick Eller. He's a forensic digital data examiner. And Patrick Eller is someone who has spent his life in the military working for various agencies, and we'll talk a little bit about that within the government to do data retrieval and data research. And he's going to talk a little bit about the phone records that are involved in this case. He's going to specifically talk about the travels of Alex Cox, because you are going to hear testimony that Alex Cox went to Chad Daybell's property on the 9th of September. You're going to hear that Alex Cox approached Chad Daybell's property a half a dozen other, 5 or 6 other times. You're going to hear testimony that Alex Cox was there on the 23rd. And you're going to hear where Alex Cox was in a number of other times and places in his whereabouts and his travels for about a 2.5 month period. And Patrick is going to, offer you some information and data to support all of that. And finally, you're going to hear from a forensic anthropologist, and his name's Eric Bartlink. And Mr. Bartlink is going to talk to you a little bit about the nature and the nature of how the remains of Tylee were burned. Eric Bartlink is going to talk to you a little bit about the lack of complete skeletal remains and why, when Tylee was dug down in the ground, there was not a complete set of skeletal remains. In fact, there were a number of pieces of that were missing. You're going to hear a lot of evidence, and the judge has talked to us a little bit about not making a decision until you hear all of the evidence. And there's a specific jury instruction that talks about that. The jury instruction is, consider all the evidence. Listen to the instructions from the court on how you're to proceed. Listen to the arguments of the prosecuting attorney and the defense. And then and only then do you make your decision. And at the conclusion of all that evidence, and at the conclusion of the judge's instructions, the arguments of both of the defense attorneys, I'm going to ask you folks to return the verdict not guilty. Thank you, folks. Thank you for your time.
That wasn't as long-winded as I
That
expected it to
concludes
be.
the opening statement of the
Pretty
defense.
succinct.
Then this time we will commence with presenting evidence. I understand the state does have a first witness to call. Is the state ready and prepared to do that?
Your Honor, the state is prepared. We had spoken with your clerk earlier. We thought we were going to have a brief sidebar.
Well, let's discuss our schedule and put there in sidebar. Sure.
Sidebar, time for a sidebar. So yes, this is a death penalty case. I thought that was a very tight and succinct opening statement, just basically humanizing Chad. But, you know, we've been anticipating what kind of defense they're going to put on, and it's obvious now to me. The defense they're putting on is Lori manipulated Chad into, you know, falling in love with her and using his zombie philosophy to decide to get rid of the children. And it was all hers and her brother's doing. And he was just an innocent bystander who, you know, it'll be very interesting to see how they prove, you know, that defense, what they, you know, how they answer to certain things, like this text message that Chad sent to his wife. As a reminder, he sent his wife away that very weekend. He said, you know, your grandmother came to me and she told me that she wants you to go see your mother and your family. Okay. He told her that. And because she was a dutiful wife and she believed that her husband was a prophet, she did what he said. And she took that weekend away. And then she receives this text message, which is an order of magnitude larger than any text message she gets from him in the previous years, because they don't have this kind of communication with each other. And he says, you know, he announces that he has shot a raccoon in his yard, and lo and behold, he's shot a raccoon in his yard and buried it in the pet cemetery. And lo and behold, that is where they find the children. And the last day that Tylee is seen alive is September 8th, the night before, the day before that text is sent. This is when she is last seen alive, and it is with her lovely uncle, Alex Cox. So I think what they are going to have to prove, perfect. I love that using the new emojis. I think there will be more theatrics later in the trial when they start bringing out more of the evidence and more of the witnesses. The theatrics came with Lori Vallow's trial when their family members testified, because it was the first time you really heard Lori's family members and what their reactions and their...
Council, thanks for discussing scheduling. Our intention here will be to start with the state's first witness that apparently will take some time. So we will plan on taking a lunch hour also at right around noon if possible. So Mr. Wood, are you going to be calling the first witness?
Yes, Your Honor, and the state will be calling Ray Hermesian.
All right, well, call your witness. We'll have him come up and sworn.
Yep, I agree, Tiggy girl.
Sir, before speaking. When you're facing Madam Clerk, raise your right hand and be sworn.
solemnly swear or affirm the testimony you're about to give will be the truth, the truth, and nothing but the truth, so help you God.
All right.
I believe this is one of the detectives that I didn't hear them say his name, but I think this is one of the detectives that found the kids. I'm not totally sure though. Either that or
Officer, as you testify, just remember to make a audible response to anything being questioned, so that the record stays clear, and try to avoid speaking over the top of anyone questioning you. That in mind, then, Mr. Wood, if you'd like to inquire, you may.
Thank you, Your Honor. Officer, will you state your name and spell your last name for the record?
Ray Hermosillo, Hermosillo. Is that on?
Your Honor, is that microphone on?
yes,
I'm not
this
sure.
detective has testified many times in the preliminary and in Lori's trial. And you don't have to apologize for saying Chud Dumbbell.
Yeah. Yeah, why don't you go ahead and start over and just talk right into the mic, please.
Detective, will you state your name and spell your last name for the record?
Ray Hermosillo, Hermosillo.
Thank you. Detective Hermosillo, what is your occupation?
I'm currently a lieutenant in the detective division for the Rexburg Police Department.
How long have you been a detective?
5 years.
And how long were you involved in law enforcement before you became a detective?
Before I was a detective, 18 years.
Have you worked for any other law enforcement agency other than the Rexburg Police?
No.
And are you post-certified?
I am.
Detective, have you been involved in the case regarding Chad Daybell?
Yes, I have.
You know what Chad Daybell looks like?
I do.
Is he present in this courtroom?
He is. He's at the defendant's table for sure in a low screen time.
Thank you. Detective, let's talk about how did you initially become involved in the investigation regarding Mr. Daybell?
On November 1st, 2019, I was contacted by Fremont County Sheriff's Office. I was told that there was possibly a Jeep that was involved in an attempted homicide in our jurisdiction. So at that time, with that information, I contacted Gilbert Police and asked what they needed us to do to assist them.
What did you do?
Gilbert Police asked us to seize the Jeep if it was located. They gave us the address of 565 Pioneer, which is Rock Creek Townhomes. They also asked us,
Detective, I'm gonna stop real quick. Where is that address located? What city?
Rexburg,
What county is Rexburg in?
Madison County.
So once you received that address, what did you do?
Gilbert asked us to seize the Jeep if we had located the Jeep. They also asked us to perform intermittent surveillance. So at that time, that's exactly what we did.
When you say intermittent surveillance, what did you do to perform that surveillance?
When we were driving around, when there was no other calls coming in, we would park in front of the residence, behind the residence, take photographs of anybody leaving or coming in. That's basically what we did for the surveillance.
And do you recall what dates you did that surveillance?
The dates were between November 1st and November 4th, when I located the Jeep at 565 Pioneer.
Did you ever see the defendant at that address?
I did. There were a few times during the intermittent surveillance that we had taken photographs of the defendant, Mr. Daybell, and Lori Vallow, either coming or going from the residence.
And that was between the dates of November 1st and November 4th.
Judge, could we, for the record, have this officer established?
I'm sorry, 2019.
So. Right, and did you, when you talked about seeing Mr. Daybell, was that between those dates of November 1st and November 4th, 2019?
That's correct.
And your primary job was to look for a Jeep, is that accurate?
Yes, that's correct.
Your Honor, I'm gonna ask that the witness be handed what's been marked, the State's Exhibit 90.
Very well.
The court has a courtesy copy and counsel as well.
Mr. Wood, to be clear, it sounded like you said 90, this is 9A.
I believe it's 90. Double check.
Glad to see the exhibit, so I can confirm my words. It's okay.
You're correct, Honor, 9A,
Thank you.
and that would be exhibits 9A through 90. Detective, do you recognize State's Exhibits 9A through 90?
Yes, I do.
What do they purport to be?
That is the Jeep that I had seized, parked in the parking lot just outside of 565 Pioneer.
And were these pictures taken at the location of 565 Pioneer?
No, these photographs are taken at our in-town lot at the police department.
Did you take these pictures?
I did not.
But do you recognize these images as true and accurate representations of the Jeep you seized from 565 Pioneer Drive?
Yes.
Your Honor, I'd ask the State's Exhibits 9A through D be entered into evidence.
Any objection from the defense?
Judge, I'd like to move on to your immediate action on the foundation.
All right, you can board there or ask foundational questions, Mr. Pryor.
Officer Hermosillo, thank you. You mentioned that you were doing surveillance on the Jeep, is that correct?
That's correct.
Did you have an occasion to get close to the Jeep during that surveillance?
We hadn't located the Jeep during that surveillance. I located the Jeep on November 4th, 2019, and that's when I had it impounded.
Okay, and at the time of being impounded, did you have the occasion to go through the Jeep and observe the Jeep energy? Or were you relying just on the photographs taken in the Jeep? Do you understand my question?
No, sir. You
I'll
repeat it.
rephrase that. Did you have a personal occasion to go through the inside of that Jeep and observe the contents within the Jeep?
Your Honor, I think that goes beyond the scope of this specific exhibit.
I guess the issue, Mr. Wood, is he indicated he did not take these photographs, and some of the exhibits also contain photographs of the interior of the Jeep, so it's proper, more dire negative objection.
May I continue, Judge?
Yes.
Officer, all I'm trying to establish is I don't want you to be able to testify that someone else took the pictures and this is what they found. I want you to be able, you're authenticating and you're under oath to swear that these are accurate photos. I'm trying to find out if that knowledge is based on your personal experience, or is it simply based on the fact that you're relying on somebody else who told you this is what we found? So that's what I'd like you to clarify for me, if you would, sir.
Sure. I impounded the Jeep. I was standing next to the officer taking the photographs, and I also went through the Jeep personally.
Okay, I withdraw the objection. Thank you, officer.
All right, exhibits 9A through D are admitted.
Thank you. May I publish to the jury?
You may want to have a quick sidebar with counsel.
Like the reporter?
So I don't know if you've been reading my chats, but I talked about the 2 near-death experiences that Chad claims to have had, which are very normal passages of life for anybody who's lived near water or around the ocean, which is to get pummeled by the waves or somehow get smacked by the water. And he claims that he's special, that he had a special experience when he was dragged under by the waves and when his face was smacked by the water, that he was able to pierce the veil now because he had a moment with God. He died and came back both of those times. That's what he claims. And this is what gives him the power to tell people that he has direct communication with God. And he's been able to convince a lot of people of this. At least by the time Lori met him, he was able to convince a lot of people of this. And she bought all of it, at least what she said, hook, line, and sinker. She had been reading his books before she met him. And then she went to that conference knowing that he would be there. So it's probably not a stretch to say that she pursued him. I wouldn't doubt that she pursued him. But that isn't entirely, it takes two to tango, as they say. So I love it when they call one side or another a home wrecker in these situations. Both sides are home wreckers when one is married and when either is married. And in this situation, they were both married. They were both home wrecking their own homes, right? But of course, she's going to be painted in this trial as the single solitary home wrecker without taking any of his decisions, his choices into account. Hello, Jamie Lee. Welcome. So that's one thing that bothers me, about how conversations in these cases roll out, which is, a woman, a very beautiful, vexatious woman, her vamp came along and she was so overpowering that the man couldn't control himself. There was nothing that the man could do to control himself from cheating on his wife. It was all the woman's fault. No, he made a decision to cheat on his wife and be with this woman. So, but when you live in a world such as they do, where God can, has this power over people.
Mr. Wood, if you'd like to proceed with publishing the court's instructions there on the sidebar, then you may publish any or all of the photos.
Thank you, Your Honor, and if I could have access to the album.
Well, and also by all accounts, Chad had also been at the very least, flirting with other women as well in the community. He had been publishing Julie Rowe's books. Julie Rowe is also, Julie Rowe still espouses these theories.
That's what you saw in State's Exhibit A.
Yes,
Is this the Jeep that you had been assigned to do surveillance for?
that's right.
Did you ever learn who this Jeep belonged to?
I did.
Who did it belong to?
It was registered to Charles Vallow, but we later determined that Tylee Ryan drove that Jeep.
Detective, this is State's Exhibit 9B.
They're talking about the Jeep that
Is this that same Jeep?
Yes,
Alex Cox used in his assassination attempts with
That's all I'm going to publish now.
Tammy
All right,
Daybell
thank
and Brandon Boudreaux.
Detective, while you were doing your surveillance, you testified that you had occasion to see the defendant, Lori Vallow. Did you ever see children with her?
no, we didn't.
Did you ever see anybody else with them?
No.
That's good. Were you, at that time, were you aware of who JJ Vallow was?
No,
Were you aware of who Tyree Ryan was?
no,
So when you spoke with, is it fair to say that when you were initially contacted by another law enforcement agency, they did not ask you to look for those children?
Welcome back,
at that time?
Chopper.
that's correct.
Detective, did your role in this investigation change after that?
It did.
When did that happen?
After I had seized the Jeep November 4th, 2019, I contacted Gilbert Police and let them know I had the Jeep. Gilbert Police Department flew to Rexburg with a few of their detectives and a few of their crime analysts to go through the Jeep and serve a warrant with the Jeep. They were looking for the infotainment center, which is the middle of the Jeep console. It has the GPS locations, things of that nature, and they wanted the information extracted. So when they were up here on November 18th, 2019, they asked me and the other detectives if during our intermittent surveillance, if we had seen any children. And we told them we hadn't. They stated that JJ's grandmother.
Judge, I'm gonna object. I'm trying to be somewhat open-minded about foundation, but I'm gonna object.
I'll ask a question, Your Honor.
Go ahead, thanks.
So you did have further contact with law enforcement from Arizona?
Correct.
And which law enforcement agency was that?
Gilbert Police Department.
And was it Gilbert Police Department that was looking for that Jeep?
Yes, it was.
When you followed up with them about the Jeep, did they give you any other information about their case?
They did.
Did any of that information regard children?
Yes, it did.
What were you told by Gilbert Police?
Judge, objection, hearsay.
Coming in for the effect on the listener, Your Honor?
Judge, could we approach?
No, give me a moment to make a ruling on that. I'll instruct the witness can answer the question, but for only the purpose of effect on the listener, if you can clarify that to your witness, Mr. Wood. And any objections overruled.
Detective, based on your conversation with Gilbert Police, did you take any action regarding any children involved in this case?
Yes, we did.
And for the purpose of what you did, what information were you given that you needed to look up on?
We were informed through their investigation that JJ Vallow's grandmother was concerned for his safety.
Judge, and again, I'm gonna object at this point to renew my objection. That's going beyond.
I'll also sustain that as bringing up your statement, Mr. Wood.
Okay. Based on your conversation with Gilbert Police, what was the next step you took in your investigation?
We were requested to do a welfare check on JJ Vallow from the Gilbert Police Department.
Detective, had you ever met JJ Vallow?
No,
Were you provided any identifying information as to his age or where he might be?
we were provided very little information, just a brief description of what he looked like, his age, and where he should be, which was 565. 565 Pioneer Road, where he lived with his mother, Lord Vallow.
Your Honor, I'm going to ask that the witness be handed State's Exhibit 1.
Judge, I'm gonna stipulate to the admission of states exhibit one.
All right, it's being offered, Mr. Wood.
Yes, Your Honor.
States exhibit one has been offered without objection. The court will admit states exhibit one.
And Your Honor, with that stipulation, I'd actually ask that the witness be handed states exhibit 2 and states exhibit 3 as well.
Right. When you talk about manipulation, Chad was already manipulating by calling himself a prophet and
Further stipulate to states exhibit 2, stipulate to states exhibit 3.
Very well. Then presuming they're being offered states exhibits 2 and 3 are.
and I feel like for Lori it was a conquest.
And Mr. Wood, if they're going to be published, again, it's an issue we discussed before today's.
That's all I'm doing that. Thank you. Detective, can you look at states exhibit 1?
I agree, Jamie Lee.
What is states exhibit 1?
That is a birth certificate out of the state of Louisiana.
Your Honor, where this is related, may I publish?
Yeah.
Detective, can you identify who this is a birth certificate for?
The name on my birth certificate is Canaan Todd Trahan,
What is the birth date?
May 25th, 2012.
And where is the place of birth?
Lake Charles, Louisiana.
Your Honor, if I may publish states exhibit 2.
You know,
Detective, I'm going to ask you to turn to the second page of states exhibit 2. Detective, what is states exhibit 2?
It's a decree of adoption.
And reading through that, are you aware of who that is a decree of adoption for?
Yes,
Who is it for?
Canaan Todd Trahan.
And on the bottom of that, can you read the second to the bottom paragraph? That exhibit.
The entire paragraph.
Yes, please.
It is further ordered, the judge and decree that the name of the child, Canaan Todd Trahan, be changed as follows. Joshua Jackson Vallow, and the registrar of the Louisiana Department of Public Health and Statistics is hereby ordered to make the appropriate changes in its records.
May I publish states exhibit 3 now?
yes.
Detective, what is states exhibit 3?
That is also a birth certificate from the state of Louisiana.
And who is it a birth certificate for?
Hey, Harlot.
Joshua Jackson Vallow.
Detective, in the course of your investigation. In the course of your investigation, have you learned what Joshua Jackson or JJ Vallow looked like?
Yes,
Have you seen pictures of him?
yes, I have.
Were you able to access pictures of him from iCloud accounts associated with his mother?
Yes,
Your Honor, I ask that the witness be handed states exhibit 4.
I'm starting to think we aren't going to be able to see even
But
evidence
is
they
one
want
that
us
says
to
it
see.
was
Detective, you testified that you never met JJ Vallow, correct?
Correct.
How did you come to know what he looked like?
Through photographs we were given,
Where did you get those photographs?
we received a few from Gilbert Police. His grandmother, Kay Woodcock. I think that's all I can remember.
And I spoke with you briefly before. Did you ever have occasion to review iCloud accounts belonging to Lori Vallow?
Yes, we did.
And on those iCloud accounts, did you find other pictures of JJ Vallow?
Yes, we did.
And did you find videos of JJ Vallow?
Yes.
Based on your investigation, what does Exhibit 4 purport to be?
Photograph of JJ Vallow.
And you didn't take this picture, correct?
Correct.
But you recognize that individual as Joshua or JJ Vallow?
Yes.
Your Honor, for demonstrative purposes, the state would move to admit the state's Exhibit 4.
The objection. Judge, there's a little bit of foundation that I want to iron on. So, no, so what's the source of that picture? Where did-
Lori's iCloud, Lori for Style, iCloud.com.
Judge, can we approach just briefly on this issue?
One thing you can count on with Pryor is a lot of objections and a lot of speaking objections and a lot of, him whining about why he believes the objection is warranted. Yeah, and I've actually tried to expand, like zoom in using, on the screen. It's really it's futile. I'll even try to do it here. Look. Like there, I'm zeroed in on it. And you can still, I'm zeroed in on one frame there. On one view, and you really can't see anything. Yep. Time for those sidebar emojis. By the way, you may have noticed that one of
Based on our sidebar with counsel, I understand the defense does not have an objection at this point to Exhibit 4 being submitted. Is that correct, Mr. Pryor?
Yes, Your Honor.
All right, Exhibit 4 then is submitted.
Your Honor, may I publish to the jury?
Yeah.
Detective, who is that?
That's JJ Vallow.
Yes, he does, Harlot. I think it's sounding like it's getting to be an Idaho thing.
Detective, you were talking about receiving a request to do a welfare check, correct?
That's correct.
When did you receive that request?
On November 25th, 2019, late evening hours, I received a call from Detective Pillar with the Gilbert Police Department. And he requested that
Judge, I'm going to object at this point.
A request is a hearsay.
Okay, we need nicknames
At
for
this point,
Pryor
I
the
don't hear
objector.
an objection on hearsay, so you see.
Can I repeat the question?
I think he did.
What did you do in response to that request?
On November 25th, 2019, I received a call from Detective Pillar, at the Gilbert Police Department. He requested that I do a welfare check on JJ Vallow the next morning because he wasn't able to get a hold of JJ or
Obviously, stand as hearsay.
Did you do a welfare check for JJ Vallow?
we did.
What date did you do that?
November 26, 2019.
How did you go about doing that?
On that morning of November 26, 2019, myself and Detective Daybell went to Lori Vallow's residence where we presumed JJ was at. She lived at 565 Pioneer, apartment 175. As we approached, expecting to speak with Lori, we noticed the defendant, Chad Daybell, and Alex Cox unloading a pickup truck near the garage area.
And at this point, were you aware of who Chad Daybell was?
Yes,
How would you learn about him?
through our investigation with Gilbert and communicating with Gilbert Police Department.
And so you recognized who he was.
Correct.
And at that time, were you aware of who Alex Cox was?
Yes, we were.
So after you saw them, what did you do next?
I got out of my vehicle and made contact with Alex. He was standing at the driver's side of his pickup truck, and the defendant Daybell was on the passenger side. I asked Alex if Lori Vallow was home, and he stated that she wasn't home. I asked Alex if JJ was home, that we were there to do a welfare check. And at that point, Alex got a surprised, frightened look on his face, looked over at across the pickup at the defendant Daybell. The defendant Daybell then looked back at Alex. And initially, neither one of them answered my question.
After they didn't answer your question, what did you do?
I asked them again if JJ was home, and Alex Cox finally answered and stated that JJ was with his grandmother in Louisiana.
When you were given that information, did it cause you any concern?
It did, because I informed Alex that it was highly unlikely because his grandmother.
Judge, I'm gonna object at this point. We're gonna be getting into your soon.
Also stand that.
Your Honor, I think the defendant's about to testify what he said to Alex Cox.
Okay, that's not what I understood where it was going. You can ask the question, Mr. Wood.
Detective, what did you say to Alex Cox?
I informed Alex that it was unlikely because Kay.
Judge, I'm gonna object. This is going to lead into hearsay.
Your Honor, this is a statement by a declarant on the witness seat. It cannot be hearsay.
Overruled, and it is permissible, so objection overruled.
What did you say to Alex Cox?
I informed Alex that it was unlikely that JJ was with his grandmother Kay because she was the one who called in the welfare check.
And what was the response to that?
There was no response initially. Alex again looked over at the defendant Daybell, and they kind of both just looked at each other. And at that point, I asked Alex where I could find Lori Vallow.
And did he give you a location to find her?
He stated that she was in apartment 107, which is the same apartment complex, just a few apartments down.
What did you do at that point?
At that point, I asked Alex if there was a way I could contact Lori and asked Alex for her cell phone number. And Alex told me that he didn't have her cell phone number.
Were you aware at that point that Alex Cox and Lori Vallow were siblings?
Yes, through our investigation with Gilbert, we knew that Alex Cox and Lori Vallow were extremely close. So when Alex told me he didn't have his sister's cell phone number, I assumed he was lying to me.
What did you do once you received that information?
Myself and Detective Hope left the defendant Daybell and Alex at the pickup truck. We went over to apartment 107 to see if we can make contact with Lori. At that point, we were just trying to find JJ Vallow.
And were you able to locate him at apartment 107?
No, we knocked on apartment 107, there was no answer. So at that point, Detective Hope began knocking on neighbors' doors. See if we can get a hold of anybody who would know if they saw a little boy coming in and out of that apartment or who resided in that apartment. And while Detective Hope was doing that, I started walking back to my vehicle to call for more detectives to come over to our location.
Why did you call for more detectives?
Because of the deception from Alex. I wanted to figure out what exactly was going on. And we were going to start canvassing the area and knocking on doors, so the more detectives we had on scene, the better it was for us.
Detective, to clarify, when you first saw Alex and Chad Daybell, did you speak with Chad Daybell?
No, I personally didn't.
So I believe you testified that you started walking back to the original covenant.
Correct.
What happened then?
As I was approaching my car that was parked in the alleyway, I noticed the defendant Daybell driving towards me in a black Chevy Equinox. It appeared he had just left apartment 175 and was headed towards me in the alleyway. So at that point, I stopped him to have a conversation.
What did you ask him?
I asked the defendant Daybell, when's the last time you saw JJ Vallow? And he stated it was in October in apartment 107 with Lori Bell.
Did you ask him anything else?
I did. I asked him how he knew Lori, and he stated he had only met her a couple of times, and that he didn't know her very well.
Did that response cause any concern for you?
It did.
Why?
Through our investigation, prior to me making any contact with the defendant Daybell or Alex Cox, we knew that Alex, Chad, and Lori had been married 2 weeks prior to my conversation with them in the alley.
So is it fair to say you were troubled by his gentleman? What happened after that?
I asked Mr. Daybell, the defendant Daybell, if he had Lori Vallow's telephone number so I can get hold of her. And he stated he didn't have her phone number.
Did you have any further conversation?
I did. When I was speaking with the defendant Daybell, Detective Hope saw me talking with him and started to walk back to my location. As he approached, I again asked the defendant Daybell for Lori's number because I assumed he was lying to me based on what I knew. And at that time, he did give me Lori's phone number.
Did he tell you why he didn't give it to you in the first place?
He did. He stated that he felt I was accusing him of something.
And had you accused him of anything?
No, I simply asked him the whereabouts of JJ and asked him for his wife's telephone number.
Detective, during this interaction, were you wearing a body cam?
No, I wasn't.
Why not?
In the detective division, most of our interviews are in a controlled environment. We call people into the police department. We have an interview room set up with cameras. So most of the time we're conducting our business and our interviews at the police department. It's very rare we're the first officers or detectives on scene. There's one body cam between 7 detectives. Unlike patrol, where a patrolman is assigned body cam, a detective is not assigned body
What happened after you got that information from the defendant?
I called my lieutenant at the time and told him what was going on. I felt that based on the deception and lies from the defendant, Daybell, who is JJ's stepfather, the lies and the deception from JJ's uncle, who is Alex Cox. I felt there was more going on with the whereabouts of JJ. And so at that time, I wanted to get everybody over there to see if we could figure out what was going on. So I asked my lieutenant to gather some detectives and respond to my location.
And then what happened?
A few minutes later, my lieutenant arrived with Detective Dave Stubbs, who had a body cam at that point. We began knocking on doors. We went back to 175, which is Lori Vallow's apartment, and started knocking on her door and didn't get any answer.
And I apologize if I missed it. Who was your lieutenant?
Ron Ball.
All right, so after you weren't able to get any answers, what did you do next?
Through our investigation, we learned that Lori Vallow's niece, Melanie Boudreaux, it was Melanie Pulowski, no, correction, Melanie Boudreaux at the time, it's now Melanie Pulowski. She lived in apartment 174, which is right next door to Lori. So at that point, we knocked on her apartment as well to see if Lori or JJ was at that apartment.
Did anybody answer?
No, they didn't.
What did you do next?
I was instructed to go back to the police department, go to the prosecutor's office to see if we can obtain a search warrant to search the residence for JJ Vallow, while the other detectives stayed on scene and started knocking on doors in that complex. At that point, our only focus was to find JJ and to figure out what was going on. So we were going to exhaust every means that we could to see if we could do that. And that's why I went to the prosecutor's office to see if I could obtain a search warrant.
And did you obtain a warrant that day?
No.
Why not?
On the way to the prosecutor's office, Detective Hope, with the number that the defendant Daybell provided, called that number. There was no answer, but he left a message. Once we got to the prosecutor's office, Lori Vallow called back, and she was instructed to open the door. There were detectives outside of her door that wanted to speak with her.
And are you aware of if any detectives were able to make contact with her that day?
Yes, they did.
Do you know who that was?
Detective Stubbs and Detective Ball.
And you had mentioned earlier that Detective Stubbs had a body cam on, correct?
Correct.
And do you know if their interaction with Lori Vallow was recorded?
Yes, it was.
Have you watched that video?
Yes, I have.
At that point in your investigation, what did you do?
After
Detectives Ball and Stubbs had spoken with Lori Vallow, what did you do? What did you do next?
we were informed that JJ was with a family friend.
Judge, I'm going to object if there's any comments.
Sustain that.
Detective, did you speak with Detectives Ball and Stubbs about their interaction with Lori that day?
Yes,
Did you speak with them that day?
yes,
Did you watch the body cam of their interaction with Lori Vallow that day?
yes, I did.
So you're aware of what she said to them.
Correct.
Based on what she said to them, what did you do next in your investigation?
We attempted to locate the family friend to see if JJ was with her in Gilbert, Arizona.
And do you know who that family friend was?
Melanie Gibb,
Were you able to contact them?
I was not.
Did you have any interaction with Arizona law enforcement day about contacting Melanie Gibb?
I did. It was starting to get into the later hours of that evening. So I contacted Detective Pillar with Gilbert Police Department. And I had him go to Melanie Gibbs' residence to see if JJ was there. Ultimately, we learned he was not there.
Melanie
About what
Gibbs
time did you
died.
learn that JJ was not with Melanie Gibbs?
Roughly 9 o'clock at night.
And what did you do when you found out that he was not there?
I contacted Lieutenant Wall and let him know. And we agreed to meet at the prosecutor's office that next morning early to obtain search warrants for those apartments.
Okay, and just for clarity of the record, which apartments are you talking about?
Apartment 175, which belonged to Lori Vallow, 174, which belonged to Melanie Boudreaux, and apartment 107, because that's the last time JJ was seen based on the defendant Daybell's statements.
Detective, were you able to obtain those warrants?
Yes, we were.
What did you do? Well, what day did you obtain those warrants?
November 27th, 2019, in the early morning hours.
And on that day, did you execute those warrants?
We did.
Let's talk about that. Where did you search first?
We searched apartment 175 first.
Was there a reason you searched there first?
That was his address that we were given from Gilbert Police Department, and that's where his mother lived.
What did you find in apartment 175?
So initially, when we broke down the door, everything looked ordinary. There were couches, there were papers on the table, there was food in the refrigerator, food in the pantry. We went upstairs, there were beds, pictures. Everything seemed that people lived there. The thing that caught our attention was there were no clothes on the hanger in any of the closets. Zero clothes. Just a bunch of empty hangers hanging there like somebody took the clothes off and left.
Did you locate JJ in that apartment?
No.
Did you see any evidence whatsoever to suggest that he had been living there?
Yes, we did. There were a couple things. We located a child's Star Wars suitcase underneath a little crawl space under the stairs. It was mixed in with some, what I can best describe as 72-hour kits, and the kits had like flashlights, flares, water. The suitcase was mixed in with those. We also found an old prescription bottle prescribed to JJ of Risperidone. And there were miscellaneous photographs of JJ in the residence.
And did you see any other evidence of any minor children?
No. Crash. We did. When we first went inside, there were some scooters and a small child's, looked like a small child's bike right on the porch.
Okay. Did you seize anything from the home that day?
We did, I seized the Risperidone and the suitcase.
After you searched apartment 175, what did you do next?
We searched 174, which was Melanie Boudreaux's apartment. Everything appeared normal in there. There were no signs of JJ or anything that he was even there. We also searched apartment 107, and that was completely vacant. There was nothing in apartment 107.
Did you seize anything from apartments 174 or 107?
We seized, in apartment 174, we seized some cash, large amounts of cash that were found in the closet. And the only reason we seized those were for safekeeping, because we had kicked the door in there as well. And it wasn't able to lock, so we took that.
Did you locate any weapons in any of those apartments?
So in apartment 175, when we were searching the garage area, we located several different style weapons, handguns, rifles, various calibers, army knives, a lot of different weapons that were inside the garage.
And why did you seize those?
Again, for safekeeping, that apartment didn't lock. And so we took those, so it wouldn't be stolen.
Did you find any evidence that J.J. Vallow had been in apartment 174?
No,
Did you find any evidence that J.J. Vallow had been in apartment 107? Did you search any other building that day?
we did. In apartment 175, we located a storage unit rental agreement contract. And on that storage unit contract was the name Lori Ryan. It had listed her as the tenant, and it listed the storage unit number as T52. And it gave an address of self-storage on Airport Road in Rexburg. So with that information, we were able to obtain a search warrant for that storage unit as well.
And did you participate in the search of that storage unit?
Yes,
What did you find there?
there were a few bikes, children's bikes. There were boxes of winter clothing, some ice skates. There wasn't a lot in the storage unit. There was a personalized like a family blanket, a big blanket with family photos that were kind of sewn onto the blanket. Those photos had J.J. Vallow, Tylee Ryan, and their sibling Kobe Ryan. There were pictures of Lori Vallow. But other than that, there was nothing else really in the storage unit.
When you performed these searches, were you looking for Tylee Ryan?
No,
So to your knowledge, she hadn't been reported missing.
that's correct.
Your Honor, if I could have a brief sidebar.
Yes.
Sidebar time, sidebar time. In case you're just joining us, we do have special emojis for court, including a special new John Pryor emoji, because he says this a lot. A lot. So you can expect to use that a lot. And for those of you who have never seen it, this is the apartment building in Rexburg. This is the apartment where Jay.
So what I understand, this is a good breaking point in his testimony for the lunch hours, is that correct?
Yes, Your Honor.
Okay, we're gonna go ahead and take our lunch recess at this time. Before we do that, again, I will just advise the jurors, please don't discuss the case amongst yourselves or with anyone else over the break. In addition, for those in the courtroom, we will be closing the courtroom, I believe, during the lunch break. So things you have in here will need to go with you. We'll reopen upon the conclusion of the lunch break, and we'll still be under the court's governing order for courtroom conduct when we return. So thank you everyone for complying with that. With that in mind, we'll go ahead and take our lunch recess now.
All rise.
Janice, he is a retained attorney. In fact, hold on a moment. Excuse me, I had to sneeze and I am a loud sneezer, so I had to mute myself. All right, so we're going to mute this at the moment. He is not a appointed public defender. He is someone hired, and my understanding is that Mr. Pryor now owns Chad Daybell's property, and that was one of the ways that Daybell paid him. He tried to get himself out of the case late last year or mid last year. Claiming hardship, basically saying that he couldn't possibly do this all on his own, and that Mr. Daybell was running out of funds, and he wants to get paid for his work and things like that. So that's what he claims. Anyway, so just to recap the morning, we had the opening statements from both parties, and they have started off the trial with Detective Hermosillo, who was, my understanding is he's the lead detective on the case. He responded in Rexburg, Idaho, to the wellness check, looking for JJ, then obtained the search warrants, looking for JJ. And he just said on the stand that he wasn't even looking for Tylee. He didn't know that Tylee was a missing person at this point. But just as a reminder, he was called out in November of 2019, and the kids had not been seen since September of 2019. So anyway, we were talking earlier about the Apple River trial, the Wisconsin River stabbings trial, and it is currently in verdict watch. There were closing arguments earlier today, and I personally want to watch these closing arguments, so we're going to watch together as we sit out this lunch hour for the Chad Daybell case. So for those of you who aren't aware, there's another trial that's been going on. It's really fascinating. It's a self-defense trial. It's a man who stabbed 5 people in a river, but he claims self-defense. We've talked about it extensively earlier, but now I just want to go ahead and show the closing arguments, because they're probably at least an hour long, and that's how long this break is going to take. But real quickly, that it was a fairly uneventful morning. The opening statements here were fairly non-dramatic, pretty straightforward. And Pryor, the defense attorney, made it pretty clear he's going to be basically shoving other people under the bus. To the extent he shoves Lori versus Alex, her brother, under the bus is unclear. It's a little easier to pick on the dead guy, who's not around anymore, and that's Alex Cox. So anyway, here are closing arguments in the Wisconsin River stabbings trial.
Acts of violence. Absolutely senseless and horrific acts of violence. And all Nick Lyman had to do was walk away. All he had to do was walk away. That's what you've seen in this case. You saw he told Lieutenant Hart, "They told me I can't run away." Obviously not true. Think about the result of his actions. Everything you've seen in this trial, the horrific injuries, the death of Isaac. Why didn't he just walk away? His only explanation when testifying was, "I stood my ground. I stood my ground." First of all, Wisconsin is not a stand your ground state.
Objection. Overruled.
I'll talk about that specifically from your jury instructions. Second, that's not true, as I'll show you. He didn't just stand his ground. I'm not going to defend the actions of the board.
Just a real quick aside here. This judge, I really like this judge. He is extremely decisive and straightforward, and he doesn't allow shit to go down in his courtroom. My only criticism of the judge is I feel like he should wear a bow tie rather than a regular tie, because he has the bow tie kind of look and he puts out the bow tie kind of vibe, but that's okay. That's a style choice. Anyway, you might recognize this prosecutor. He's been prominent in several Wisconsin trials that we've watched.
Boys who testified. It was cruel what they're calling Nikolai. They shouldn't have been mocking him, calling him predator, raper. But their conduct did not justify what Nikolai did. You heard from Alina, Isaac's mother, about her son Isaac. He was 17 years old when he was killed. He enjoyed golfing, spending time with friends, recently started a new business, detailing cars. He was an honor student looking forward to going to college. His death was senseless. One of the things defense said in the beginning of trial in their opening was they're glad there's a video. So are we. Without the video, Nikolai would have slipped away. The only reason he was apprehended was because law enforcement had that screenshot of him. The video doesn't fade with time. It's not biased, not influenced by alcohol. As I told you in the beginning of this case, the violent episode from the video is about 25 seconds, from the point he punches Madison until you see him walking off after stabbing 5 people. He's not seen, Nikolai is not seen in that video for 8 to 9 seconds until the point you see him walking away. You don't see him stab Dante. Some of you may have wondered why we called Marion Davis. Certainly it wasn't for his eyewitness testimony, but he took a video. He took a video that captured a different angle than Juwan's video. It's grainy, it's difficult to see, but you can see enough. And it shows Nikolai seeking Dante out and stabbing him when his group is in the opposite direction. Nikolai walks into a crowd of people, stabs Dante. Before I show you that video again, I need to provide some context from Juwan's video. Take it off. Clear the screen, please. So here at 2 minutes and 6 seconds, this is after Nikolai.
So Harlot's asking, he acted like he had the knife blade up just by chance, didn't he? You know, I don't know. I don't remember any specific testimony about why the knife blade was up, but they show throughout the video that as he's walking through the water, he's constantly checking for his knife. And then eventually he pulls out his knife and he wields it, and he threatens them with it and wields it. But not very, it wasn't very long before he took it out and just started stabbing people. This is a really, really tough case. It's going to all end on, it's all going to be decided on the technical legalities of, was this a justified reaction to what the kids were doing? And unfortunately, it was such a melee that it's kind of hard to see what happened first. But the kids claim that Mew, the defendant, struck a woman first, and that was why they started hitting him, and then he started stabbing people. That's what they claim.
I stabbed the 4 people that you do see parts of on the video. He's standing next to Ariel. Ariel's there. Nikolai's not by himself.
I think what has been established throughout this trial is that the defendant has lied multiple times about the incident and his involvement, and he's been impeached with his lies many times because at first he didn't realize that this was all recorded. So he started making up stories about how all the kids were pulling out knives on him and things like that. Why did he ditch the knife? When the police picked him up, why did he pretend he didn't know there was even a fight? I mean, all of that to me, like if it was just an innocent, I just defended myself type of thing, he wouldn't have had to run away. He wouldn't have run away, ditched the knife and pretended nothing ever happened. Right? Let me see. Let's check out how this goes on the speed.
Two minutes, 8 seconds. That's the last you'll see of Nikolai until you see him walking off in this video. You see Dante or AJ, the boys running back to their tubes. And you see Larian filming in the background.
I agree.
Larian captured
Oh,
one
look
of
at this man's
the
knee. Oh, he is on edge.
And here, in a moment, you can see the edge of Dante's swim trunks on the right. You can see the light on top, the dark on bottom. At this point in Larian's video, Dante's just been stabbed. Next, you see of Nikolai, he's walking off. You can see Dante in the background, holding his stomach, looking down at his knee. Well, actually, you can go for a second, sorry. And then for further context, you see Alex Vang running to Isaac. Let's see Larian's video. Okay, that was me. Remember, Nikolai admitted he walked up to Larian. He walked up to Dante and stabbed him. He admitted Dante was the last person he stabbed. Here you can see Nikolai, dark swim trunks, bigger build. On the right, you can see Dante, swim trunks, lighter on top, darker on bottom. You'll see Nikolai walk up to Dante and stab him in the chest. You'll see Dante recoil from the stab. You see the boys on the right running to their tubes. And in the second here, you'll see Alex Vang. You'll zoom in on him as he runs to Isaac. I'm going to show that again. So,
Look at
a few things to know. There's nothing between Nikolai and Larian. He's not surrounded. His friend Ariel is there at this point. There's nothing to the left and behind Nikolai, except his group in the distance that you can't see on video.
Look at
He
their
walks
faces.
away from those directions towards a group of people and stabs Dante in the chest, not standing his ground. He's seeking out Dante. That's retribution, not self-defense.
I want to give all.
Recall too the DNA results. Isaac's DNA and Dante's DNA was the only DNA on the knife. They're also the last two that are stabbed. Makes sense from how the analyst described DNA and how it can wash off. You probably noticed throughout this trial, not a lot of witnesses come off with brains after they testify. There's some exceptions. Obviously, the Good Samaritans who went to aid Isaac and AJ. Eric Von Williams included in that from Nikolai's group. He's the only one who went to their aid. Sheena Lowell, you heard her testify from the Carlson group. You saw her just standing in the background watching what's going on the whole time. She was completely sober. You heard her testify, Nikolai punched Madison. She has zero connection with the group anymore, zero contact. Her acquaintance broke up. Tony is another one. He only comes in to break up what he thinks is a fist fight. He's directing Nikolai towards Nikolai's group. Nikolai turns and stabs him twice. Another one I submit to you is an exception that acted admirably is Isaac. His death was tragic and horrific. This is what you see of Isaac in the video. On the left, he's standing next to his tube, not moving away from his tube. He's pointing at Nikolai to leave. In the middle, when Nikolai turns back to Isaac, Isaac puts his hands up, fingers played. The only other thing you see of Isaac
I agree.
is him standing in the background. When the other boys are mocking calling names to Nikolai. Isaac is just standing in the background. He's not saying anything. He's not doing anything. He's not jeering. He's just standing there holding their tubes. There's been a pretty serious mischaracterization of Isaac's actions with regard to when he gets stabbed. Defense has tried to classify it as a strangulation. Defense accused the state in openings of being selective in the photos we use, the frames, to try to show a certain narrative about Nikolai smiling. As you've seen, he's smiling a lot in the video. But defense is actually doing that when it comes to Isaac. Nikolai never said anything about being choked, never said anything about pain on his neck, even when specifically asked by the start nurse, never mentions anything. And the video doesn't lie. So on the left, Nikolai has just stabbed Riley, who you heard from multiple witnesses who are just standing there. Tony comes to try to break it up. Nikolai stabs him twice. Isaac, just off frame, I submit to you, he just saw Nikolai stab those two people completely unprovoked. Although he was in the background the whole time, not doing anything, he came to their aid. And he pushes Nikolai. You can clearly see it's a push. He has one hand on the arm, other hand on the chest. It's Nikolai's own action of thrusting the knife into Isaac's heart that moves Isaac's hands. You can even see from the release, it's a push. He's not sitting there left holding his hands out in choking motion. Let me take this screen down. Yes. I'm going to show you the video so you can see it's obviously a push.
Yeah, during this trial, the defendant tried to claim that the kid who died was choking him based on a still frame where his
While my
hands
computer
were
is loading here, even if it was a strangulation, which it clearly isn't, Isaac was justified in using any level of force. He just saw Nikolai stab two people who posed no threat to Nikolai. Tony was breaking up the fight. He had actually ignored Nikolai at first, walked past him, pushed Dante out of the way. Riley was just standing there. Met 2 minutes and 3 seconds. Can we have the screen?
I agree. I don't think I could. I would try to disqualify
Clearly a
myself
push.
from this jury if I could. Oh God. I'm glad they stopped right where they did because they were just.
Defense has mischaracterized the entire situation as 13-on-1, 13-on-1, implying it's some sort of mob beating up Nikolai. It's not even 13 people yelling at Nikolai. As you saw in the video, Gabby, Janelle, they're just standing in the background. Isaac, he's just standing in the background, not yelling anything. It's 13 people in the proximity, only 2 close to him, 2 tiny females. Nikolai's clearly not afraid of the boys. He ran up on the boys, turns his back on them and others multiple times. Even at worst, this is a 2-on-1 with AJ and Dante. But even then, as you saw in the video, Ariel's right there. It's more like a 2-on-2. Ariel's right there. Plus, Tony comes in as a neutral party to separate things. It's not 13-on-1. As soon as AJ gets disemboweled, you see people start to move away. So there's not even 13 people immediately around. You saw Owen way in the background because he saw the knife. So why try to mischaracterize the situation? Because there's some things that are hard to explain otherwise for defense. Turn on the screen, please. This is the second time you saw in the video that Nikolai turns his back on boys and people from the Carlson group. You don't turn your back on somebody. It's common sense. You don't check your common sense at the door when you serve as a jury. Don't turn your back on somebody if you're afraid of them, especially if you're so afraid you got to reach for your knife. You can't be that afraid that he's got to reach for his knife and so unafraid that he turns his back on them. He was angry, not afraid. That image on the right is only less than 30 seconds after he turns his back on them.
And you can see the anger on his face. He switched.
The defense tried to
Anger,
explain
happiness.
that change from in that 30-second window by saying he was getting pushed by Madison and Riley. He's getting pushed. They're lightly touching his arms and they're tiny. They're not in his face. You can see in the images, they're standing close. They're not in his face. They're not shaking their fists at him. They're not even sticking their fingers in his face. They're standing close to him, touching his shoulders, pointing, yelling at him to leave. I'm going to back up a little bit and talk about Nikolai looking for the phone. So Eric Von Williams from Nikolai's group, you heard testify, before any of this happened, he was concerned about Nikolai's behavior. He was concerned that people were going to think he was a predator. Ernesto told Nikolai not to go look for the phone. Others in the group told him not to. You heard they didn't care about the phone. Ariel didn't care about the phone. Nikolai went. Sandy said he went twice, was back for 5 to 10 minutes, then went again over by the boys. Defense argued in opening that the boys' their goal was to humiliate Nikolai. Clearly, he wasn't looking for little girls. But the boys are not completely unreasonable in their beliefs. Eric Von Williams thought the same thing. They reacted wrong, but they just didn't invent this whole thing in order to humiliate Nikolai. What about Nikolai, 52 years old, apparently sober, according to, I think, what defense will argue. He didn't have any signs of intoxication when law enforcement made contact with him, but he certainly made a point of telling Lieutenant Hart multiple times how much he was losing, drinking on the river. He can't let it go that he was insulted. So much so that as the boys are trooping away from him, all Nikolai has to do is stand there. He doesn't even have to take a step back. He just has to stand there, let the boys continue tubing. They're down in their tubes. He starts walking up to them, touches his knife, and then runs up to them. You heard Nikolai's ridiculous description or explanation for why he ran up on the boys. Because one was holding a phone, he thought it was Ariel's phone. You also heard Nikolai had to concede, had to admit that pretty much everyone on the river had those phone cases. Another double standard from defense is physical attributes of those involved. They wanted to elicit evidence that Nikolai is feeble. Sandy, he wasn't feeble according to Sandy. He had a surgery a couple years ago, recovered in a few weeks. Maybe things took him a little longer than they did before. He wasn't feeble according to Ernesto. You heard Ernesto, when he was being asked about the stabbing, said, he's a big guy, he was in the army, he doesn't need a knife to defend himself. He didn't say, oh, he's this fragile old guy. He's clearly not feeble, as you see in the video. He runs up on these boys in the water. He leaves behind.
One interesting thing I want to point out is that his Nikolai's wife was a state's witness. She is now his former wife, but she was his wife at the time that this happened, and it was in 2020. So I'm curious about what happened and whether she left him because of this or how much this played into them breaking up. Yeah, I don't know who left who, but she was a state's witness. She didn't dish on Nikolai. She didn't go out of her way to make him look bad, but she was their witness.
Kind of devastating injuries. Slices clean through 2 of Isaac's ribs. He comes out of the whole event essentially uninjured. While defense tries to argue that Nikolai is this feeble old man, they ignore that the only 2 people actually standing close to Nikolai are these 2 females that are barely over 100 pounds. If the boys are a threat, why does Nikolai run up on them? And clearly he knows they're not a threat to him. When he ran up on them, grabbed their tubes, standing over them, they did nothing. They didn't kick up at him, they didn't punch at him, they jumped out of the tubes and moved away from him. He knows they're not a threat to him. They're mocking, saying cruel things, but not violent. You saw how awkward it was for Nikolai to try to explain this transition from 0 fear to 10 out of 10 fear. He's got to take out his knife. Tried to explain it with what I submit to you is obviously rehearsed testimony about his scales of fear. You heard from witnesses recounting what they recall of Nikolai, the demonic look on his face, staring through people, smirking. Defense argued in opening, it's a slide 2 or here there. You know, after seeing the video so many times, that's not the case. When he's not glaring, he's smirking in the video. Recall, I asked Ernesto, his best friend, when he was trying to describe the shock of Nikolai, asked, was he smiling? He didn't say, yeah, he smiles when he's scared. He smiles when he's nervous. He said, Who's gonna smile in a situation where they're in shock or in fear? Nikolai was angry, he wasn't afraid. He's smirking even as he's holding the knife. Why didn't he just walk away? The defense tried to argue there's rocks in the stable, his sandals were bad, didn't stop him from running up to the boys as they're shooting away from him. Why didn't he just hold the knife up? Say, hey, I got a knife, back up. You saw, Owen is the only person who saw the knife and you saw his reaction. So everyone else is moving forward and responding to Nikolai punching Madison. Owen's trying to pull people back. Next you see him, he's off in the distance. This whole thing would have ended if Nikolai just held up the knife. Instead of opening it down by his waist without looking down, because it's human nature, if you were to look down, people would have looked down. He holds it down by his waist, opens it up, never displays it, or says he has a knife. Nikolai did not act as any reasonable person would in that situation if they were truly in fear of their life or great bodily harm. So let's talk. Here's Owen reacting, as you see. Again, Isaac just standing in the background in the middle. You see when other people are moving forward, Owen's trying to pull them back. You heard him yell, bro, he's got a knife. So let's talk about the punch to Madison. I submit to you the evidence shows clearly, beyond a reasonable doubt, Nikolai punched her. She fell backwards, but caught herself. Multiple witnesses testified to seeing her falling backwards. Defense is saying, arguing on cross, well, she's not wet, she didn't actually fall down. If witnesses are all standing in that kind of semicircle around Nikolai, she gets punched and falls backwards, and then their attention's back to Nikolai as Dante's hitting him. They're not going to see that she caught herself. They're going to think she fell down. Look at her position next to Riley. Her shoulder to shoulder in front of Nikolai before the camera pans away. When the camera pans back, now Dante's shoulder to shoulder with Riley, and Maddie is back. She clearly got knocked backwards. Her sunglasses aren't on her head anymore. Defense has a double standard about that too. If there's not a photo of it, it didn't happen. If there's not a photo of an injury, it didn't happen. We know Nikolai got punched. He didn't have any injury. Defense can't have it both ways. So turn and talk a little bit about memory, credibility. Obviously, a witness's memory is better closer to the event. That's obvious. Alcohol is going to affect memory. Traumatic events going to affect memory. How fast it happens is going to affect memory. But crucially, and absolutely crucially, there's a huge difference between getting some details wrong, right hand, left hand, sequence of events, and making up an entire story like Nikolai did.
Hello, Rando and KK's Way.
Defense has tried to highlight throughout the trial, Nikolai was in this traumatic experience, give him a break. It's understandable, he made up all these lies, told this whole story. Even though he looks calm and collected in the videos, he's convincing in the videos, talking to the sheriff, talking to Lieutenant Hart. But don't give any sort of credence to the theory that trauma affects memory for anyone in the Carlson's group, any of the boys, any who were stabbed, any who had to drag Isaac as he's bleeding to death to the shore. AJ was disemboweled. Don't give any credence that trauma might affect their memory and how accurately they can remember all the details. But Nikolai, who invented an entire story, tried to skip through the crowd. Give him credence for that. You saw what happened to all these witnesses, how fast it happened. It's not surprising, some of the details are wrong. But the major point is accurate, is consistent. This all started when Nikolai punched Madison, whether it's the right hand or left hand. You heard the turmoil of the boys when they realized Isaac was stabbed. Clearly a traumatic experience. There's a big difference between details and invention. Think about the most basic example. You and say your partner go to the grocery store, park your car, leaving the grocery store. You think your car's parked over there, they think it's parked over here. You still know the car's parked in the parking lot, even if you can't remember where it's parked. Same is true for the punch to Madison. You heard from 10 people, both from the Carlson group and the boys group, that Nikolai struck Madison. So let's talk a little bit about witnesses from Nikolai's group. Ariel, what did he say? At trial, he says Nick defended himself. Can't really say how. Never said that when interviewed with law enforcement. He denied even being close to Nikolai. Remember, Ariel was there when he stabbed Dante. He was right there when Nikolai stabbed Riley, Tony, and Isaac. Law enforcement went there with the frame of Ariel standing next to Nikolai when Nikolai has the bloody knife. Ariel denies seeing anything to law enforcement of what Nikolai did. Ernesto, at trial, testified he didn't see Nikolai get hit, just saw him down in the water. Said he couldn't remember Nikolai saying, "They took my knife." You saw on the body cam, he said that repeatedly. He testified that somebody was walking towards him, he pointed at him, "Get back." Never said that to law enforcement, although he did describe to law enforcement, as you saw, him saying, "Nikolai, get out," Nikolai walking out, and then he said, and that's it. Never said anything about anyone pointing at him and walking towards him. When I asked, he said, I wasn't asked that question. But he described that event. He also wasn't asked more than 10 times if Nikolai said they took my knife. So, about the punch to Madison again. Sergio, he's in Nikolai's group. He had walked out a little ways. You can see him in the photo on the left, in the top right. He had the white shirt, white bucket hat. He testified he saw the blonde girl in the black leotard walk over to Nikolai and say, "Go, go, go." He said it repeatedly to law enforcement. And he said Nikolai pushed her. So this is what it would have looked like from his perspective, although a lot farther back in that photo on the right. How could he have seen Nikolai do anything to Madison unless she got pushed back, punched back, something violent, not some light push? He's not going to see that from where he was. Madison testified, and you saw in the video, after she was hit, she goes back to her group. Why would she walk away back to her group if Nikolai just lightly maybe touched her, maybe didn't? She told Quentin she was punched. She told police at the scene she was punched. She told police in the interview she was punched. She testified about feeling the throbbing pain in her cheek, her heartbeat in her cheek. Tammy testified she was told by law enforcement, sheriff's office, they didn't need the photo. You heard about that misunderstanding. She had anxiety about deleting the photo. In an effort to console her, she was told, "Don't worry about it." This is an important jury instruction in your jury instructions. Although we're not a stand your ground state, there's also not a duty to retreat. But in determining whether Nikolai's actions, whether his use of force was reasonable to prevent or terminate the interference, you may consider whether he had the opportunity to retreat with safety, whether such retreat was feasible, whether he knew of the opportunity. He turned his back on them multiple times facing open water. People were yelling at him to leave, to walk away, to go. And he didn't. Instead, he took out his knife. That is not reasonable. You heard from Sheena Lowell, Janelle Duxbury, Ghazi Khazri and Nazimpour, Dante Carlson, and AJ about the strike to Madison. You heard from the boys, Ryan Nelson, Juan Cockfield, Landon Wire, and Alex Bang. Alex Bang originally described it as slap. You heard from Owen that he heard an impact and saw Madison fall back and catch herself. Defense has to argue that they're all either lying or mistaken. All these witnesses, including Sergio. If they're lying, why would Quentin say, "I saw some swelling and some slight redness, but didn't see the punch"? Why wouldn't he just say, "Yeah, I saw the punch too"? Why wouldn't Tony say he saw the punch? Why wouldn't Tony say he saw Riley get stabbed and she's just standing there? They tried to explain what happened as best they could remember. The punch isn't on video, but you see the reaction. You hear Dante yell, "You can't hit a woman before Riley is stabbed." They obviously didn't plan this lie in the chaos of the moment. So the only thing defense can argue is they're mistaken. That all these people standing around Nikolai in that half circle, proximate shape, they're all looking in that direction, including Sergio, including Sheena, who was by the group, the tubes for the Carlson group. They all were wrong in what they saw. Another defense double standard, it's relatively minor, but I submit to you it shows that they're grasping at straws, is this trying to put Nikolai's group in a different category. There's drunks on the Apple River, then there's Nikolai's group. About half of you raise your hand that you've been on the Apple River. That's what people do on the Apple River. They go up, they tube, and they drink. Nikolai's in the exact same boat they were in. He wasn't bird watching in this group of drunk teenagers ran up on him. He knew what it's about. He'd been on the river before. Another thing about the punch to Madison. You heard that they didn't get to see the video before giving their statements. Even Jawan, who took the video, said he got far enough to get the screenshot of Nikolai, and then law enforcement took his phone. He didn't get to see the video. You saw what happens in this case if somebody lies about something that happened on video, because Nikolai got burned by that. He made up complete and total lies. Video showed he wasn't telling the truth. The video happens to not show the punch, but it still corroborates what all those witnesses said.
That's what bothers me. If it's all so innocent, why lie? Why immediately lie? He just needed to tell
So,
straightforward
Count 6 is battery to Madison.
self-defense story.
It has 4 elements. Nikolai caused the battery to Maddie, caused the injury, the harm, the pain. She testified to that. He intended to cause the harm despite his denial. I submit to you that's clear. Don't punch somebody without intending to cause harm. She didn't consent. She testified to that. He knew she didn't consent. She's a stranger. Obviously, she didn't consent. Punching Madison was not self-defense. Again, there's no duty to retreat, but you have to consider the opportunity to retreat, the knowledge of the opportunity to retreat, and whether the use of force was necessary in preventing the unlawful or the interference in Nikolai's person. So what is the interference at the time he punches Madison? The boys are saying cruel things to him. Manny and Riley are standing in front of him, lightly touching his shoulders. People are pointing and laughing at the boys. They're not, Manny and Riley aren't in his face. They're standing close, but they're not in his face. What amount of force was necessary to prevent that interference? People yelling at him, Manny and Riley standing close. What amount of force was necessary? Absolutely zero. Just walk away. That's what people are yelling at him to do. Just walk away. Instead, he takes out his knife and punches Madison. Regardless of whether you were convinced beyond reasonable doubt it was a punch, Nikolai Ascension admitted to pushing her. Sergio said it was a push, although when asked, he couldn't remember if it was a push or a punch. There's still provocation. The jury instructions talk about provocation and how that affects self-defense. A person may not use or threaten force intended or likely to cause death unless he or she reasonably believes he or she has exhausted every other reasonable means to escape or otherwise avoid death or great bodily harm. Remember, Nikolai ran up on these boys who were tubing away. They didn't run up on him. He ran up on them as they're tubing away from him because they insulted him. He was angry. He didn't walk away from the boys to leave the situation. He went over to Maddie, who was yelling at him to leave, and he lies to her and says, "They took my snorkel." I'm going to play that for you so you can hear. All right, this is at 105 in the video. I'm ready.
Doesn't matter.
You can take it down. He didn't go over there to extricate himself from the situation. He went over there and accused the boys of taking the snorkel, which was a lie. And he had just ran up on the boys. So after he runs up on the boys as they're tubing away, he goes and tells Maddie they took my snorkel. He's standing there smirking at people, takes out his knife, either punches or pushes Maddie. That's provocation. Defense has zero reasonable argument, especially when it comes to Tony, Riley, Isaac, and Dante. Nikolai gets punched. He gets struck with an open hand twice. He gets ineffectually pushed by AJ. It doesn't do anything. Nikolai pops right up and disembowels AJ. After Nikolai goes down in the water, nobody approaches him. Nobody. Nobody goes to kick him. Nobody goes to punch him. Nobody goes to push him again. Tony, with Nikolai down on the ground, Tony walks by Nikolai with his back to Nikolai, yelling, "Get back to Dante." He turns around to tell Nikolai to get away, and Nikolai turns around and stabs him. Nikolai was facing his group with an open path of escape after provoking a reaction. He just stabbed Riley before stabbing Tony. After stabbing those two, he stabs Isaac. After that, after Ariel's there, he walks over to Dante, stabs Dante in the chest, right below his ribs, right below his heart. So self-defense. I submit to you, the state has proven beyond a reasonable doubt this was not justified self-defense, and Nikolai knew it. He knew it from the moment he did it. First of all, imminent threat of death or great bodily harm. He's not in an alley with no way out, with people blocking his exit. He's on an open river, 150 feet wide, people yelling at him to get away. None of them are armed. Punch, 2 open hand strikes, ineffectual push. Look at look at the definition of great bodily harm, whether he reasonably believes death or great bodily harm is imminent. For attempted first-degree homicide for Dante, AJ, Tony, and Riley, the state has to prove that he intended to kill each of them. And the acts demonstrate unequivocally, under all circumstances, that he had formed the intent and would have caused the death of each of them, except for the intervention of some other person and an extraneous factor. Third, the defendant not actually believe that the force used was necessary to prevent death, the death of great bodily harm. So for the intent to kill, but for outside circumstances. AJ is beyond clear. He would have died but for the blood in the helicopter. He would have died, but not for the surgery Dr. Meyer performed. He is lucky, extremely lucky to be alive. What else was Nikolai's intent but to kill him when he slices him up like that? He had the knife blade up. That wasn't an accident. He did not know. The first thing he does with it is slice up AJ's stomach. Riley, he slashes across the ribs. You saw the horrific nature of those wounds. He cut into her stomach, cut into her diaphragm. Luckily, he didn't hit any major arteries or her heart or lung. Tony blocked one stab, so Nikolai stabbed him again. When he blocked, he saw the injury. It was very close to where AJ's artery was severed. Dante was stabbed again, just below his heart. But for Nikolai missing vital organs, but for medical intervention. You claimed he had tunnel vision. Oh, sorry, back up. So Dr. Meyer also testified, you heard about anytime there's a puncture wound in the torso, stomach, they have to go in because there's so many major veins, arteries, organs, they have to go in to make sure something major isn't done. Nikolai killed Isaac, almost killed AJ. Riley needed emergency surgery. Luckily, but for dumb luck, he missed the vital organs of Dante. But for AJ blocking one strike, missing vital organs, he survived. Nikolai said he had tunnel vision. I thought everyone close to me was attacking me. I thought anyone touched me was attacking me. He didn't stab Ariel, and Ariel came up. Makes the tunnel vision claim a little bit unconvincing. For first-degree intentional homicide, Isaac Schumann, Nikolai stabbed him so hard, he cut clean through 2 ribs. The wound was deeper than it was wide. He sliced Isaac's heart. There's no other intent when you stab somebody directly in the heart than to kill. An intent to kill doesn't need to be planned ahead of time. Your jury instructions talk about that. It doesn't have to be formed a week, a month, a day, even a minute in advance. As long as he had that intent when he does the act, that's intentional homicide. The first element is he caused Isaac's death. That's obvious. Acted with intent to kill. I've addressed that. Did not actually believe the force was necessary to prevent imminent death or great bodily harm. I'm going to get to that in a little bit for all of us. Third element, he did not reasonably believe the force was necessary. That also goes to, I'm sorry, that's part of the third element. So how do we know, what Nikolai believed, what a reasonable person would believe? That there's only one person on the planet who experienced what Nikolai experienced, saw what he saw, was standing in his place. And what did Nikolai believe? He believed it was unjustified. The very first thing he does is walk away, doesn't run, doesn't tell Ariel or Nestle anything, doesn't tell them to run. He walks away from his group to the other side of the river, at some point rinses the knife because it wasn't covered in blood, throws the knife on the bank before walking back to his group, says nothing to his group other than they took my knife, puts on his hat, sunglasses, and shirt, and sits down in his seat. He's the one, as he said in his interview, says, let's go, let's get out of here. They can't right away because Eric isn't there. You saw, and as they're tubing down the river, you saw the video of him casually paddling along. You saw So plan one, get away. Slink away with the crowd. That didn't work. Plan two, play down. Can you take the screen down, please?
It's really infuriating to watch him play dumb in the police video, knowing all the things that had just happened. And, you know, I really honestly believe that.
Camera recording started.
Still doing all right? Okay.
What's going on?
Temperature? Okay.
Somebody, I hear somebody got stabbed,
Um,
and I fit the description.
yes, you do.
All right.
Yep. So we're working through that now. Did you see that fight on the river?
I heard about it.
You heard about it.
Yeah, and I seen people gather around,
Oh, I've
Okay.
heard about it.
All right.
and I went over to talk to see if somebody saw anything, but that's about it.
Okay.
Our whole group was pretty interested in finding out what happened.
Okay. And that's your whole group over there?
Yeah,
Okay. All right.
So I don't know. Okay, well,
Did you see anybody injured?
no,
You didn't see anybody injured?
No.
Did you see anybody
Oh,
fighting?
no, not at all.
I heard people screaming at each other.
No, no,
Okay.
no.
Screaming in anger or screaming in pain? Do you know?
Everybody's drunk, so I don't know. I can't tell the difference, but I would say I don't know, screaming.
Okay.
Calling each other.
Yeah, 'cause
names.
you stabbed him.
It's seen that all day. And we've all been drinking a lot. I'm sure they're drunk. I'm sure they're drinking. Kids being kids.
Kids being kids. Where are you? Where's your group from? Where did you drive from today?
Sure they're drunk. Kids being kids. Sexual chair needs it. He's acting like he has no idea what's going on. Clearly not in shock. Can you take it down, son? Clearly not in shock. Clearly Nikolai knows that was not justified and he's looking out for Nikolai. Slinking away didn't work. Plain dumb didn't work. He's told he's under arrest for homicide. Plan 3. Completely lie about what happened as to justify him using lethal force. The boys pulled out the knives. They twisted their arm, poked him. That's what he was poked with their own knife. So first degree intentional homicide and second degree intentional homicide are very similar. For first degree, did Nikolai actually believe? Did he actually believe that he was not justified? For second degree, it's the reasonable person standard. I submit to you, it doesn't make a difference in this case. It's crystal clear. He knew he wasn't justified. He knew he wasn't justified. It's crystal clear from his actions after the fact. Can't be explained away by shock. It's clearly not in shock. The use of force on AJ, stabbing Riley just standing there, stabbing Tony trying to break it up, stabbing Isaac directly in the heart. Burial's there, walking up to Dante and stabbing him. The injuries he left behind, that all shows his intent. Again, you have to consider whether he knew he could retreat, whether there was a safe escape. He could have just walked away. He could have just raised his knife. He didn't do any of that. He just stood there with the knife until he punched Madison. He touched his knife when before running up on the boys. He takes out the knife, opens the blade up, never says anything, never walks away, never takes a step back, never raises the knife, never yells for help. He's smirking with the knife in his hand. Finally, after stabbing 5 people, then he walks away. Doesn't run, walks. It's shocking to see what Nikolai did in this case, to see the injuries, and then see his calm, cool demeanor after the fact, tubing down the river, sitting in his tube at the scene of chaos, casually talking to Sheriff Knudsen, making up this huge lie to Lieutenant Hart. He even lied to the start nurse at 9 p.m., so 5 hours after the incident.
Hello, Green Creek.
Boy pulling a knife, twisting his arm, poking him with his own knife. He even lied to Sandy after the arrest. Nick recognizes that what happened is not justified self-defense. Just standing there with the knife, not walking away when he clearly can. So even to Sandy, after he's charged, he casts blame on her and the group for not hearing him yelling. He never yelled. Normally, it'd be difficult to know what a defendant believed in a self-defense case, not in this case. Nikolai was not in fear, he snapped. He was angry and he snapped. and he knew it. His actions show he knew he did not reasonably believe the amount of force was necessary. He was not actually in fear. If he was actually in fear, he would have left. How else? You know, what other clues? Think about his testimony. We submit to you that this is first-degree intentional homicide, first-degree attempted homicide. His acts clearly show intent. If you can't agree unanimously on that, as your jury instructions tell you, you have to consider second degree. Again, the difference in second degree is Nikolai's belief versus reasonable person. You know, I submit to you his belief from his own conduct. Afterwards, he knew it was not justified. If you can't agree on second degree, you consider first degree reckless homicide, first degree reckless endanger of safety. Element 1, Nikolai endangered the safety of another human being. That's obvious. Endangered the safety of another by criminally reckless conduct. Jury instructions define criminally reckless conduct, creating a risk of death or great bodily harm. It's unreasonable and substantial. He was aware of the risk. Again, obvious when he's stabbing people. When you talk about reckless conduct, let's say you believe his testimony that he just thought anyone touching him, anyone close to him was attacking him and stabbing him. That's reckless. That's criminally reckless conduct. That's utter disregard for human life. What other clues are there utter disregard? He just walks away. He just walks away. He doesn't call 911. He just sits on his tube as other people are helping the victims. He tubes down the river. Your jury instructions talk about the question, the special question, yes or no. Did you commit these crimes while possessing a dangerous weapon, a pocket knife? There's nothing inherently wrong with carrying a pocket knife. A lot of people carry pocket knives. Totally fine to carry it as a tool, totally fine to carry it for self-defense, totally fine to carry any legal weapon, firearm, knife, if it's used legally. Nikolai he was not justified in self-defense when he attacked these people. So we asked that you answer yes on that question. In the end, what is beyond clear, Nikolai knew this was not self-defense. All of his actions, from the minute the stabbings are done, from the second the stabbings are done, he knew it. It's obvious. His actions were horrific. They were senseless. He killed Isaac Schumann, stabbed him directly in the heart, disemboweled AJ, stabbed Tony who's trying to break up a fight, Riley who's just standing there, and then walks up to Dante. That walking up to Dante, stabbing him when he's got clear paths to retreat, that destroys any argument.
A destination.
He was angry. There's no rational reason Nikolai, his group's over here, would walk this way towards the group of people to stab Dante. Senseless and horrific acts. The state has to find Nikolai guilty of all charges. Thank you.
Yeah, Dustin, we've been watching these.
Thank you. We will take a 10-minute recess. We'll be reconvening at 11:05.
Yep.
Please take the jury out.
All right, the jury.
All right. So that was the state's closing arguments. Now we're going to fast forward to the defense closing arguments.
And you heard Owen Pelican. I didn't those for it decreased. And you've heard Mr. I just want to give you guys a little bit of an indication as to kind of where I'm going to go. And more importantly, what I think you need to think about when you are back there.
Now, listen to the way this defense attorney speaks to the jury. I don't know if he's going to speak to the jury the way he spoke to some of the witnesses, but the way he spoke to the witnesses, some of the witnesses, was very condescending and mocking. I really do not like this defense attorney's vibe at all. He's just let's see how he acts with the jury.
They're thinking about the evidence. Okay. First is the law. 1, there is no duty to retreat. Period. That is the only requirement. In this state, bullies like men.
Yep, there he goes. He's already starting out with his intense level of enunciating with his mouth. Listen to the way he talks. This is the only thing. I don't. He's super intense. He's very off-putting to me.
Madison Cohen don't get to tell us where to go. Bullies like Madison Cohen don't get to get in our face and require that we leave. That's not a requirement here.
So what you'll hear is that they constantly call the other parties the bullies. So they're calling Madison Cohen a bully. She was a woman who came over to defend the kids, and many witnesses claim that Nicholas Mew struck her first. So maybe she was being a very Karen-like person and in his face and yelling at him to get away. Maybe that was bullying. I don't know. But what's more bullying? Telling somebody to get away from a bunch of kids that are feeling threatened and are acting like absolute idiots. So it's probably a good idea for you to get away from them. Or the person who punches that person in the face. Madison was not a kid, one of the kids. Madison was an adult that came over from a whole other part of the river. Let me decline that. Sorry. So let's keep going.
Keep that in mind. 2, subjective beliefs. Okay. When you're listening to or contemplating the evidence and replaying it in your mind, you are to do that and consider the beliefs, not the actions, but the beliefs of Mr. Mew. And when you do that, you are to do that from his perspective at the time that the events were occurring. So while we have a video, that video is from the perspective of Joanne Cockney. The video perspective that the jury is required to consider it is as Nick Mew is holding the camera.
They definitely look young, Harlot,
We'll
but
address
they
this a
were
little bit later, but
in their
the
20s.
idea of provocation, whether or not Nick intentionally caused harm to Madison Cohen. That is something that you should consider when you're considering provocation. And the other main one I want to talk about is what it means, because it's different here, beyond a reasonable doubt. So normally, beyond a reasonable doubt is this hurdle, and the state has to jump that hurdle in order to prove a case. It's a little bit different here, okay? Because in this case, self-defense has been alleged. Remember when you're back there, Nick Mew doesn't have to prove he acted in self-defense. They have to prove beyond a reasonable doubt that he didn't act in self-defense. They have to prove that his beliefs were unreasonable, okay? So the way that I look at this video, the main video of Juwan Cockfield, we've all seen the 9-second video where he's screaming at Mr. Mew, calling him a raper. I'm not talking about that. I'm talking about the video that you've seen probably more than you want to. But I'm breaking that up into really 3 parts, okay? 0 to 149 is the first part, all right? Before anything actually happens in terms of the attack. And what is in dispute in that first minute and 49 seconds? I think 2 things were raised in the case that were in dispute. And that is, first, whether or not these drunk teens were actually afraid of Mr. Mew, right? I think to a person, they testified, yeah, we were really concerned about Mr. Mew.
Hey, Chef.
And you get to use your everyday experiences in life when you decide what to believe. Does that look to you like teenagers who are afraid of that person? Is that what that looks like to you? Does this photo of drunk teenagers taunting him, does that make you believe in your experiences in life that they're afraid of him? Or is this what drunk teenagers who are terrified,
They
is
were
that what they look like?
children.
Does that make sense to you? Because you heard this. As the numbers rose, as the number of people grew, their fear, it decreased. And you've heard Mr. Anderson say over and over again, all Nick Mew had to do was walk away. you heard from each one of those tubers, those drunk teenagers, we could have passed. When he walked over by Madison Cohen, we could have passed. And you heard Owen Pellegrin. I didn't want to pass. I wanted to see how this was going to play out. Why? Because John Packfield was recording this entire incident. They wanted to see what was going to happen. They're not afraid. They want to see how this is going to play out. And Jawan Packfield said it best of all. It's for the culture. He wanted to put it on the internet so other people could see. And when you're using your everyday experiences in life, ask yourself this. Do people who are afraid of other people, do they walk up on them? Is that what people do when you're afraid of someone? Or do you try to get away from them? If you're afraid of someone, do you taunt them? Do you call them names? Do you circle around them?
That works both.
Those are questions that
Counsel.
you all can answer. Or an alternative hypothesis to them being terrified is, do they do those things because they're drunk teenagers and what they want to do is make a video and put it on the air? Which one of those two things, based on the evidence that you've seen, which one of those things makes more sense to you? The second thing that I think is in dispute, or was at least raised in the first minute and 49 seconds of that video, is whether or not Nick Mew's looking for little girls. Now, Mr. Anderson gets up here and says, no, he wasn't looking for little girls. But he also says, the boys didn't invent that. No, they pretty much invented that. And why do we, or how do we know that? So that's not in video anywhere, right? They don't mention it. They don't say anything about Nick Mew telling them that, right? Every one of them who speaks to the police provides a statement about what happened. Zero mention to the police that he said he was looking for little girls. This gentleman over here, Investigator Schultz, I think he said that he was a sensitive crimes investigator. He saw some of this stuff come across his desk. That would have interested him. Investigator did testify. Said he would have mentioned, if any of these kids would have mentioned little girls, I would have taken note of that. So,
Yeah, I just want to put on the record, this is my thinking. Nobody was acting great. No, the behavior across the board was horrible. So we have to be able to differentiate, though, what was bad, worse, and most worse. Right? So everybody was acting horrible. But does acting horrible and screaming names and doing all that type of stuff deserve a stabbing? Was the response proportionate to what was happening? He did have the opportunity many times to walk away. He was asked to walk away and he refused. He just glared at them and smiled. Okay? So he was acting just as menacing as they were. They were all being assholes. But remember, he's a 52-year-old man, and he knows that these are a bunch of drunk teenagers. When you're a 52-year-old man and you're confronted with a bunch of drunk teenagers, you walk away. Because nothing good can happen from that. Nothing. You don't taunt them, which I believe he did. And then when you're called names, not even threaten them with the knife. He didn't even say, hey, I have a knife, get back. He just pulled it out and started stabbing people. So, and it all happened so quickly that you really have to pick these threads apart.
what's the alternative? Why did they say that? I would submit to you that what kind of person does what these kids did to him? And what would they look like as people if all they did was pick a guy out and start to torment him. What do we think of people who do that? What do we think of people who call grown men rapers and pedophiles and predators?
We think of them as children
kicks.
who need to grow up.
What do we think of those people? They had to come in and say that. Because if they don't, we know what we think of them. That's the reason they came in, and they said this to you guys under oath. They got on that witness stand and swore to tell the truth, and they told you that he said he was looking for little girls.
And
Well, the cops got up under oath and told you, no, they never mentioned that to me.
he lied under oath many times.
What are the odds? What are the odds that that actually happened? And nobody mentions it to the police. What are the odds? Two other little points on that. In your everyday experiences in life, would you expect a man that you never met to walk up to you and say, if you ask him, how's your day? What are you doing? Oh, I'm looking for little girls. Would you expect someone to actually do that? Does that make any sense to you? He's with his wife.
No, that's probably why they were surprised.
He has lunch with his wife and his friends.
Why would a man say that? He was
In
by
order to
himself in
believe
their eyes.
what these drunk teenagers are saying, you have to believe that he has lunch with his wife. He's with his friends. They're having a fine time. Ariel loses his phone. And Nick goes, this is my chance. My wife's right over there, but this is my chance to go look for little girls. And I'm going to tell a bunch of drunk teenagers I've never met before, that's what I'm doing. Tell me that makes sense to you. Because you get to judge the credibility of what people have said to you. Okay? But I want to talk about what we know in that first minute and 49 seconds of the video. What do we know? We know, based on the evidence, that Nick's looking for a phone. We know that. Ariel said that. Nick said that. They find Ariel's phone in the river. So we know that. We know that Nick comes up to the teenager's tubes, and we know that Cotfield's looking for a phone, and Cotfield's holding a phone. It's when Cotfield's holding. We know that Nick Mew walks away from them as he passes them. We know that. We know, right, that the drunk teenagers move toward him and start confronting him. We know that. We also know that Nick sees what he believes to be a reasonable, rational adult.
Same
So he heads over there.
lawyer, harlot, same defense lawyer.
And what we know is you can see his thumb. He's motioning back, trying to explain what happened. And we know that Madison Cohen, who knows nothing about what happened, zero, starts screaming at him to leave. We know that Madison Cohen feels comfortable enough to put her hands on him for the first time.
Yeah.
And move him.
If it's this,
Because, well, she's queen of the river and she decides where people go. So she's moving him. We know that. We know that Nick is uncomfortable. So he waits for his group to come over because the state can say whatever they want. He's by himself. So we know Nick does that. We know that when Nick waves to his group, so does Madison Cohen. But there's one big difference here. Her group shows up. And they show up in numbers. We know that the group of teens are brave. And as this is going on, they start taunting this man who's done nothing to them. We know that. We know that Riley Madison comes over and now she thinks it's necessary because she's been anointed something in the river and she gets to tell him where to go. So we know that she puts her hands on him. We know that Nick's uncomfortable enough that he waves the group over a second time, trying to get someone to come to his aid. We know that. We know that Madison Cohen pushes him, puts her hands on him. Again, he tells her not to touch him, but she does it anyway. We know at that point it's 13 against 1. The other thing that we know, because we heard it, was someone in the group, the brave group of 6, tells Nick and you got 10 seconds. In your everyday experiences in life, when someone tells you that you have 10 seconds, what normally comes after that? If we have children, I'm going to count to 3. You got 10 seconds to do this. Nothing's good is coming after that. It's reasonable in our experiences as adults to take that as a threat.
Okay, we are back. We are back in court
Mr.
on Daybell.
Before we proceed, is the statement
Sorry to
ready?
interrupt that.
Boards and rejections,
Back to our
17.
main programming.
Yes, if you would have a sidebar about the issue, the evidence issues.
Wait, what did they just say? Let me go back and see what they just said. So Detective Hermosillo is still on the stand. Looks like they're probably pulling in the jury. In case you aren't aware, we can kind of see the courtroom layout from, you know, from our view here. But let me see. Oh, maybe I took no. This is a diagram that Nate Eaton put together showing the, you know, where the jurors are. In the upper right hand corner where that X is, that's where the jurors come in. So the jurors can come in right where they sit down. And you know, it's just a very rudimentary drawing, but it's somewhat helpful. Yeah. This might be a little nappy in terms of, you know, groggy making in terms of the testimony. Trials always start out, you know, you got your opening arguments, and then the witnesses start out a little bit dry. Usually, not all the time, but usually it starts out with the detectives. In Lori Vallow's trial, the first witness was Kay Woodcock, which I thought was interesting. And I think it was because she was the one who called in the wellness check on JJ, which led to the wellness check on November 26th and them seeing he was not there. And then they went back with a search warrant. And when they went back with the search warrant, Chad and Lori had taken off to Hawaii and told police that JJ was with Melanie Gibb. They contact Melanie Gibb, and at first she ignores their calls, but then she gets back to them. The Montgomery case really mixed it up. Mixed what up, Harlot?
All right, we're on the record now. This is
Oh,
CR 22211623, State versus Chad Guy Daybell. The jurors are not present at this time. Had a sidebar with counsel. Previously, a few of the exhibits that were offered and admitted had some reference material on them, base numbers, etc., from the case that the court raised a concern. And I believe, Mr. Wood, what you've done is figured out a way to remove those references from the exhibits, and the court would know those references were not published to the jurors, and they won't be, so the court will permit those references to be removed from the exhibits before they are published or provided to the jurors. Is that how we're going to handle that, Mr. Wood?
Yes, that's my understanding, Your Honor.
All right, and Mr. Pryor, any objection from the defense to proceeding in that manner with those few exhibits?
No objection.
Okay, thank you. I'll make sure then that the original court exhibits to the jurors will have that information removed before the jurors are either published the information or receive copies of it. And with that, then I believe there are no other issues to take up before the jurors are brought in. Is the defense ready to proceed as well, Mr. Fryer?
Yes, Your Honor.
All right, thank you. Then we'll continue with
Also,
testimony of
Harley,
this
we
witness.
did that.
And
Here, I'm going to mute this
Mr.
because
Wood, if you're ready, we'll have the jurors.
jury until the jury comes in. So they also did that with this Nikolai Mew case with the river stabbings case. All the early witnesses were actually incredibly impactful. It was they basically brought on just a long trail of witnesses from the actual event. And among the first witnesses was the guy who took the actual video recording. And most of the witnesses became pretty emotional on the stand. They were restraining themselves and they were trying to hold back and they were trying to be just witnesses. But most of them are incredibly young. There were some, I think the youngest person to testify might have been even 17 years old. They're kids, right? So let's see if we can hear now. But that's what they did in that case.
Concluded the lunch break at this time. We're continuing with testimony of Detective Hermosillo and Mr. Wood. If you're ready, you can inquire. I'll remind the witness you're still under oath for your testimony.
It was incredibly heartbreaking, hippie chick.
Thank you,
All of
Ma'am.
the testimony.
Detective, before we broke, we were speaking about the search of a residence. Can you remind us what residence that was?
I believe it was apartment 175.
And whose residence was that?
Lord Vallow.
Your Honor, the state would ask that the witness be handed the state's exhibits 7A through 7K.
It's so weird. All of it, Judge. Oh, it for a moment there, it looked like some of the Zoom frames had frozen, but it looks like they're waiting for something. Oh, they're waiting for evidence to be reviewed. Yeah, Stacy, I had to shield my eyes a number of times. I had to look away a number of times. You know, when I'm watching fiction and there's violence, I'm able to watch it and convince myself, you know, this is fake, it's phony, don't worry about it.
The witness is handed
Not here.
state's
Not with that.
exhibits 7A through K. They've been reviewed by defense. Mr. Wood, you can inquire.
Detective, do you recognize state's exhibits 7A through K? Go ahead and take a minute and review them.
Another interesting thing.
Yes, sir.
Oh, sorry.
What do those exhibits purport to be?
They are photographs that were taken of Lord Vallow's residence in the morning of November 27th.
And were you present You testified earlier you were present at the search of that apartment on that date, correct?
That's right.
Did you walk through every room in that apartment?
Yes, I did.
Did you take these pictures?
No, I didn't.
Do you recognize them as true and accurate representations of what you witnessed in that room that day?
Yes, I did.
Or, I'm sorry, in that apartment that day?
Yes, I did.
Your Honor, the state, moving for admission, states exhibits 7A.
The objection from the defense.
What do you indicate objection?
Yes, and use your microphone, please, Mr. Clark.
May I, Judge?
Yes,
Officer, what time were these pictures taken?
I don't know the exact time, roughly between 10 and noon, I would guess.
Are you guessing or do you know?
I don't know exactly what time, sir.
Okay, who took the pictures?
I don't know who took the pictures, sir.
What day did they take the pictures?
I believe I testified November 27th, 2019.
Well, if you weren't there, how do you know if you don't know who took it or who?
Objection, he's misstating the testimony.
no, I'll allow it. You can continue to work on it.
I never once said I wasn't there. I was there the entire time on this.
That's not what my question was. The question was, you weren't there when the pictures were taken, were you?
I wasn't there when they were taken. No.
You don't know the condition of the home when the pictures were taken, is that correct?
I was there when the pictures were taken, not standing next to the photographer.
So you were there when the pictures were taken,
That's correct.
but yet you don't even know who the photographer was who took the pictures. Is that what you're telling me?
That's correct.
Is there a reason why you wouldn't know a photographer who's taking pictures for a police investigation that you're in charge of?
I wasn't standing next to the photographer. I was inside the residence when the photos were being taken. At the same time they were being taken, I wasn't standing next to him.
Okay, but the question I asked is why is it that you don't know the name of the photographer when this scene was closed off for an investigation pursuant to a search warrant, and you can't tell me who the name of the photographer was who took these pictures?
There were a lot of people that
Ask
were part of
him
that search warrant. I can't tell you exactly who took the photographs.
Well, that's what my concern is.
Prior, and we're getting speaking objections now. If there's a continuing objection, state the grounds.
Well, there were a number of people that were in and out of that apartment, is that right?
In and out of that apartment? No, sir. In that apartment, yes.
How many people were in the apartment at the same time?
Roughly 10.
And you would know all of the names of the people that were in the apartment, right?
Correct.
Yet you don't know the name of the photographer who took the pictures. Is that what you're telling me?
That's what I'm telling you, yes, sir.
Relevance?
Object.
Your Honor, I'm gonna lay some more foundation.
All right, you can lay additional foundation, and I'll also note it is a group of photographs, so if you have to work through them individually, we will. I'll note just an objection on 7K, and Mr. Lee, you can seek additional foundation related before I rule on the objection.
Detective, you testified you were present that day,
That's correct.
and you recognize these images as true and accurate representations of what you saw in that apartment.
That's correct.
And is it a true and accurate representation of the condition you found the apartment in?
Yes, sir.
And as you look through these pictures, is there anything in there that is different than the way you found it?
No.
Your Honor, the state moves again for the admission.
Objection again, Judge. There hasn't been proper foundation. The officer can't even tell me who took the pictures. He doesn't know what time the pictures were taken. And the condition he's talking about is the condition that he saw, not necessarily when the pictures, in the condition when the pictures were taken. So there hasn't been proper foundation here.
All right, I've considered the objection. I'm going to overrule the objection as it relates to.
Right, because it's petty.
Photographs finding the officer has personal observation of the location. The one exception that I'll consider a standing objection on is on 7G, which is different, I would say, than just showing the apartment. Not saying it's not admitted, but still under advisement. pending any additional objection or foundation. So photographs, with the exception of 7G, are admitted, and you can inquire further, Mr. Wood.
Thank you, Your Honor. If I could publish those to the jury.
Yes.
Detective, can you tell me what you observed in State's Exhibit 7A?
That's the front door of apartment 175, front porch area.
And is this the apartment that you searched while you were for JJ?
Yes.
Detective, what did you observe in State's Exhibit 7B?
So as you walk into the front room of the apartment, that's looking towards the dining kitchen room area. There's a child's car suitcase sitting there. Like I testified earlier, it looked like it was lived in. There's still cups, things on the counter, paper towels, everything looked normal.
What did you observe in State's Exhibit 7C?
That's standing in the kitchen, facing the doorway, so the opposite direction of glass door. You can see the stairwell going upstairs. There's still pictures on the wall, TV, thing, papers on the counter. Everything looked normal at that point as well.
Observed in State's Exhibit 7D.
So when I testified about the crawl space under the stairs, and the 72-hour kits, those are a few of the 72-hour kits, along with the Star Wars suitcase that we had located.
When you, Your Honor, does the court have a pointer?
I don't know, let's have the bailiff from the, no, we did not, so.
Can you point to what you're referring to, describe the 72-hour kit?
So these black
Hold on a
bags,
second, Mr. Wood, yeah, okay, go ahead.
these black bags were the 72-hour kits. There's some underneath here that you can't see. There's some here, and then that's the Star Wars suitcase that I was referring to earlier.
Detective, what did you observe in State's Exhibit 7E?
That's the top of the stairwell, looking down towards the bottom of the stairwell. This part right here goes into the front room, and the front door is right here.
What did you observe in State's Exhibit 7F?
This is the master bedroom. So when you come up the stairwell, immediately to your left is this entrance here. Like I testified, there was bedding, pillows, everything looked normal in the room at that point. This is a bathroom as well.
Detective, what did you observe in State's Exhibit 7H?
7H is what caused some red flags for us when we were searching the apartment.
Why was that?
Because of all these empty hangars. People go on trips.
Judge, I'm gonna object as unresponsive. There isn't a question here, that's a narrative.
It's the same. Detective, I asked you why the empty closet was concerning to you.
Because when we made contact with Lori Vallow the day before, she had lived in the apartment, she was in the apartment living. The very next morning, when we served the warrant, this is what we found, empty hangars.
And Detective, why would empty hangars be concerning to you?
Because it appeared to us that she grabbed her clothes, left everything else and took off.
And that's exactly what happened.
What did you observe in State's Exhibit 7I?
This was a bedroom. If you walk down the hall towards the west, this is the bedroom on the right hand side. This is the bedroom we found Alex Cox, some of Alex Cox's belongings in. So this is the bedroom to the right.
And what belongings of his did you find there?
There was a plastic tub with some of his belongings in, some hygiene things that had his name on it, things like that.
Detective, what did you observe in State's Exhibit 7J?
This is the same bedroom. There's one of the plastic tubs that had some belongings of Alex. There's some prescription pills up here that had Alex's name on them. And then there was some white Tyvek suits that were in the closet area.
What did you observe in State's Exhibit 7K?
This is the room to the left. So the previous room was to the right. This is the room to the left. It had twin beds, bedding, everything looked normal in that room as well.
Your Honor, I'm going to ask that the witness be handed State's Exhibit 7G again for further foundation. Very well. That's if you recognize State's Exhibit 7G.
Yes, I do.
What does it purport to be?
A rental agreement with the tenant of Lori Ryan.
And you testified earlier about finding a rental agreement, is that correct?
That's correct.
Is this the rental agreement that you were speaking about?
Yes, it is.
And where was that located in the residence?
In the master bedroom on a desk in the corner.
And you saw it there?
That's correct.
And is that a true and accurate representation of the rental agreement you saw?
Yes, it is.
Your Honor, I move for admission of State's Exhibit 7G.
Any objection?
No, Judge.
All right, Exhibit 7G is admitted as well.
May I publish?
Yes.
Second, is this the rental agreement we were just speaking of?
Yes, it is.
And you testified earlier about searching the storage unit, correct?
Correct.
Was this the rental agreement that led you to that storage unit?
Yes.
Thank you. Your Honor, I'd ask that the witness be handed what's been marked as State's Exhibit 8A through 8Q.
8A through Q sounds like a lengthy exhibit. So I see what they're doing here is just establishing the early happenings, the early events in this case, how detectives, how law enforcement were made aware, and then what they first discovered when they started to investigate, showing pictures of Lori's apartment when they went there the day before and looked around. It was full and lived in. The next day they go there and all the clothes are taken off the hangers and it looked like they had all just bailed, which is exactly what they did. They bailed. They went to Hawaii and on December 5th, they did this. Oh, no. Sorry. It wasn't. I'm sorry. I have the wrong date on that. It was like 17 days after Tammy died. So actually, they were already married. Sorry, I have the timeline wrong there. So they were already married from the beach. When all of this was taking place. When this initial search was taking place, when Lori pretended not to know who Chad was, she pretended that Chad was her brother's friend. Looking over the exhibits. And this,
I'm going to ask you to take a moment and review since exhibit 8A through 8M.
hello, Jelly Baby. Getting ready to see an exhibit, although it's kind of hard for us to see it. So Stacy sent a image of a zoom in.
And what do you states exhibit 8A through 8M report to be?
Photographs that we had taken in number 175.
And what day were these photographs taken?
November 27th, 2019.
This image is courtesy
And
of
was this
Stacy.
a part of the search that you testified to earlier?
Yes,
And you were present in the garage?
that's right.
Were these items laid out in this manner when you got to the garage?
No,
Were they taken out to be photographed?
yes,
And did you observe that taking place?
I did.
Right. And other than moving those items to be photographed, are these pictures, are these items in the same condition that you observed them that day?
Yes, in the same condition, like I testified to, we manipulated some of them so we get better photographs.
And are they true and accurate representations of what you observed in the garage of that apartment that day?
Yes,
Your Honor, the state would move for admission of State's Exhibit 8A through 8M.
Or dealing with.
I'm sorry. I should have said 8L.
Yes, Tiggy girl. The birds are outside, just outside my back door window here.
Eight A through L.
Judge, why do you have any objection?
I get lots of happy
Or-
bird sounds here in my house.
Officer, as before, were you present when the pictures were taken?
yes,
What was the name of the person who took the pictures?
Detective Daybell.
Were you present at the exact time that the pictures were taken of all of these items?
Yes, I was.
Who else was present at the time that these pictures were taken?
I couldn't tell you who else was in the room.
Well, we were in a garage, weren't we?
Couldn't tell you who else was in the garage.
Were there so many people there that you don't know?
No, I
Your
just,
Honor, this doesn't go to foundation.
I'll allow them more dire if you wish, Mr. Pryor, continue.
So many people in the garage, you didn't know who was there?
no, I just can't recall their names at this.
They're not officers that work with you?
They are.
Pryor's objections are so petty.
How big of a garage are we talking about?
I couldn't testify to that.
Two-car garage, one-car garage?
Mr. Pryor, I think we're getting across here. Is this a foundation objection still?
Judge, I'm trying to establish. Judge, I'll move on. Save it.
All right, the court's considered foundation objection as it relates to exhibits A through L. I'll overrule the objection and those may be admitted.
Thank you, Matt Publish.
Yes.
I mean, you gotta wonder what are the
What did you observe in State's Exhibit
end
8A?
goals of these objections.
So when I testified earlier about various magazines, weapons, there were knives, this is where we found those items. And
I
this,
just want to stop you real quick to clarify, when you say magazines, what type of magazine are you referring to?
magazines that go in rifles.
And you testified that you moved these items to take pictures of.
Correct.
And what did you observe in State's Exhibit 8A?
So here's some of the various magazines that we took out of some of the tubs. There's some ammunition. There's a few suppressors that screw on to the end of a gun to muffle the sound. There's a ghillie suit. Different items in this photo at different spots.
Could you tell me what you observed in State's Exhibit 8B?
So these were items that were located in black plastic bags, which are right here that I'm pointing to. So we simply took those items out of these plastic bags and laid them out so we get photographs of them.
What did you observe in State's Exhibit 8C?
These are various caliber ammunition in plastic bags that were located in plastic tubs.
When you say ammunition, those are for bullets, correct?
Correct.
What did you observe in State's Exhibit 8D?
This was one of the rifles that we had located in the garage in apartment 175. It's got duct tape here. What you can't see up top.
Judge, I'm responsive.
I'm gonna move the picture so you can see the top. What did you observe at the top of State's Exhibit 8D?
Like I was testifying to, at the top of this rifle, it's threaded for a suppressor to muffle the sound of a gunshot.
What did you observe in State's Exhibit 8E?
This rifle here is the exact same rifle from the previous picture. There's also another rifle that was in a bag, and that's this one here. This photograph was taken at the police department once we got the items back.
What did you observe in State's Exhibit 8F?
This is the rifle in the previous picture that was back here. It's just a close-up of that rifle.
What did you observe in State's Exhibit 8G?
Those are what I call the suppressors. From earlier that there was a photograph of these two men on the garage floor. This is just a close-up of both of those suppressors.
What did you observe in State's Exhibit 8H?
These are knives that were found amongst the ammunition in the rifles and tubs.
You described to the jury what you observed in State's Exhibit 8I. Okay.
This is just a handgun that was also located that was still in the case inside the garage.
Did you observe in State's Exhibit 8J?
This is a Halloween mask, or what we think is a Halloween mask, that was located in a plastic bag in the garage along with duct tape and rope.
You described to the jury what you observed in State's Exhibit 8K.
Once we remove the Halloween mask, this is the duct tape and the rope I was referring to in a Walmart bag.
And what did you observe in State's Exhibit 8L?
That is a passport that's located in belongings in that garage belonging to Alex Cox.
In Your Honor, I'd ask the witness be handed State's Exhibit 8M through 8Q. Well,
I've zeroed in on the witness box in the screen as closely as I can because that's really where the action is happening. And courtesy of Stacy, we have that beautiful view. That beautiful shot of John and Chad. This bailiff, he's going to get his steps in, right?
Briefly review states exhibit 810 through 816. Do you recognize those exhibits?
Yes, I do.
What do they purport to be?
These are items also located in the garage 175. What we go through each.
Not yet. Did you observe these items with your own eyes?
Yes, I did.
And you saw these on November 27th during your search of apartment 175?
Correct.
I believe you testified they were also in the garage.
That's correct.
Are these true and accurate representations of what you observed that day?
Yes.
Your Honor, I move for the admission of states exhibit 8M through 8Q. Any objection?
Yes, one to your native objection, Judge.
Go ahead.
Officer, you previously testified that I don't want to put words in your mouth, that you staged certain items. Is that a fair assessment?
Correct.
And some of the items that you staged, and I mean, when I mean staged, you removed those from packages or boxes, and you laid them out to take pictures. Is that correct?
That's correct.
Did you take pictures of all the items in the garage, or are these just selected pictures that you've decided to show today?
We took photographs of the items in the garage, anything that we thought was evidentiary value. We took photographs.
Okay, so the question is, the answer is then that you did not take pictures of everything that was in the garage. Is that fair?
No objection, Your Honor. This is cross, doesn't put a foundation of these items.
I do sustain that. We need to be on the narrow issue of foundation for admission or not, and we need to be allowed to cross later, of course. Questions on
So the question is that when I hear previously that you took items out of a package and you took pictures of select items, did you take all of these items out of some sort of packaging and take select pictures of these as well?
Yes, we took these out of tubs that were in the garage. We took photos.
So when you were there and present going through the garage, and we don't know how big this garage is because you don't know. You couldn't see these in plain sight when you went through them, correct?
That's correct.
So you don't know what was in the garage and what wasn't. These were staged by someone else who took pictures, that correct?
We took these out of tubs and took photographs of them.
Who took them out of the tubs?
I couldn't tell you what officer took them out of the tubs.
When did they take them out of the tubs?
I mean, where is he going with
Are
this?
you asking for a time, sir?
Is he trying to
Asking for
claim
time, yeah.
misconduct?
Roughly 10 to 12, I would say.
In the afternoon, in the morning, when?
10 o'clock in the morning till 12 noon.
And you were present when they were taking these out of the tubs?
That's correct.
And who took these pictures of us?
Detective Hope.
Judge, I have nothing else. Thank you.
All right, I'll rule an objection on foundation relating to exhibits 8M through Q, and those will be made. Thank you.
May I have a question?
You know,
Detective, can you describe to the jury what you observed in states exhibit 8M?
That is what appears to be an email printed item that was located in the garage at 175. There's some handwritten scribbles on it, some names, numbers associated with those names.
And at the time that you found those documents, did you understand what that?
No,
Were you able to determine, you said it was an email, who the sender of the email was?
yes,
Who was it?
Chad Daybell.
Were you able to determine who the recipient of the email was?
I don't recall the recipient. Just
No.
who sent it.
Oh, I apologize, I didn't get that down.
I just remember who sent the email.
And were you able to tell what date it was sent?
I believe it was October of 2018.
Was there a specific date?
I would have to look at it a little closer. It's in the upper left-hand corner.
Second, I'm going to have States Exhibit 8N, if you can describe what you observed there.
It's the same photograph from
Good for
the
you,
last
Bogart.
slide.
I wish I
States
could hand
Exhibit
snacks
8
out.
vote. Or is you, oh, sorry.
It's also more of the same email papers from the last slide.
In fact, if I were to have States Exhibit 8N that, would you be able to tell the date of the email?
Yes.
What is the date on that email?
October 30th, 2018.
And then detective, what did you observe in States Exhibit 8P?
Those were also in the tab books written by Chad Daybell.
And then lastly, what did you observe in States Exhibit 8Q?
That was a cell phone that was also found in the tab in the garage.
Were you able to look and get that cell phone at any time?
As far as forensically,
Yes.
I wouldn't be able to tell you unless I looked at the report.
Detective, we've been talking about this search on November 27th, correct?
Correct.
And at any time that day, did you locate JJ Vallow?
No.
What was the next step in your investigation to find JJ?
Our next step was to talk to anybody that would take our phone calls. JJ was,
Judge, I'm going to object. This is again becoming a narrative.
Your Honor, you still just answering the basic question.
All the without objection.
JJ was who we were looking for. And so we were exhausting every effort to find JJ. So we would call his siblings, family members, any family friends, anybody that might know whereabouts JJ.
So who were some of those family members that you spoke with?
We ended up speaking with Brandon Boudreaux, Melanie Boudreaux, JJ's brother, Colby Ryan. Gilbert Police ended up speaking with family members down there. That's who we spoke.
At any time during your investigation, did the scope of the search change into who you were looking for?
It did.
Why was that?
After we spoke with Colby Ryan, who was JJ's brother, he mentioned that he
Judge,
had,
I'm going to object. This is hearsay.
Sustained. Detective, at any time did the scope of your search change to include the search for Tylee Ryan?
It did.
And so let's go back to your search very briefly on November 27th. Did you see Tylee Ryan at that apartment at any time?
No,
And during your intermittent surveillance you talked about in early November, had you seen Tylee Ryan?
no,
Did you ever meet Tylee Ryan?
no,
Did you become familiar with who she was through your investigation?
yes, we did.
How did you do that?
After speaking with Colby, our search encompassed JJ and Tylee.
Your Honor, I'm going to ask the witness be handed State's Exhibit 5. I believe this comes in by stipulation.
It does. Judge, we've stipulated the admission from this exhibit. The council would be so kind as to repeat the exhibit number for me, please.
5.
Thank you.
All right, exhibit 5 has been offered and admitted. You can proceed, Mr. Wood.
Thank you. Detective, do you recognize State's Exhibit 5?
Yes, I do.
What is it?
It's a birth certificate issues out of the state of Texas.
Your Honor, may I publish that for the jury?
No objection.
Go ahead.
Detective, were you able to read that on the screen?
Yes,
You could point out with your pointer the name of the individual or who that birth certificate applies.
the name is Tylee Ashley Ryan.
And what was the date of her birth?
September 24th, 2002,
And where was she?
Travis County, Texas.
And just for purposes of the record, can you state who her father was?
Joseph Anthony Ryan Jr.,
And who was her mother?
Lori Noreen Cox.
Through your investigation, have you learned of Lori Vallow's maiden name?
Yes,
What was it? Cox. Okay. So Detective, you testified that at this point you were approximately when did the scope of your search widen to include Tylee Ryan?
it was after we spoke with Colby on December 11th, 2019. We entered JJ, Vallow, and Tylee Ryan into what we call NCMEC, which is the National Center for Missing and Exploited Children. So on December 11th, 2019, we entered both of those children as missing and endangered.
How does NCMEC work?
It's a center where
I'm going to object at this point on the foundation.
Mr. Wood, if there's any additional foundation or anything that has been.
Okay. Can you restate again what the acronym NCMEC stands for?
National Center for Missing and Exploited Children.
And is that associated with the government entity?
It is.
Do you know which entity?
I don't.
Have you ever used NCMEC before in your job as a detective?
Yes.
How have you used it before?
When we have missing children, we enter and call NCMEC, enter the information, it goes into a database.
Mr. Wood, for the record, could you indicate what that acronym is?
Yes, Your Honor, it's NCMEC. Thank you. If you'd like the detective, can you just state what that stands for again?
National Center for Missing and Exploited Children.
Did you include any other law enforcement agencies in this search?
We did. After November 27th, we reached out for assistance from the FBI. We reached out through Fremont County. So we were in contact with Gilbert Police, Chandler Police, anywhere down there where JJ or Tylee lived or could possibly be at.
And did you ever try to contact Lori Daybell in regards to the whereabouts for children?
Absolutely.
How did you do that?
We tried contacting Lori by her cell phone. We also attempted to contact.
Well, let's talk about that real quick. Were you able to talk to her?
No, her cell phone was shut off.
Did you ever attempt to contact Chad Daybell in regards to the location of the children?
Yes, we did.
How did you do that?
We attempted to contact him through his cell phone.
And were you able to get in touch with him?
No, it was also shut off.
And at any time, did Lori Vallow ever call the Rexburg police to report missing children?
Judge, objection. Foundation.
Response, Mr. Wood?
Your Honor, it's just a basic question. I think it's in line with the question we've been going through. I don't know what additional foundation. I can look for that.
On foundation, is overruled. Witness can answer.
Did you ask that again, please?
Did Lori Vallow ever contact the Rexburg police, to your knowledge, regarding missing children?
No, she didn't.
Did Chad Daybell ever contact the Rexburg police regarding missing children?
I'll renew my objection, Judge. Knowledge foundation.
It's overruled.
No, he didn't.
Seeing that shows consciousness of guilt. You drop everything. You
Detective, when you
call the police.
place the children in the NCMEC database, you receive tips from that.
Yes, we set up tip hotlines through NCMEC, also through the FBI and through the Rexburg Police Department. So anybody with any information on those two missing children could call any one of those numbers and provide us with any information.
And did you ever receive tips through NCMEC regarding JJ Vallow, Tyler Lane?
Yes, we did.
What would you do when you received those tips?
When we would receive the tips, we would assign it a tip number. And those tips were followed up on by detectives or other officers. So as soon as those tips came in, they were given a number and assigned to an officer to take it forward.
And would those tips, when they come in, do they have a phone number associated with them?
A lot of times they did have a phone number. A lot of them were anonymous. They didn't want to get involved. So some of them had phone numbers where we could follow up, others didn't.
And if someone submits an anonymous tip through NCMEC, is there anything you can do to follow up on that?
It depends on the information they gave us, but we would follow up with any information that they had put on the tip.
And when a tip comes in with a phone number, would you call those individuals back?
Yes.
Did you ever alert the public that the children were missing?
We did. We held a press conference on November 20th, 2019. And alerted the public that we had two missing children in our area.
And after that press release came out, did you receive tips after that?
Yes, we did.
And did you follow up on those tips as well?
Yes, we did.
Did any of those tips ever lead you to finding JJ Vallow?
No,
Did any of those tips lead you to finding Ty Ryan?
no,
Detective, regarding Ty Ryan and JJ Vallow, are you aware if a child protection action was filed in Madison County regarding them?
yes, it was.
Were you involved with that?
I was the one who wrote the affidavit.
And what was the purpose of that action?
Judge, I'm sorry, I didn't hear what the officer's response is. I was the one who
Wrote the affidavit.
thank you.
You want to re-ask your questions?
I will, I just letting the witness drink his water.
Appreciate it.
Detective, what was the purpose of that affidavit?
To get Lori to produce her children to the Rexburg Police Department or the Department of Health.
And are you aware if there was an order issued in that child protection action?
There was.
What did it order?
It ordered Lori Vallow to produce her children within 5 days of being served at court order.
Detective, were you ever able to locate Chad Daybell and Lori Vallow?
Yes, we were.
How did you do that?
A few different ways. Some of the tips that came in gave us location in Kauai, also through cell phone data.
Judge, can I have some foundation as to the time, date, location?
There's a foundational objection, Mr. Wood.
I'll just ask some more questions, Your Honor.
Very well.
Approximately when did you learn about the location of Chad and Lori?
Beginning of January of 2020.
And you stated earlier, but what kind of tips gave you that information?
Eyewitnesses that would call in that said they saw Lori and Chad on the island of Kauai,
And where is Kauai?
in Hawaii.
Did you ever write warrants to aid or apply for warrants to aid you in finding Chad and Lori?
Yes.
What kind of warrants were those?
We wrote warrants for cell phone data, geofence location, a few different warrants through cell phone companies to assist us in finding Chad and Lori or their location.
And did any of the data you received from those help you locate them?
Yes, it did.
Jacob, did you ever go to Kauai as part of your investigation?
Yes, I did.
And what did you do when did you get there?
I got to Kauai January 24th, 2020.
And once you got there, what was the purpose of going there?
We went there to aid and assist the Kauai Police Department in serving that court order to produce JJ Tiley to the Rexburg Police Department.
And did you see Chad and Lori Daybell in Kauai?
Yes, we did.
You mentioned assisting the Kauai Police Department in serving that order. Are you aware if Lori Vallow was served with that order?
Yeah, she was on January 25th, 2019, correction, 2020.
While you were in Kauai, did you do anything else?
We observed the Kauai Police Department serve 2 search warrants. One on Chad and Lori's condo and the other on the rental vehicle.
Did you perform those searches as well? Or just observe the Kauai Police Department do it?
No, we just observed and we let them serve.
Do you recall where their condominium was located in Kauai?
I don't recall the physical address, but it was Princeville.
And is that a town or city in Hawaii?
Yes.
When you observed the search of the residents they were living in Princeville, after the Kauai Police Department did their search, were you able to walk through that residence?
Yes, I was.
What did you observe at that residence?
Everything looked normal. It appeared two adults were living there. There were beach towels, two beach towels, everything was in pairs. Food in the fridge, couches, everything seemed ordinary.
Did you see JJ Vallow there?
No,
Did you see Ty Ryan there?
no,
Did you see anything that would have indicated to you that a child was living there?
no, I didn't.
Did you observe anything that would have indicated to you that a teenager was living there?
No.
Detective, to your knowledge, did Lori Vallow ever produce her children to the Rexburg Police Department or the Department of Health and Welfare?
No, she didn't.
And that entire time, her family was begging
Your Honor, I'm going to ask
Lori
that
to
the
produce the children.
witness be handed State's Exhibit 6. Detective, do you recognize State's Exhibit 6?
Yes, I do.
What does it purport to be?
It's a photograph of Kylie Ryan.
Did you have, as part of your search, did you look at Tyler Ryan's social media?
Yes, we did.
To your knowledge, was this image obtained from her social media?
It was taken from her Instagram account.
And so as part of your search, did you personally observe her Instagram account?
Yes, I did.
And did you personally observe this image on her Instagram?
Yes, I did.
Is this a true and accurate representation of what you observed on her Instagram?
Yes.
And also, as part of your investigation, did you see other pictures of Tyler Ryan?
Yes, I did.
And is this individual, is that a true and accurate representation of Tyler Ryan?
Yes.
Your Honor, the state would move for State's Exhibit 6 to be entered into evidence.
No objection, Judge.
Very well. Exhibit 6 has been offered and admitted without objection, so it's in the record and will be published if you wish, Mr. Ward.
Thank you.
Yeah, I think Tylee was very smart and she wasn't fooled
Detective, is this
by a lot of this stuff.
the exhibit we were just speaking of?
Yes, it is.
What was the username on the account that you found that picture in?
Tylee A. Ryan.
And this individual is the Tyler Ryan that you came to recognize through your search.
That's correct.
Detective, I want to ask you about the phrase proof of life. Are you familiar with that phrase?
I am.
As a detective, what does that mean to you?
Proof of life is any documentation, any video, photograph, anything that we can use to show the last time somebody was saw alive or seen alive.
Pursuant to your investigation, did you find a last known proof of life for Tyler Ryan?
Yes, I did.
How did you locate that?
That was taken from Lori Vallow's iCloud account.
And what, do you know which iCloud account it was taken from?
Lori for style at iCloud.com.
And what was the form of that proof of life?
It was a photograph of Tylee taken at West Yellowstone.
Your Honor, I'm gonna ask the state, or the witness behind State's Exhibit 29A, 29B, and 13, and I believe these come in by way of stipulation.
All right, take a look at defense for me as well.
So what they've established at this point is that Chad and Lori have flown the coop. They've been ordered, or at least Lori has
Judge, that's correct, by way of stipulation.
ordered to produce her children
I'll just review those briefly and then
and refuses to. And now we're going to see that the last sign of life, the last proof of life of Tylee is a picture taken of her at Yellowstone with her murderous uncle, Alex Cox.
have a quick sidebar, counsel.
Sure.
Sidebar. So I just find myself wondering, what does Pryor think he's going to get out of these petty Annie objections? You know, like the foundation of when a picture was taken, who was in the apartment, who took the picture, all of that type of stuff. How does any of that, what it signals to me is that he has a weak defense. Because if you have to be that nitpicky at the very beginning of tiny little in the weeds things that probably won't have any bearing on the outcome of the case whatsoever, you're desperate. And you could say, sure, he's desperate to save this man's life. This man's life is on the line. But as Tiggy Girl astutely observes and says here, he's going to start annoying that jury by keeping them there longer and by muddying the water with these, in the weeds questions that they will see eventually really have no bearing on the outcome of the case. And what it also signals is that he's trying to go in the direction of police misconduct. And there's absolutely.
I will note that exhibits 29A and B and exhibit 13 are all admitted without objection. You can proceed, Mr. Williams.
There's been absolutely no indication of police
Detective, would you look
misconduct
at State's Exhibit
situation.
13? What does that report to be?
That is the photograph taken from Lori Styles. They testified to a remove Tylee and West Yellowstone.
If I may publish.
Yes.
You can just identify the individuals in that photograph, Detective.
Sure. The little boy is J.J. Vallow. The Tylee Ryan's in the middle, and their uncle Alex Cox is on the right.
And as part of this exhibit, did it contain metadata?
Yes, it did.
And did the metadata in this instance, well, can you describe to the jury what metadata is?
Sure. Metadata is like a time and date. It has a time and date stamp with the photograph that's taken. So it's just data associated with the photograph.
And this photo was accompanied by metadata?
That's correct.
And what date was this photograph taken?
September 8th, 2019 at 2:49 p.m.
And you testified earlier that this was in Yellowstone?
Yes,
How do you know that that's Yellowstone?
I've been there.
So you personally recognize that location?
Correct.
This would be Tylee's last day on Earth, and she didn't know it.
Detective, revisiting this idea of proof of life. Throughout your investigation, were you ever able to find photographs dated later than that of Tylee Ryan living?
No,
And can you describe just quickly where you found that photograph?
from the iCloud account associated with Dorbell.
And I believe you already said it, but just for purposes of the record, what was the name of that iPad?
Lori for Style at iCloud.com.
And how do you know that that account was associated with Lori Vallow?
Such a Lori name.
The information attached to it and also the photographs that were attached.
And when you say photographs, what type of photographs led you to believe that that was attached to Lori Vallow?
Family photographs, Lori Vallow's photographs with her in the photos.
Detective, pursuant to your investigation, are you aware of a last known proof of life for J.J. Bell?
Yes, I am.
Your Honor, I'm going to ask this. The witness be handed states exhibit 14, which I believe also comes in by way of stipulation.
The last image of JJ is rather candid and blurry, so I don't have it here to show you. Also, it's kind of an eerie photo in my view. If it's the one I'm thinking of, it's him sitting on the couch in their apartment. He's wearing, if I recall correctly, pajamas, but red pajamas, and I think they're the same red pajamas they found him in.
It's been stipulated to, and is there an objection to the 14 million?
No, Judge, it was entered by a stipulation of parties.
Or 14 is admitted.
Detective, what is states exhibit 14?
That is a photograph of JJ sitting on a couch in what appears to be the front room of apartment 175.
And where did you locate this picture?
That was also on Lori for Style, iCloud.com.
And you mentioned you believe you recognize the location. I'm sorry, can you say that again?
Yes, it appears to be the front room, same type of couch that was found in Lori Vallow's apartment, apartment 175.
And did this picture have, well, may I publish it for the jury?
Yep, I agree, Jamie Lee.
Can you just describe to the jury what you observed in states exhibit 14?
That's JJ Vallow sitting on the couch in red pajamas.
And did this picture, was this picture accompanied by metadata?
It was,
Is this the metadata that accompanied that picture?
yes.
Can you, what was the date of that picture?
September 22nd, 2019,
Did you know what time of day it was taken?
11:46 a.m.
And just to clarify, what iCloud account was that? Was that picture taken from?
Also, Lori for Style, iCloud.
So Detective, You testified earlier that, well, you testified earlier that an order was served on Lori Vallow to produce her children.
Correct.
And I believe you already testified that she did not produce her children.
Correct.
What was the next step in your investigation after that?
Our next step in that investigation was to reach out to anybody that would possibly know where JJ was.
Who would you reach out to?
We reached out to family, the FBI, other agencies, anybody that would take our calls, tips that were coming in.
Detective, while you were doing this investigation, were you aware of any investigation in Fremont County regarding Tammy Daybell?
Yes,
And what did you know? Were you a part of that investigation?
I was a part of it, but my focus was mainly JJ and Ty.
And what was the investigation in Fremont County regarding?
A suspicious death involving the defendant Daybell's wife.
And as part of your investigation, did you know when she had died?
Yes,
When was that?
October 19th of 2019.
You testified that your primary focus was locating Tylee and JJ, correct?
That's correct.
Your Honor, please have a very brief sidebar.
Yes.
Yeah, I agree with you, Jamie Lee. I think, possibly he thinks, oh, I'll just keep bugging them with my objections. But that is a double-edged sword because then you're bugging everybody, right? Including the jury. And even if they're trying to stay objective and trying to just look at the facts, it does end up having an influence on their decision. I mean, it unfortunately does, I'm sure, have an influence on their decision when they get irritated with one or other of the lawyers. So what do you all think so far? I mean, it's pretty much going so far the way I thought it would go. Not super duper exciting and theatrical. Probably won't get into a lot of theatrics until other witnesses get on the stand. We saw that happen with Lori's trial. They slated this trial for 8 to 10 weeks or something like that. So, it's a commitment. It's definitely a commitment for those jurors. And it's a commitment for everybody. And rightfully so, it's a death penalty trial. The jurors not only have to make a decision on whether he's guilty, but then they have to decide. It's the juror's decision to decide whether he should get the death penalty. Yeah, I do find myself wondering why one or the other of these two, Chad or Lori, didn't fold on the other person in a plea deal.
To make every effort to be concluding trial each day at 3:30, including today. We are going to take our mid-afternoon break at this time. And just for your reference as well, in case I forget to mention, we'll be going through evidence and testimony again tomorrow, scheduled 8:30 to 3:30. And then with some scheduling issues, we are going to not be holding court on Friday. And so we'll be back on Monday. I just want to make you aware of that schedule as well. So
no court Friday.
Go until 3:30 today, but at this time we will take our break. So we can try to keep the break to 20 minutes. I appreciate it. with that, I'll apologize for the jury.
Okay, they are taking a break. Hello, Annie O. And look, Jamie Lee's been a member for 1 month. Woo! Do we know if Lori was subpoenaed to testify in his trial? So they have sealed the witness lists, but I highly doubt that she will testify. She didn't even testify in her own trial. And the thing is it's a double-edged sword for a defense to call a co-conspirator as a witness, because she can testify, about him being, she can try to testify to his innocence, but then she has to be cross-examined, right? And that's a huge risk, because the cross-examination can be the undoing of the defense. So you always have to take the both sides of the argument under consideration when you think about, okay, if I'm going to put somebody on the stand, are they going to be a good enough witness for me, but B, are they going to be able to withstand cross-examination? And yeah, she's in Arizona now. She has now been charged with the murder of her fourth husband. My understanding, Bogart, is that in certain cases, it is possible for you to have to testify against your spouse. But I'm not a lawyer, so don't take it from me. But my understanding is that is not like some blanket strategy is to get married to somebody just so you can't. A lot of people speculated that the reason Alex Cox married Zulema Pastenis was so that she wouldn't have to testify against him. And then he died. Right? And yes, she is appealing. And yeah, she would probably take the fifth. So it's probably a waste of court time, resources, and a huge risk at the same time. Right? So while we're waiting for them to come back, do you guys want to continue watching the closing statements in the Apple River stabbings? I'm going to turn that on. Let's continue watching this these closing statements, because this trial is on verdict watch. So here we go.
Right? And if you think about it, they all blamed. They didn't know it. But the guy holding the bag is Isaac. We know it's not Joanne Cockfield, and everybody else denied it. So who's left? Their buddy Isaac. They all blame, without saying his name. It's like, wasn't me, wasn't me, wasn't me. Well, you're saying it's the one person who isn't you. Right? That's what we know. We know everything here I just told you is what we know in the first minute and 49 seconds. And why does that matter? What does
I can't see the exhibits.
And step up and go over to the side.
What does that matter? Why does this matter? Because one of the things you have to consider when you consider self-defense is Nick Mew's reasonable belief that there is going to be an imminent interference with his person. And when you add all of these things together, he has to subjectively believe that. As a jury, as you sit here today, we don't get to look at it and say, what would an objective, reasonable person do? Does Nick feel that way? Does Nick feel, with all of these things listed here, that there is an imminent unlawful interference with his person? And I would submit to you, he does. He told you he did. Right? We're going to see the video one time, promise, broken up into those parts.
That makes sense, Bogart. That was from the video. It's a very loud video from this.
What is he on? Whoa! Whoa! Oh God! He up! He up! What are you talking about? What? Get away from us! What? What's going on with y'all homie? He's on camera. Scripted. He's on 4K. Yo, the new iPhone got that good quality. What are you saying? Yeah, what the hell? Who is this? Yes. Further culture. Who is that? Further culture. Who is that? Who the hell is this? Doesn't matter. He was looking for a little girl. Yeah, that's exactly what he said. We're gonna stop. I didn't have that part on camera. Did I? Some young ass kid. What the hell is that problem, bro? We try to have fun. He's gonna go you. He's gonna kill you. We didn't know what he was about. The second
They're definitely being loud.
that I think is important, and Attorney Anderson's talked about.
Nobody was touching him.
Is really the 1 second that we don't get to see, right? The 1 second where the state is insinuating and is claiming that Madison Cohen was punched, and where Nick Mew has testified that he raises his arm to get her out of his space. So those are the two possibilities as to what happened in the video that you don't see. And I am, once again, asking that you use your everyday experiences in life when you make this determination, okay? And I understand that people in stressful situations don't get everything perfect. I get that. I'm not holding anybody to this exact standard. But what have we heard in order to prove beyond a reasonable doubt that this happened? Well, you heard AJ Martin say that he grabbed her by the back of the hair and was slugging her from behind. Okay, no one else says that. You hear Alex Vang say he slapped her with a right hand in the face. Then I say, Mr. Vang, how can that happen? He's got a knife in his hand. And he says, you're right, that can't happen. He punched her. You hear Joanna Cockfield, who's not looking at it, he's holding his camera in another direction, says he threw a hook at her. I saw that. Right? Madison Cohen says, she said on direct examination, he hit me with a left hand to the left side of my face. And it's that. Then when I asked her questions and I said, can you explain how that's humanly possible? And her response was, you're right. I get lefts and rights wrong. He hit me on the other side. Okay. But the state says she had a heartbeat in her cheek. She should remember what side of her cheek the heartbeat was in. She doesn't get that right. But how about the things when you use your everyday experiences in life that the state, they didn't talk about what he was up here talking about her injuries. He talks about her falling back and people seeing things. Okay, people can be wrong. How about things that make sense though? We know that she's wearing sunglasses, right? We know that. Her sunglasses are not broken. She doesn't have a mark on her face from being cut by sunglasses. None of that. Is that what would happen if a 250-pound man squared up on a woman and threw a hook to her face? She doesn't have redness on her face. She doesn't have swelling on her face. She doesn't have puffiness, a bruise, or a mark. How do we know that? Investigator Schultz told us, I saw her shortly thereafter, and she didn't have a mark. He says, if I would have seen a mark, I would have taken a photograph of that Makes sense, right? She doesn't drop her drink. She doesn't drop her vape. Her cell phone doesn't leave her bathing suit. Is that what happens when a 250-pound man swears up on a woman? She doesn't drop a thing.
Nobody
doesn't
said
have
he
a-
squared up.
Does that make sense to you all? Or does it make more sense that Nick Mew pushes her out of his space? Attorney Anderson said she's not in his face. Well, most of her friends said, no, she was. She was in his face. She was in his face. She was in his face. Right? If he makes this motion, she's not going to have broken sunglasses. She's not going to have a mark on her face. She's not going to have redness, puffiness, swelling, a bruise. She's not going to drop her drink because he doesn't hit her. Which one of those two things in your everyday experiences in life makes more sense? You get to decide that.
It makes sense that he didn't square
And I
up.
want you to think about this.
He just hit her.
She knows the seriousness of the case. She tells the police she takes a photograph or photographs. Then she claims to have deleted them in a homicide case. Then the police say, that's okay. That happens. You give us your phone, we can get the pictures. Wrong.
This is the weird part. Why
They
did
do a cell-break downloaded
Sure.
extraction of her phone. Investigator Schultz doesn't do it, but he reviews it and says, there's no deleted photos that I saw in there. He even goes so far as to reach out to Madison Cohen's mother because maybe she either took the photos or were sent the photos. No, it's not there either.
mother?
You get to judge the credibility of people and whether or not that makes any sense. That is not provocation. And just briefly on retreat and provocation. I told you when I started, there is no duty to retreat. And that is true. That's the first sentence in the retreat instruction. If you want to, it says you may consider whether or not when he was retreating or if he had to retreat, whether the defendant reasonably believed the amount of force used was necessary to terminate the interference. You may consider whether he had the opportunity to retreat. Okay. Now you don't have to. But when it starts, when it matters, is when he's using the force. And when he's doing that, he's surrounded. He told you he was surrounded. I asked Lieutenant Hart, do you have any information that would be contrary to Nick Mew's belief or statement that he was surrounded? She said, no, I don't. Where's he gonna go? So he doesn't have to go anywhere. We don't let people dictate what we do, and the loudest voice in the room doesn't have to win. Madison Cohen doesn't get to make these decisions for people. He doesn't have to leave. The drug teenagers don't have to leave either. They told you they could have left, but they wanted to see the show. He doesn't have to go, and there's nowhere to go. That should be the beginning, middle, and end of that evaluation on retreat. Same analysis, same result on provocation, okay? You have to find that Nick Mew committed an unlawful conduct against Madison Cohen to provoke this attack. He wanted her to get out of his personal space. The bully in the room doesn't get to yell at you and tell you to leave, and then when you don't leave, doesn't get to get in your personal space because you are not leaving. That's not how this works. The last part of the video.
I'm pretty sure he's still incarcerated, Phyllis Doc.
Okay. Now you heard yesterday. The state wants to break this video, this last 15 seconds or so, down into stills. 1/24th of a second. No one lives their life in 1/24th of a second. And you're not supposed to in this case because you're supposed to look at this case through the eyes of Nick Mew. And if you've watched that video, the first time I saw it, I didn't see what happened. I didn't see employment. I didn't see some of these people getting injured because it's moving like this. When you break it down to 1/24th of a second? It's just not how we live our lives. You have to look at those 14 seconds through Nick Mew's eyes as he was standing there in the river. And remember, he told you yesterday that he believed that he was going to die, but he doesn't have to believe that. He just has to believe that he's going to suffer serious bodily injury.
His testimony was not very
That's what he
convincing in my
Okay.
view.
And before I start this video, I'm going to ask you this again. What do we know in those last 15 seconds? We know that Anthony and Dante Carlson were asked by their dad to go over there. Why? To help him. Quentin Carlson testified that he was concerned that Nick Mew was going to get the brakes beat off of him. So Quentin Carlson wanted his boys to go assist. I would submit to you that Quentin Carlson was concerned that Nick Mew was going to suffer serious bodily injury if someone didn't help. Alex Vang told you Mew's getting his butt kicked when this is going on. And Owen Peliquin said those guys got on his ass. Right? Anthony Carlson is yelling, stop, stop, stop. He's not yelling it to Nick Mew. Nick Mew's tail down in the water. Presumably, he's telling it
He
to the
testified
people who are beating him.
that he was saying it to
Right.
everybody.
That's what we know. He ain't a woman! He ain't a woman! You ain't a woman! Now, Juwan Cockfield found that to be funny for quite some time. You can hear him cackling on how he thinks it's funny that Mew's getting punched in the face and knocked in the face, slapped, okay? But what we know from that video is a 250-pound man, 250-pound man, has been knocked clean off his feet backwards into the water by getting punched in the jaw. That's what we know. We know that in 1 second, Dante Carlson, who throws that punch, runs around to the other side of Nick Mew while he's still on his back, kind of on his lower, on his butt, kind of on his lower back, and he cracks him across the face. We know that. That's not in dispute. We know that AJ Martin, who says he's the peacekeeper, that's what he said. He runs up from behind and shoves Nick Mew while Dante Carlson comes in for thirds and smacks Nick Mew in the face again. I would submit to you at this point, it's coming from all sides and from multiple people. And this man who had heart surgery is terrified as to what's going on. We know, well, let me just remind you of this. At this point, after he's been punched, slapped, pushed, slapped, he hasn't stabbed anyone. Right? And if you listened closely to what AJ Martin said in his testimony, when he was shown the picture of him making contact with Mr. Mew before Mr. Mew stabbed him, he said, he got me before I got him, I guess. What does that tell you about what AJ Martin's intention is? He's back in the water now for a third time after getting pushed down by AJ Martin. And what do we see next? That's Anthony Carlson. He walks right by me. Mew doesn't do a thing to him. Mr. Mew doesn't do a thing to Anthony Carlson as he walks by. You will then see, and what we know is Anthony Carlson comes up from behind him, appears to be yelling at him and putting his hands on him. So now Mew has been touched at that point, punched, pushed from behind and slapped. And now Anthony Carlson comes up to him. We know that. And then we know 1 second later that Isaac Schumann comes up to him. You guys get to make the decision on whether or not he's choking him around the neck. You get to make that decision. I'm not telling you what that is. You get to decide if that looks like a choke to you or not. So at that point, 4 people have attacked Nick Mew. And why does it matter? Why does any of that matter? Because if you find the following, Nick Mew is not guilty of all the charges, okay? If you find that Nick Mew believed that there was an imminent unlawful interference with his person, if you believe that he believed that was coming, the 19 or 18 reasons that I put up there supports that, and he told you that, and that's his subjective beliefs, okay? If he believed the amount of force that he used was necessary to terminate that interference, okay? So if he believed that he did what he had to do, right? I would submit to you there's only two answers to that, only two possible answers. He either did what he had to do to survive, or this man who you watch the video, who's never got a speeding ticket, who decides to go out with his wife that day, who's floating down the river and having lunch, decides, you know what, today's the day I'm going to start stabbing people. I'm going to leave my group, I'm going to go over and I'm going to start stabbing people. Mr. Anderson says he snapped. If he was in fear, he would have left.
Well, that's weird. Hold on a second. Wow. They didn't leave the whole closing arguments up. Wow, wow, wow. That's really weird. Okay, we're going to switch over to, they're going to be back soon. So we're going to switch over to this feed, and I'm going to answer Solo Sock's question. What did I think of the Crumbly sentencings? My understanding, I didn't watch them yet. I was planning to maybe watch them with you all on a break during this trial. Maybe tomorrow we'll do that. My understanding is that they both got 10 to 15 years. That's light to me. I mean, I don't think they should have gotten life sentences or anything like that. But 4 children died and others were injured and shot. They were declared responsible, for part of that, for the negligence that led up to those things happening. I don't know. 4 people's lives, 10 to 15 years. That just seems, they certainly deserve that, at least. That's what I think. I mean, I'm not a lawyer, so I can't sit here and make legal opinions about sentencing, but the way it feels to me is like, yep, it's a definite deterrent to other parents who might be watching that and will watch their children more closely, hopefully, especially from a mental health perspective. You have to assume that most people are going to be much more careful and safe with their firearms in their home. You just have to assume that most people are, right? But not only were they not safe with their firearms, they were not paying attention to his mental issues that he clearly had and he had asked for help for. So at the very least, hopefully the sentencing, the whole idea that these people had to go on trial and sit there in front of a jury of their peers for that long and be judged, hopefully that in and of itself will be a deterrent and will teach people to pay much more attention to their children's mental health and well-being at the very, very least. Those are my thoughts on that. What do you think, Solo Sock? Oh, and they are coming back.
Thank you. Please be seated. We've got the jurors return, please.
Thank you.
Council, while we're waiting for the jurors, we will take up on the record at the conclusion of today, after the jurors can dismiss the issue of further stipulated exhibits, and I'll bring that up before we conclude for the day.
That's a good point, Solo Sock, but I'm hoping that the jailers take all of that into consideration. We know they really don't, but it'd be nice to be able to believe that the jailers take all of that into consideration. I certainly don't think that that the Crumblies are going to go out and reoffend in the same way. So there has to be, so their sentence is more of a deterrent and a punishment than a incarceration to keep the rest of the world safe from them, right? Because they don't have any younger kids younger than Ethan. The damage has been done already. Really. I mean, no one could see either of them intentionally going out and doing anything similar to that in the future. So it was punishment and deterrent, and neither of them, well, actually, they did have criminal histories, as I think Jennifer had more of a
All rise.
so that was certainly factored into her background, but her criminal history didn't really directly attribute to, or wasn't directly connected to what she was convicted of. Yeah, and that's what I want to watch, Hippie Chick, is watch the victim statements, and I want to see what the Crumblies say as well.
Very well. Please be seated.
I've been doing work on my other channel and been preparing for this and haven't been able to watch that in full yet. So I was thinking I would watch it with you all during a break at some point.
We're back on the record after our mid-afternoon break. Mr. Wood, if you'd like to continue the examination of the witness, and I'll remind the witness, of course, you're still under oath. Mr. Wood.
Thank you. And I need to just take up a couple of issues for clarification of the record. Detective, you spoke earlier about searching Lori Vallow's residence.
Correct.
And you stated the address. What city was that address located in?
Rexford.
And what state is Rexford in?
Oh, yeah.
Thank you.
Oh, really, Solo? I didn't know that.
Detective, as part of your investigation, did you ever help execute a search warrant on Chad Daybell's residence?
I did. I executed a couple of warrants.
Okay. When was the first one?
January 3rd of 2020.
And Chad Daybell's residence, what county is that located?
Madison County.
What's his address?
202 North, 1900 East.
And is that, and what city is it listed as?
It's listed as Rexford. It's actually in Fremont County, but it's listed correct.
Okay, so just to be clear, did you just misspeak when you said it was in this?
I did. I'm going to say it's right.
Okay, and it's what county?
Fremont County.
All right, thank you. And you testified that you did a search there on January 3rd.
Correct.
Was that search in aid of another investigative agency?
It was.
Which agency was that?
Fremont County Sheriff's Office.
And do you recall what the purpose of that search was for?
I don't recall what the probable cause or the reason for the search was at that time.
So you didn't write the affidavit?
So,
Did you have any other occasion where you served a search warrant on Chad Daybell's residence?
yes, June 9th, 2020.
When you served that warrant on June 9th, 2020, what time did you arrive at Chad Daybell's residence?
Roughly about 7 in the morning.
Your Honor, I'm going to ask that the witness be handed State's Exhibit 10A.
Yeah, 775 for that house seems super high. My gosh.
Detective, are you familiar with State's Exhibit 10A?
Yes, I am.
What does it purport to be?
It's a aerial image taken from Google Earth of the defendant Daybell's property.
So, do you know who prepared that image?
I did.
Right. But you didn't take the picture
No.
because it's a satellite photo, correct?
Correct.
Have you been, I believe you testified you have been to Chad Daybell's residence.
Yes.
Have you walked around the grounds of Chad Daybell's residence?
Yes.
And have you been inside his home?
I have.
Are you familiar with the landmarks of that residence in the yard?
Yes, I am.
And are you familiar with the general layout of the yard and what's located in it?
That's correct.
And is this image an accurate representation of Chad Daybell's residence?
Yes.
Your Honor, for demonstrative purposes only, the state moves to admit Exhibit 10A.
Any objection?
Objection, 1 year and any objection.
Right.
Now, sir, approximately how much property are we talking about?
I couldn't tell you the amount of property.
And the prosecuting attorney mentioned the yard. Now, I believe the yard usually means where there's grass. So you're familiar with what's on the grass, is that right?
I'm not sure I understand your question.
Well, and I'll represent to you that there's about 4.5 acres out there. Does that sound close to me?
Okay.
Okay. And I'll represent to you that there's an area that's known as the yard, that's a lawn area, that you would mow with a lawnmower. Are you following me?
Your Honor, this is testimonial.
Yeah, Judge, he says that he's familiar with the yard.
Well, I understand. I think we're going into cross-examination now, which will be permitted. The question is on an issue of foundation or other objection, whether or not the exhibit gets admitted. So, Mr. Pryor, what would be the foundational objection?
He hasn't testified, Judge, that he's familiar with pasture, 3.5, 4 acres of property that go beyond the yard.
All right, response, Mr. Wood?
See, this is why
I
it's
think
so, why does it
question-
matter whether it was his yard
Based on foundation and with the
or the pasture?
testimony of the witness about his knowledge of this property, court will overrule the foundation objection, allow the exhibit 10A to be admitted, and you can go into those issues by cross, Mr. Pryor.
Thank you.
It was all his property. Are they
Your Honor,
trying to
I'll publish that shortly.
say that because the kids were buried in a place that was further away from the house that he couldn't have been involved?
So you testified that you executed a search warrant on June 9th, 2020.
Correct.
What time of the day did you arrive at Chad Daybell's residence?
Roughly 7 in the morning.
And was it only the Rexburg police or were there other agencies involved?
At that time, there was Fremont County and Rexburg City Police that went to his house at 7.
And did any other agencies help you that day on that search?
They did.
Who were they?
The FBI ERT team, which is the evidence recovery team, the Attorney General's office, Fremont County. I believe that's it.
Okay. And you testified you got there about 7 o'clock.
Yes.
When you first arrived, who was with you?
So I do apologize. Could I have a quick sidebar with council? I'd like to discuss this exhibit briefly.
Sidebar. You know, I kind of doubt that the Watts house is still getting the attention that it used to, but I would bet that people still give it attention. I'm just wondering if them turning around and selling it so fast had anything whatsoever to do with the case, or, you know, such as people trying to come by and visit or whatever, or just feeling weird inside of the house. Or if, you know, maybe they bought it to flip it. But it wasn't a fixer-upper house. The only way it was a fixer-upper was because it had been left empty with that murder as the last thing that ever happened in it, you know? And yeah, there's no way I would live in that house, but you know, there's people who may not have heard it. That has to be disclosed, I'm pretty sure. I don't know what the laws are like in Colorado, but I believe in California, if someone is murdered in a home, that has to be disclosed during the real estate transaction. I don't know. But I guess we won't know what their motives were, the new owners, and what they were doing until they come out and talk about it. But I kind of doubt that they would. Yeah. I'm pretty sure that in most states, you must disclose when there was a death in the home that wasn't natural. Right? I mean, if it was just a natural, person dying in their sleep or whatever, that's one thing. That happens all the time in homes. But for a basically a triple murder to happen in a house like that, or some people believe that he killed the children before Shanann got home and then killed her. Some people believe that, and he told this story that he killed Shanann, then brought the girls to the oil batteries with Shanann's dead body in the car, and then he killed them at the site of the oil refinery of Servi 19, and then buried her and then put them in the oil tanks. I don't think anyone has ever proven what actually happened. If you believe the video from Armchair Detective, which has shadows, you see movement besides Chris in the shadows. And some people say that is proof that the kids were still alive when he was packing up the car. Some people say, nope, that was the doggy Dieter. That's what the movement was. So, so many open-ended questions in that case, which caused a lot of people to want to get answers that they may not normally have deserved. Armchair Detective got yeeted off of this platform, Solo Sock. He's gone. Yeeted. And I've noticed that a lot of there are many now fairly well-known YouTubers from the Watts case that have been since yeeted. One of them is Molly Golightly. Another one is Armchair Detective. And armchair detective was probably yeeted as a direct result of the Watts case and other cases. Molly Golightly's yeeting had nothing to do with the Watts case, but her ongoing antics over the years. Yeah, it's possible, Patricia Burns. I don't think we'll ever know.
All right, Mr. Wood, apologies for the court's interruption, discussing that last exhibit. You can continue with your direct examination of the witness.
Your Honor, could I have the court reporter read back the last question I asked?
It's kind of a half question. When you first arrived, who was, the question before that was, and you testified you got there about 7 o'clock, answer yes.
That's right. Thank you. May I proceed? Yes. Detective, when you arrived around 7 o'clock, who was with you at that time?
There was myself, Lieutenant Ronball at the time, Detective Kai Kamani, and Detective Bruce Mattingly, and also Detective Dave Stubbs.
All right. So can you go back to those individuals and say where they, who they were employed by real quick?
Lieutenant Ronball with Rexburg Police, Detective Stubbs is also with Rexburg Police. Detective Kai Kamani and Mattingly are both Fremont County Sheriff's Office.
And just for clarity of the record, is Detective Ball still with the Rexburg Police?
No.
Okay, and what organization is he with now?
Madison County Sheriff's Office.
And Detective Kai Kamani, is he still with Fremont County?
No, he's also with Madison County Sheriff's Office.
All right, that's just clarity, thank you. So when you got there, what did you do?
Initially, we knocked on the front door. We made contact with Mark Daybell, who's the defendant Daybell's son. He answered the door. He was eating a bowl of cereal. It was early in the morning. We informed Mark of why we were there and that we needed to speak with his dad. He stated his dad was still asleep, and we showed him a copy of the warrant, and he proceeded to let us in and show us where his father was.
And did you make contact with Mr. Daybell that morning?
We did. He showed us that he was sleeping in bedroom above a loft, above the garage. So we walked up the stairs, just a few of us. Detective Kakamani and Maddie, we stayed back. We informed Chad that we were there and needed to speak with him. He was still asleep. He asked if we could get some clothes on. We allowed him to do that and he came downstairs with us.
And did you provide a copy of the warrant to Mr. Daybell?
We did.
And what happened next?
Mr. Daybell asked to speak with his attorney. We were standing in the kitchen area. He had a seat in the kitchen. And his attorney at the time was Mark Means. So we allowed him to speak with his attorney. At that time, Mr. Means wanted to speak with one of the investigators.
Judge, I'm going to object at this point.
That's fine, Your Honor. We'll stop that. Very well. After Mr. Daybell spoke with his attorney, what was the next step in your portion of the investigation?
I allowed Mr. Daybell to sit in the front room. He sat on his recliner closest to the door. His children sat on the couch in the same room. I gave Mr. Daybell a copy of the warrant and he read through the search warrant while sitting in his recliner. He asked if he needed to leave the residence while we conducted business. We informed Mr. Daybell he didn't need to leave the residence, but if he chose to stay, he would be accompanied by an officer just for safety purposes.
After you had that conversation, what did you do?
Mr. Daybell asked if he could make a phone call. And at that point, he was allowed to go outside and make a phone call.
And where did you go?
I went outside with him.
And what did you do after that?
Mr. Daybell wanted to sit in the vehicle that was parked backed in on the west side of the house. There's a west driveway. So I allowed him to sit inside the vehicle, windows rolled up, and make a phone call. I stood in the grass area close to the vehicle.
At this time, Your Honor, I'm going to ask to publish State's Exhibit 10A.
You may.
Detective, do you have that pointer?
Yes, I do.
Can you point out where the front door of Mr. Daybell's residence is? In that image, or where it would locate?
There's two doors. I don't know which one Mr. Daybell used as a front door. I can tell you there's a door right here and a door on the back side. So Mr. Daybell was roughly, that's not the vehicle he was in, but it's roughly parked in the same area. And I was standing here in the grassy area.
Earlier, there was some talk about the yard or the grassy area. Can you just outline for the jury where, I'm going to call it the grass area of the yard, is located on that image?
The grass area is right through here.
And is that a driveway behind the house as well?
Yes, there's a driveway here.
And to the just east of that, what is that? Is that grass as well?
There was grass here. There's a little shop area. There's a shed here. And then this is, I guess you would call it pasture area.
Did you observe any livestock there?
No.
Detective, you testified, if you can show again where Mr. Daybell was and where you were in relation to him when he went outside to make a phone call.
So Mr. Daybell was sitting in a vehicle fairly close to this location. He was sitting in the driver's seat. He was back in. I was standing here just observing Mr. Daybell make a phone call.
And did you observe his behavior while he was making that phone call?
I did.
What was the nature of the behavior? What was he doing?
Initially, he was just on the phone, and I was watching him. But as the call progressed, he had the phone in his right hand and was intently looking over his right shoulder. And so I found it odd. I wanted to see what he was looking at. So I maneuvered myself to see what he was so intently looking at.
In other words, he was acting.
And when you did that, did you attempt to orient yourself so that you would be looking in the same direction you perceived him looking at?
That's correct.
What did you see when you did that?
So with the vehicle backed up here, he was looking over his right shoulder in this direction. I stood over here, kind of in front towards the roadway to see exactly what he was looking at. And when I looked that way, I saw this area, this pond area.
Now, let's look at that pond real quick. If you can just kind of run the pointer around it so the jury's sure where it is.
Right here.
And
There's a tree right here
thank you.
and then a pond.
And when, at the time, you noticed Mr. Daybell looking over there, was there any activity going on over there?
There was. So like I testified, we got there about 7 o'clock. When we made contact with Mr. Daybell and the scene was secure, we radioed for the other units that were staged about 1.5 miles down the road that they can come start marking things off in the search warrant. So as time passed, Mr. Daybell was reading the warrant on his recliner. While he was doing that, there were ERT members and other officers that started marking off different sections in the backyard that we wanted to search.
Now, Detective, just for clarity of the record and for the jury, I believe you defined ERT earlier, but can you tell the jury again what ERT is?
Evidence recovery team
And who are they associated with?
with the FBI.
Now, Detective, were you the lead of executing the search warrant that day?
I wasn't in charge of the search warrant.
So, kind of just for clarity again, what did you see when you looked in the direction you thought Mr. Daybell was going to happen? Or I guess, what activity did you see?
There were some ERT members marking off a section under this tree, right next to on the east side of the pond area, so right in this general location.
What did you do next in your part of the search that day?
I was tasked with going into the backyard and sifting through what we determined was a fire pit.
Can you show the jury on that map or on that picture where the fire pit is located?
Now they're coming to the stage where they find Tylee for and JJ.
And you said,
I apologize, but for the record, would you have the witness please reference where that point to just somehow, so there's a full representation?
yes, Detective, if you can point there again and describe what it is you're pointing at, where it is you're pointing.
The fire pit area, which there's like a little tree here. It's just to the north of the tree. Yes,
Is that adequate, Your Honor?
It is.
So you said you went north of the fire pit. Exactly what did you do?
so a few of us were tasked with getting dirt and anything that was in the fire pit and putting it through a sifter. So that's originally what I was tasked to do by the team leader of the ERT team.
About approximately what time when you do that?
I'd say roughly probably 9 of them that one.
Who was the team leader of the ERT team?
His name is Steve Daniels.
And how long did you sit in the fire pit?
I would say probably 35, 45 minutes.
And so when you sifted, what kind of tool did you use to do that?
It was a wooden sifter. We would scoop shovels full and put it in the sifter. It had wooden handles. You would just shake back and forth. And any larger debris would stay on the top of the wire screen.
And did you find anything of interest while you were sifting through the fire pit area?
Not at that time, no.
Did you move to another area of the search?
I did.
When approximately did you do that?
You asked for a time,
Approximately, yes.
probably 10-ish maybe.
And why did you move?
There were ERT members and some other members of law enforcement that had marked off a place under this tree next to the pond. They had called and wanted some other people over there to help with that area, so I left the fire pit area and responded to this section right here next to the tree and concrete.
And what did you observe when you got over there?
I observed ERT marking off, they had already marked off probably a 6x6 section The best way I can describe it is there was taller shrubs. In the middle of the 6x6 section, it looked like there was just a little bit of grass, probably the length of sod. And some dirt protruding through the grass, but there were no taller shrubs like on the outside of the section.
What happened next?
The ERT team began excavating that site. They removed a top layer of soil, took off the shrub and the top level of dirt.
And what did you see under that?
At that point, you could see what appeared to be 3 large white rocks. And as soon as they did that, we could start to smell the odor that, through my training experience as a decomposing body.
Let's talk about that. Have you, on other occasions through your work, smelled the decomposing body?
Unfortunately, yes, I have.
And is there a distinctive smell to you that you associate with that?
There is.
And it's your testimony that as that first layer of ground was lifted off, you began to smell that.
That's correct.
What did you observe next?
After they slowly and methodically dug around the white rocks, they were removed. ERT took pictures and measurements. They continued to dig down. Right below the layer of rocks were 2 pieces of thin wood paneling. Just right below the rocks.
Were you still able to smell that smell you had described?
Yes, as they dug down, it got stronger.
Were those boards removed?
They were.
What did you observe after that?
So after the boards were removed, you could see the discoloration of dirt. So you had dry dirt. And then underneath the boards was like a wet, moist type dirt. So it was pretty obvious there, the distinction between the soil.
Then what happened?
They continued to brush away the wet soil. And at that point, you could start to see a black round object start to protrude through the dirt.
And describe that object. About what size was it?
Initially, it just looked like a littler black round object. They dug down further carefully and it appeared to take shape of the crown of a human head.
What did you do after that, or what did you observe once that was uncovered?
So once the black round object was uncovered, at that point, the ERT team leader, Steve Daniels, got a small, sharp instrument and made a slit in the black plastic. He kind of opened that up just a little bit, not to damage or manipulate any of the evidence. But underneath the black plastic was another white layer of plastic. So he used that same instrument and cut a slit down the white plastic and kind of opened it up. And at that point, it looked to be brown human hair.
After that was discovered, what happened next?
As soon as that was discovered, we received information on the radio that the defendant Daybell was leaving his daughter's residence, which was catty corner to his residence, at a high rate of speed. And at that point, Mr. Daybell was pulled over and subsequently placed in custody.
Did you go back to the site where what appeared to be a human head was located?
I did. When I got back to what we ended up calling burial site, they continued to excavate around that black plastic. And after they excavated and took the dirt off the plastic, it revealed what appeared to be a small body wrapped in black plastic with duct tape around it.
Monsters.
Thank you. Your Honor, I know the time.
Yes.
This would be a good place to stop for the day.
All right, we are going to try to adhere to this court schedule, so it is 3:30. This time then, I am going to conclude trial for the day. I've got one additional issue I'll take up outside the presence of the jurors. However, the jurors will be excused here momentarily. As you're leaving for the evening, then, ladies and gentlemen of the jury, as I will try to remember to tell you each and every day or when we leave breaks, longer breaks, please do not discuss this case amongst yourselves or with anyone else. Please don't do anything to investigate this case. If you see any media coverage of the case, please try to avoid that so you can remain impartial. And with that in mind, that will conclude our first day of evidence. So we'll allow the jurors to be excused at this time.
All rise, please.
All right, so today's testimony has ended, or testimony and opening statements. And I'd like to say, that was a fairly strategic place for the prosecutor to stop, because he ended on Detective Hermosillo coming right up on, describing finding JJ Vallow. And that leaves the jury with a harrowing image. Like, how the hell? So what they literally just heard in the last 5 minutes. Yeah, I like that too, hippie chick. It's very nice for us streamers as well. What the jury heard in the last 5 minutes there was, we go to serve a search warrant on Chad Daybell's property. We notice that while we're searching, he is talking on the phone in a very strange way. He's appearing guilty. And then as we're searching his premises, and he sees that we have zeroed in on a spot, which was where JJ was, he starts trying to flee. And they have to arrest him. So they arrest him right there. And it was fairly dramatic. All of this was really shown live, because by that time, the police had tipped off the media that they were going to be there searching. They tipped off Nate Eaton. And so there were helicopters over this thing the whole time. And then TV crews were showing up. And they showed Chad Daybell getting handcuffed and perp walked into the vehicle and taken to jail. So then right after that happens, they discover the actual remains of JJ and then later Tylee. And so they're stopping the day with that image in their head and that story in their head. And then tomorrow it's going to open up with them finding Tylee. And then they're going to have to, I'm assuming they're going to have to see, well, that might be during autopsy. I don't know, but they might show for a dramatic effect what they found in images. So, out of curiosity, I'd like to, Hidden True Crime is there on the scene, and she's been doing like lunchtime like recaps and stuff like that, and I'm interested in seeing what she had to say today. hold on. So I'm bringing it. I'm gonna bring you that now. See if she had anything interesting to say at lunchtime.
And it kept crashing on me, which has never happened in the history of Lori or Chad's trial. So I don't know if it's because so many people were going live at the same time. What's bad? First off, I felt Rob Wood did an excellent job. Hey, McSpunky. Hey, Idea Pants. Hey, Tina, Shannon, Jamie, Christy. It's so good to see all of you. Hey, I also want to thank everyone for being members during this time. So just supporting Hidden Truth. Had up on the screen all the major important events to know. Explaining that I loved it. I loved it when Rob Wood was saying that Chad didn't want this ordinary life, and he actually said that he wanted. What was the wording he used? I quoted him. What was it? The thirst. Yeah, he said thirst for sex, power, and money.
I would like to hear some inside the courtroom information.
But then he said special. He didn't use the word special though, but for being. Okay, so Lindsay is saying that if she was a juror and she didn't know anything about the case, she felt it was the best he could have done. I just hope there's not like a single misogynist on the jury, because
so they're more talking. I'm looking a little bit more for like courtroom inside, like what's it like inside the courtroom kind of thing. It looks like they're more talking about just the making the same exact observations we were just making. So I won't linger on that. But just to really wrap things up, today was impactful in the way it needs to be impactful for a jury, I think. I think that, as they were saying there on Hidden True Crime, I'll look for and see if Nate did anything real quickly. Hold on a moment. But in the meantime, hold on just a sec. I can't talk and search at the same time. I'm so lame. Let me see here. One moment, please. Yeah, I can't see anything. Let me just go to Twitter real quickly. See if there's anything interesting on Twitter that we can all look at. But I've been looking off and on while we've been watching the opening statements and everything, and and this testimony, and haven't seen anything super exciting. Let me see. Let's go to East Idaho News. Let's do a search on East Idaho News. Oh, here's Nate. Let's see if he had anything here. So Nate is doing like live tweeting, basically. There's the picture of JJ on the couch. It's a little eerie to me, to be honest with you. Both of the pictures of the kids, last picture of their kids on their last day is pretty eerie to me. But I don't see any video of Nate kind of talking about inside the courtroom. So, and that's really what I'm kind of looking for right now. Sparkles says, it's always a better day with you hanging out with us, talking trials and stuff. So extra big ass thank you. Extra big ass thank you to all of you for being here. And, I realize I kind of sabotage my channel a little bit by like not going live in between trials. So I'll try to do better at that. That's why my channel isn't really like in the trial algorithm right now. But we'll work on it together, right? Right. All right. Thank you all for being here. I'm going to, I'll start up tomorrow in the morning around the same time. And I hope to see y'all here. And please remember to like and subscribe and consider becoming a member. There's a join button on the channel. And I will see you all tomorrow. Bye.